Good morning, you guys. How are you? It is going to be day 107 of the YSL RICO trial. And I see, hey to Yaya. Godfried is coming in all the way from South Africa. Hey to Fallon, Belinda, Debbie. 2 p.m. Wow, that's so different to me. I'm like, I woke up like an hour ago and you're like halfway through your day. Good to see you, Tom. Keisha, J. Caputi. Saz says, ready to party this morning. Well, there might be some excitement. If you guys missed the end, I know a lot of people tune in throughout the day, but might miss the end of the court days. But right at the end of the court day yesterday, Brian Steele kind of gets up and make this argument that the state, to anybody's surprise, turned over discovery really late on Monday evening. And it relates to cell phone records, to a telephone number. And the judge was looking at the state like, well, when did you first hear that this telephone number might be relevant, or the person that this number belongs to might be relevant? And Adrian Love was like, we're like, everyone in the chat, I think the word of the day was when. And we really didn't get a straight answer. So if we see some more on that today, I think that will be really exciting. It's also supposed to be finally the deadline for the state to name their next 30 witnesses and the relevant information, evidence that they plan to bring in with those witnesses. That's something we've heard Judge Whitaker ask for several times already. And hopefully today is chop, the deadline for that. But, as Judge Whitaker said, the attorneys like to drop bombshells at the end of the day. Keisha says, what does everybody think about Woody yesterday? I think he made an excellent decision. No use in going to jail Wednesday when you can wait till Monday. What do you guys think? I was thinking that same thing because the judge kind of hinted that it would be Monday. So, although to be fair, it doesn't mean that the judge would have decided if you say no today, that I'm going to hold you in contempt today, right? Maybe that judge would have used some discernment and decided, well, that would be punishment because we didn't plan to have you testify today or tomorrow. But I feel like maybe Glanville would have been like, all right, you just said no to me now, so that means contempt starts now. So he made the safe and quick-witted decision to say, I don't have a decision right now until Monday. Definitely agree. Boss Beauty Butterfly, good morning. Factual Lie, good to see you. And look, you're gifting memberships. You guys know the drill. Say thank you to Factual Lie in the chat. And if you're a new member, if you just got gifted a membership, choose your Mario Kart racer. You have custom emojis you can use now. Good to see you, Wealthy Wisdom, Raphael the Moore, Nursette, I like that name. Midwest Later, Jimmy Got Soul, 10-4 to Bluebird. Miss Kim's good to see you. Jonathan Reed, Kelly Lewis, Trish Manfield. I see Drea's in here. I know Drea was in here. But yeah, so look at this. Woody is sharper than most think. Oh, and it's Woody. Woody. Woody is playing the game. Lisa says he came in the white tee. He was ready. Drea. Remember Drea's birthday's coming up, you guys. So appreciate her so much for being a great mod on this channel. She's a great person. She's hilarious. She's wearing pearls to clutch today. Oh my goodness. Good morning to Biliano. Yeah, I know. Woody. I've got to get that together. That one's hard for me to change for some reason. I think it just sounds weird to say Woody. And then John Rutland says, good morning to the whole chat. Hey, JC. Conditionally accepted wants us to take our bets. Do we think Woody will wear a tie on Monday? And then all hail. This is a great point because this is, kind of what we saw the state encouraging him. You don't want to lie, but you can just say, I don't recall. So all hail says him going on the stand and saying, I don't recall, allows for them to bring in all the video evidence and builds the upcoming testimony from other witnesses. Did anyone else catch yesterday when the state expressed similar concerns about witness Zachary, who they plan to call after Kenneth Copeland after Woody. But yesterday, the state, Adrian Love, was like, you know, we have some reliability issues with this witness as well, Your Honor. And I'm thinking, like, okay, so is there like a possible, could this witness get up there and also not want to answer questions and maybe also try to plead the fifth? Are we going to do like a rerun and encore of everything we saw with Kenneth Copeland? Maybe again with Kenneth Copeland, but then also again with the witness that follows him. So, and this stuff is all important because this is really, as All Hail is pointing out, they want to get these statements from these videos in. Good to see you, Frodo. Good morning, Simply Sherry. Good morning, JC. Good to see you. Tamika, good to see you. Thanks so much, Devana. And yeah, you guys are laughing. I'm like, why is everybody saying no, 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 no? It's the tie question. Nobody thinks he's going to be wearing a tie. And you know we do this counter clock for Judge Whitaker. We are 1 minute late. We are 1 minute late for this feed to start. Let's see. Yeah, everybody, Woody in a tie. Hit that like button, you guys. It's free 99. And then Dennis. The state wants Kenneth Copeland's testimony so bad. I gotta, like, Casey makes me think of Kansas City. The state wants Casey testimony so bad it annoys me. That's why I want him to plead, but he has to do what he has to do for his family. I don't think this trial will go into 2025. Well, and that's the other thing. If getting all this stuff in is so dependent on Kenneth Copeland, I mean, by him not testifying, he's probably shaving off like like a week and a half, 2 weeks of him being on the stand. I know they shaved these videos down, but I don't know how much they actually effectively shaved these videos down. And they left a lot in the air. The state's going to still have to lay foundation for certain statements to come in. And, you know, I'm just not sure that the state's going to make their arguments short and concise. And yeah, it has been a while. The Right Honorable I Told You So. Love the name. And Andrew Hansen, thank you so much. So this, do you mean the late disclosure with the cell data from a number that maybe they've had for a while, and then they suddenly turned it over on Monday night? After, in my opinion, Monday was a huge L for the state. And then they make this late disclosure. And let's also underscore that the main L that the state took on Monday was the judge pointing out that, hey, we should all be taking Brady evidence seriously, Brady material seriously. After we had Melnick and Caleb Bumpus, plus a bunch of state witnesses that seemed to end up confirming more of what Kayla and Melnick were saying, rather than helping what the state was trying to argue to cover their butts. And then on Monday, we get late discovery from the state to the defense, all while they're complaining about reciprocal discovery from the defense that they're not getting. Okay, let me refresh the stream, because... Are you guys watching 11 Alive? Let's see. Thank you so much, Andrew Henson. I think you might be talking about that late discovery. Yeah, it still shows me waiting for Law and Crime. So I'll keep refreshing. The Law and Crime chat is like, it's Glanville. But yeah. And then guys, during the lunch break, because you know she gives us like an hour and 20, hour and 30 for lunch, we're going to look at the Corey Harris update. Do you guys remember Corey Harris? I'll give you a hint. He drove to court for a specific thing that maybe you shouldn't be driving for. He's got an update today. And then William Fagan, is today the day the state is finally sanctioned? I don't know. I do hope we get oral arguments. I'm going to keep refreshing the screen. I do hope we get oral arguments from Brian Steele about this late disclosure. I hope we get the same from other attorneys, other defense attorneys. And Christine Torres, thanks so much for becoming a member. You also have access to the Mario Karts. Choose your racer. And Mason Martin, I think the delay could be for any number of reasons. It could just be that the defendants didn't get transported in time. Okay, let's go. Where's Sylvia's channel? All right, we're gonna rewind it and I'll switch over to this. Thank you so much for that.
Got his number, records as I stated.
And we'll see exactly what this, there we go.
Of the cell phone records.
Yeah, they're talking right about the records, you guys.
As I stated yesterday,
Here we go.
Mr. Boyd, what I was able to discern is that Mr. Boyd is a person who is whose existence is made clear on the wiretap conversations that were provided in discovery. There is a point at which he indicates something to the effect of FaceTime me. And through looking at the wiretap calls, investigators with the Atlanta Police Department got his number, and actually ascertained this might be someone who's involved in this murder. He is believed to have been in the car with Mr. Nichols. The other car is the car that we believe the gunshots rang out from, and he is the one that they believe pointed out Mr. Drink, but they do not believe that he was the one that fired the gun that took his life. That does not make him less of a party to the crime in their estimation. The recordings that are included in the wiretap call that have been provided, and the fact that his phone number and the number of times that he communicates with Demekion Garlington throughout the course of that part of the conspiracy are matters that have been disclosed. The cell phone records were obtained, I am told, in order to seek a warrant for arrest and perhaps to indict Mr. Boyer. That did not happen. They did not seek the arrest, or they haven't yet. I can't say they won't ever do it, but that part of their investigations have not yielded an arrest.
All right, and who's the they here?
Atlanta Police.
APD?
Yes.
All right.
And they did have as a result of the wiretap, they obtained his cell phone records, they said in the fall of 2023. So we've had them since the fall of 2023. There is, in our estimation, not exculpatory, but rather inculpatory information contained in the phones, but we don't have any. So to the extent that they're Brady, we want them to have them, but we don't or didn't intend to introduce the phone records. That is not the reason we didn't turn them over. We didn't turn them over because it was conveyed to our team that they were
still should have turned it over
into indicting him or to getting an arrest warrant for him. And the sentiment was that they did not want to alert him himself while they were still doing that. At this stage in the game, the decision to go ahead and give it to them, give it to the defense in the event that they consider it Brady material was made. But the fact of his, what the Atlanta Police went on to get the search warrant for his cell phone records is material that have been provided to the defense.
So you say that Mr. Boyer's existence was revealed in the wiretap that the defense has had for a while. And his phone number and the number of times he was communicating with Garlington is information that the defense has had for quite some time. Is that right?
Yes.
Okay. When did APD secure anything, and it may have been these cell phone records, that caused them to believe he was in the car with Mr. Nichols?
It was reviewing the wiretap data, which caused them to say, oh, this person looks like he's a part of this.
Okay.
And then looking at the number of times and the types of communication between them, they're able to see data exchanges. They were able to compare it to the time that we believe the murder occurred.
Okay.
And they were able to follow on the surveillance footage that we have the path of.
Okay, so I mean, basically the raw data from which they reached these conclusions is all from the wiretap?
Yes, it's from the wiretaps. And then when they got the cell phones based on what they saw in the wiretaps during their investigation. And I believe that as it relates to the Waters Road incident that occurred during that same time, they were able to, this is still information in the wiretap, but there was communication from Mr. Boyer about what was going on at the Waters Road incident. That's a part of the data that's included within the wire information.
Okay. Have you, meaning the DA's office or APD, conducted any interviews of Mr. Boyer?
No, not only no interviews, no warrants have been secured either at this time.
All right. I'd like to review the affidavits in support of seeking I assume you got cell record, cell site info, and then you separately got contents of cell phone, or did you not need that because you had the wiretap stuff already?
We because no one had any contact with the person himself, we never had access to contents of his cell phone, just his cell phone.
Okay, so when we are saying cell records, it's essentially like location information?
Yes.
Okay. All right. So can you get me the affidavit in support of that, please, to review? Yes, sir, Mr. Shardt.
Your Honor, regarding the state's assertion that we were put on notice about Mr. Boyer, there is a wiretap. That is true. We were provided the contents of the wiretap. That is also true. There's nothing in the wiretap. There's a phone number, which is what the state handed over on Monday, the contents of that phone number that shows contact through the wiretap. There was nothing linking that phone number to Mr. Boyer. I just want to make that clear.
Okay, thank you.
There's nothing that puts us on notice that Mr. Boyer is a person of interest or potentially at all involved or in contact with our clients in this case. And there was also, Mr. Harvey is also pointing out there was no raw data provided in the wiretap regarding the wiretap itself.
Okay, I guess when I said data, I meant the information from which they formed those conclusions.
I understand. We were aware of what numbers were calling what
You
numbers
just
at what
weren't
time.
aware that whatever this number is
Right.
was connected. It's obviously somebody's, but y'all didn't know whose phone
Correct.
it was.
And I can state in my place as an officer of the court, upon information and belief, that I've listened to pretty much all those calls. I don't recall in any calls in the wiretap where that number's involved, anyone ever saying any government name that would put us on notice and say, oh, that's DeMarco Boyer's number. So we've been pretty diligent.
Okay, so Ms. Love,
Yes.
what do you say about that?
I'm not refuting the person's name. I'm talking about the phone number whose records we turned over being present and the content of his conversations and communication.
Okay, so do you have the affidavit available?
That's what I'm getting.
Potentially by the time of the affidavit, but certainly by the time the cell records were secured in the fall of 2023, you
on,
knew
Judge.
that phone number was connected to DeMarco Boyer, true?
That is true.
Okay, so is there a way that the defense was supposed to have also known that that phone number was connected to DeMarco Boyer?
1 second. If the court will permit me 1 second.
Go ahead.
Think of an excuse. Think of an excuse. Look at her typing on the screen. Look
Will
at
the
the
court
Zoom
permit
screen.
one of our team members to step outside of the courtroom and make a phone call to expedite this obtaining?
Yeah, absolutely. Unless you are the one who needs to step out and you're the one in the midst of the argument, the rest of your team can do whatever they want to do.
Thank you.
Okay?
Okay, so there's no closed captions on this stream, so I'm going to
It went
match
on,
up the
Your
law
Honor,
and
just
crime
from
stream.
memory,
Yeah.
I do know and believe that there was
And we'll
there's a
switch.
reference to not his given name, not his formal name, but to a nickname. I'm getting that information.
In the wiretap?
Yes.
There we go. Is anybody surprised that this is happening? And thank you so much to Steven for the $1 super chat. I appreciate the support. You're always supporting this channel. Cutthroat Radio Podcast, thank you so much for the support. No comment, just a super chat. And then Aussie Tank dropping gifts in the chat. So Aussie became a member and helped 10 people become members. I love gifts. It's my favorite feature of the YouTube chat. You guys throw some party emojis in there for Aussie Tank. Thank you so much. That's so awesome. Well, I thought Atkins maybe had an answer, but I guess not. And don't forget, this actually involves Nichols, so we might see Bruce Harvey get up and make an argument about all this. Yeah, and let's never forget, I see you guys pointing out in the chat, Angie in the chat had pointed out that Glanville said Steele was unprepared. But here we are. Good morning again, Tasha. We're doing the same old thing with Love not being prepared today.
Okay.
Right, Sentinel. Cue the Jeopardy music. I should. If I had a soundboard, I'd put that on there. Like, just start playing it. Kels, exactly. Thank you so much. Again, if unprepared was a person. And I wonder if it's making a difference that Hilton's not here. Like, maybe Hilton would have had it together. And then Love ends up having to leave anyway when the judge was like, well, pretty much everybody but you can leave while you're the one making the argument. Maybe we'll get the shopping cart to make an appearance. Miss AB, good to see you. We are focusing on, so apparently in the fall of 2023, due to a wiretap that may or may not have actually had a warrant for that wiretap, they had a phone number with a person of interest identified as something Boyer. And it's not clear if back in the fall, when they knew of this phone number and this person, if the defense was made aware of the person of interest being Boyer. So they never had an opportunity to look into this person, find out that he was near or maybe not near the co-defendants during the Waters Road incident, which would have actually involved Bruce Harvey's client, Mr. Nichols. So I'm sure Shardt, Steele, Bruce Harvey, when it's their time to respond and make their arguments, we will get some early morning fireworks. Thanks so much for your support, Miss AB. Simply Sherry, it's crazy, but so Simply Sherry says it's crazy Love doesn't have this info on hand. But I think everybody's used to it. The judge has to be getting used to it already. She's been here like a week. Like, she got here a week ago, and she has to already be used to Love doing this. That's insane. It's like when you start a new job, sometimes you're on like a probation period. You got like 90 days and we could fire you voluntarily or something like that. Try to put your best foot forward. We get a new judge, Love is just like, oh, we're going to do the same thing we always did. The court reporter's probably enjoying her time off.
One other thing you were going
There we
to
go.
do, well, a couple of other things today. We discussed yesterday, providing the exhibits to the extent they're currently ready with the rest of them. Has that been done?
Can I get that to you at lunch? She's still working on it.
Okay. Okay, and co-conspirator statements, the same? Okay.
So apparently they
All right,
have that
any
done.
idea of timing on this?
So our legal assistant is working on getting the affidavit.
Okay.
The nickname listed in the. Okay, so the wiretap affidavit was served in discovery on 8/22/2022.
Yeah.
So
I'm not looking for the wiretap affidavit. I'm looking for the affidavit to get Mr. Boyer's cell records. I don't assume that was served in discovery, was it?
I'll check. The reason that the phone records weren't served was that they were considering arresting him.
So the answer is no on that one.
Correct.
Two things, Your Honor. First, yesterday we were told that it was, to my understanding, an inadvertent oversight by the state to hand over these records. Now we're being told it was a conscious
Intentional.
decision not to hand over the records.
Yep.
Secondly, regarding the affidavit for the search warrant for Mr. Boyer's, presumably Mr. Boyer's phone records, I specifically requested that yesterday via email, and I haven't received it either.
Wow.
And I reached out to the investigator who got that last night. That person, I can provide information to the court and Mr. Shardt as to what is happening to the lady that on their end.
Is there some reason that can't just be shared right here and now?
They're trying to thwart a murder.
They're trying to do what?
Thwart a murder that is underway or being.
Okay, then seems they should pass off the responsibility for getting the affidavit to someone else.
My legal assistant is looking for the affidavit.
Did you in any way respond to Mr. Shardt?
No, I didn't see the affidavit email. What we were trying to get last night was the information about the phone records. That's where I got part of what I provided to the court this morning. What I'm waiting on is my legal assistant, because the person we were able to communicate with at the door said, the lead investigator said that the affidavit was provided to us. So
The affidavit was provided to us as in, I don't know what.
Turns out, I'm sorry.
Well, I mean, I would assume so.
So that,
Look
so
at her
we
face.
have it, we should have it to give to Mr. Shardt and to the court. I'm awaiting that to provide it to the court, to Mr. Shardt.
Okay, and so you didn't see the emailed request from Mr. Shardt last night that said, could we please have the affidavit in support of the cell record?
I did not, and the court is welcome, Mr. Shardt is welcome to look at my email.
I'm sure you get a lot of emails.
I did not see that. I don't even know what time he sent it, but I did not see it.
And I want to be very candid with the court. I sent this to Mr. Atkins because he was the one that sent
Oh,
the
okay.
information.
Well, that's
Um,
why you didn't see it, Ms. Love, because it wasn't sent to you. It was sent to someone else.
Because he was the one that sent us the phone records. And I want to be clear, and I think it's clear what I wanted, but my email said that I wanted to see the search warrant, which we haven't received either. Obviously, I meant search warrant and affidavit, but I
Okay.
did put search warrant. But we haven't received either.
At what time did you send that? It was,
1:53 p.m.
so yesterday afternoon. Okay. Okay. Okay, so I understand that I can't remember who just stood up and raised it, but whomever said that yesterday you said it was inadvertent, and this morning you're saying there was a decision made not to share this information with the defense because Mr. Boyer had not yet been arrested and APD was contemplating whether to secure a warrant, and I didn't want to alert him. So which is it?
Thank you. They are both. I asked the court yesterday
Mhm.
to allow me time to speak with team members.
Right.
And the information internally that I know is that when the phone records were initially secured,
In the fall of 2023.
yes,
Okay.
when they were initially secured, the thought process was, we're going to get this person arrested and indicted.
Okay.
As time went on, our team had the records, and as we advanced in trial,
Do you know when the decision, if there was one, was made, okay, we're not going to get a warrant for him after all?
I don't think that decision was ever made, because talking with the lead investigator who got the records last night, there is still frustration because they get permission to get the warrant, and their efforts have not yet been responded to. So they're waiting. That person wants a warrant. So there's not, the decision to obtain the warrant has not been abandoned. The
Okay.
efforts to obtain it have not been abandoned, but we are at a place where it occurred to team members that, oh wait, we have this, we need to give this over. And time progressed. It was in our possession.
Mm-hmm.
It occurred to team members. This is something we can't wait for a warrant or arrest on. All of that is true. And I would have to consult with our team to see when they ask that those records be plotted, because at that point, I know that would be something that, at least in our minds, we're thinking, we could use this, so I could get that date as well, the date that they were sent over to be plotted. But,
Okay. Because, I mean, do you think that it's reasonable that at least by that point, you should have shared that information with the defense?
I think that when we're talking about realization and oversight, that at least at that point, if not sooner, at least at that point, that is when it was, oh shoot, I should have turned this over way earlier, at least by then. So initially there was this belief and understanding that there was this investigation that would lead to an imminent additional person charged. That has not occurred. And there was the realization that we have in our possession this data that we need to turn over.
This is
Are
crazy.
there any outstanding warrants for any other things for Mr. Boyer?
Yes, I believe he has, not here, I believe he has, I think he is in jail for a murder, but I think he is in jail in another county, not here, but I think he's in jail.
For like a pending murder? Not a pending murder. The murder has already happened, the murder that is he charged or is he just?
Charged, I believe he's charged for a murder.
Okay.
I have no
Do you-
details about that murder, I have no details about that.
Okay, but he is in custody somewhere in Georgia facing charges.
Yes, the capital.
This is like making me feel funny that this is what she's doing.
So, does the state intend to try to talk to him?
We were not going to talk to him.
Okay, does the state intend to use this plotted out, whatever y'all got about his cell phone location at different times?
No, unless, so, no, not in the investigation.
All right, and all the information you have, the state have regarding Mr. Boyer is inculpatory of these 6 defendants, or not all 6 of them, whomever is charged in the Thomas murder?
In the drinks.
Drinks, oh, okay, okay. Which is something that other than your opening, which isn't evidence, have you gotten to that point in the evidence yet?
No, that would be likely one of the last.
Okay. All right.
I feel like there was another question the court asked me that I did not answer.
I don't know what it was at this point. All right, so I will, whenever it's forthcoming sometime today, get and share if I assume Miss Love's going to share based on the request, the affidavit in support of and the search warrant and with the defense and also with the court, right? Okay. So we will await that. And then if anybody wants to argue anything
Plot twist.
concerning
I
it,
mean, suspense.
I will listen. The fact that this has to do with the drinks murder makes it a little less well, strike that. If y'all want to say anything else after we get those, then I will entertain it. Okay.
Oof.
All right. So in the meantime, let's keep plodding
Yes,
through
exactly this.
this set of statements of Mr. Zachary's.
Can I ask a date or a date certain for the court to inquire of a date certain on this issue before you?
On the debt, on the getting the affidavit and the search warrant?
No, on, I'm just, I'm sad saying it. I'm really hurt saying this, but this is not new. So a date when Ms. Love just said, oh, shoot, this is not a quote, but some effect of, oh, shoot, we must turn this over. That was before giving it to Agent Berni. So what happened on that date of the oh shoot to we get it yesterday, and we don't get it new. Like, oh, this is new stuff. Let's
Good
talk
question.
about it.
That was, so We are one team, but we have many members and parts, but I will get the date, but I can tell you that when I said that there was the realization that we do need to turn it over.
Yeah. When did that realization occur?
I will find out because it was not mine. It was not my realization.
Okay,
I'll
You
find
said
out.
I said, oh, shoot.
What I'm saying is
Who's in charge of the team?
I am. And so therefore
Okay.
it's mine, generally speaking. I'm saying that in terms of a date certain, there was communication internally. We looked at it. We were looking at everything we had to turn over, and we were looking at anything that we haven't turned over. Collectively, we realized, oh my goodness, this has not been done.
All right, and you don't know what date that happened?
No, that's what led to turning it over.
On Monday.
Yes, this weekend we were talking about it and we turned it over.
All right, so sometime over the weekend is when the realization occurred, oh my gosh, you knew you hadn't turned it over. Oh my gosh, we need to turn this over?
Oh my gosh, it has not been turned over and we need to turn it over.
Okay, and you're getting us the information about when when we get the affidavit in support of the search warrant for the cell records, we'll know the date that occurred.
That is correct.
Uh-huh.
We're working on that.
And it did not occur to anybody at that point in time that this is information to be shared with the defense?
When the court says at that point in time, you mean with the affidavit for the search warrant? When the search warrant for the records were obtained?
Yes. Right? I mean, obviously not, since
No, because-
you got them in the fall of 2023.
And because the information that the search warrant was based on had been provided. So
Well-
we weren't thinking along those lines then.
Okay, had you at any point provided information that the phone number that y'all all know about from the affidavit and the nickname, which I think that's what it was, you were going to tell me what the nickname was, is actually DeMarco Boyer. Did you ever before Monday share that information?
No,
Okay. All right, what was the nickname?
Unc is
Unc.
the name that's listed on, I think in the wiretap, I think it's.
Okay.
Unc. That's. And I'm also seeing if there are any other nicknames associated with that number. There may be more than one. That's not uncommon. So I'm gonna get all of them.
This is crazy. She said, oh, shoot, right? And then said, oh, I don't know who had the realization.
May I step to the door once more?
Yeah, and before you step to the door, is there at this stage, which is mid-trial, anything else, whether Brady or not,
Great question.
that you think might be relevant to either the state or the defense in trying this case that you, the state, know of that the defense still does not know of?
Come on, Miss Reciprocal Discovery.
And you may want to huddle with whomever comprises your team, and y'all all put heads together and really, really, really think about that, and then get me an answer after lunch, okay? Can you do that? Okay. Yeah, just we'll recess in place until you come back from whatever you're going to find out at the door
Please.
now.
Holy moly. The judge is pissed. Rightfully so. Love is stuck. Someone in the chat said she buffers.
And since we're recessed in place, I'll just sit here.
Okay.
No, go. Oh my God, no, go find your team and figure it out. Oh my gosh. What a great day for gifted memberships, you guys. Thank you so much, Aussie Tank. This is a crazy start to the morning. Like, did we get a valid excuse out of her? She tried to say I didn't realize. And that's a weak excuse. It doesn't, like, make it okay to try to introduce something late. But sometimes a judge will give it some discretion, right? But then 7 or 8 minutes later, you're saying, well, I wasn't the one that had the realization. You just told us. And then the judge has to ask you, who's your team? Who's in charge? And Love is like, well, me, you know. And then she's just sitting here panicking on her phone to have someone else come sort it out. Like, this doesn't look good. And to me, I'm so glad the judge not only took back her commentary that, oh, this is about the drinks murder. She also said, strike that. She doesn't want that on the record. Because think about it. If this was an ordinary trial, talking about 2 different counts might not be spaced out by 100 days. This could be a day or 2 apart. And there could be information relating to this incident of another party. Someone that apparently is in jail potentially for a murder. And the defense hasn't had time to look at that and see if he could be involved in not just the drinks murder while someone else is charged for it. Maybe he was out here involved in the other stuff, the other counts. And it's just another instance where we get somebody introduced into the playing field that looks like they've engaged in criminal activity relevant to the same type of criminal activity in the counts here that wasn't looked at as part of this investigation. The state doesn't look in that direction. And it all goes back to the opening statements from the defense. They don't know. The state doesn't know who actually killed Donovan Thomas. What evidence do they have that says they're sure they know who it is? It's just crazy. So thank you so much for the gifts, Aussie Tank. It's been so generous of you. I think you've given 15 plus. You became a member yourself. So I appreciate that, you guys. Everyone shout out Aussie Tank in the chat. Simply Sherry, this is, yeah, we read this again, but it still applies. I think it's always so funny when a super chat from 30 minutes ago could apply to what we just watched 2 minutes ago. William Fagan wants more than scoldings. I think the whole chat agrees with you. I would bet the whole chat agrees. Thank you so much. Thank you so much, Living in Truth. And then Steven says, is there any other cell phone location data? It would be interesting if the state uses location data to show when people were together. And I had seen, this is like through the grapevine, you guys, but, you know, Woody said that when he does something he's not supposed to be doing, he leaves his cell phone at home. So there's this whole, and I have some, someone on X named Price's Audio went through some case law. So State v. Bagley, Georgia v. Jones, and State v. Thomas are all case law that support what could be a defense to the use of cell phone location data. That a cell phone pinging to be in a certain location at a certain point doesn't mean that the person who's tied to the phone bill was or was not in that physical location at that point in time during the commission of a crime. So when we have a break, I want to look at that as well as that Corey Harris update. It'll be a quick hearing. He got his permit a month ago, and he had a hearing set, a pretrial conference today, 8/7, but if he got everything tightened up, he might be good to go. So we'll get some news on the famous or infamous Corey Harris today during the lunch break and that case law. But thank you so much. That's a great, point to consider, Stephen. But yeah, I don't know where the state wants to go with this, but I don't think it's their discretion to decide whether or not, just because we don't think we want to use it. Because they might not want to use it because even though they said the word inculpatory earlier, do we trust the state that the things that they say are inculpatory are in fact not actually exculpatory evidence for the defendants that they want to get the conviction against? It shouldn't be the state's decision to make there. Aaron Grimmett, thanks so much. Aaron says they had to step out to call Judge Glanville to tell him what to argue. He's probably up at the other trial he's presiding over, like, hold on, I have to take a comfort break. Be right back. And then thanks for asking, Cut Though. So the little symbol, I think it's like a dollar symbol, money symbol. It might look different in different countries. Next to where you type into the chat, there's an option to become a member. So click that, you should see it. And I have heard that if you're using like an iPad tablet, you do actually have to like go to a browser rather than the YouTube app, which is kind of a pain in the butt, but thanks for asking. And then Gwenin says, thanks for hosting Nick's crew while he's flying. Yeah, oh, I saw his picture posted at the airport. We can pull that up over break too. And thanks so much. I'm glad to have you here. I love Nick Starro. And then anyone want to bet she got dressed in the dark today? You know, I had this thought. I didn't notice wrinkles on the back of her blazer when she first got into court. And then when I switched streams, I noticed wrinkles. And all I could think of is like, is she like something coming off of her that's making her wrinkle, the tension. But yeah, it kind of clashes, in my opinion, with the green nails. Those green nails have been a talking point all week. But thank you so much, FFS. And then Miss Kim's Hilton is job hunting. Well, so apparently, I think Joseph Bapp covered it. Maybe it was Thugger Daily. Her, Fonnie Willis, and some other members of the district attorney's office are at a conference in Boston. And I think Hilton and Fonnie both got some type of award at this conference. So the vacation is actually like a celebratory thing for the work that they're doing, coincidentally enough. So. And then Aussie Tank just dropping the gifts in the chat. Look at that, you guys. Major, major love to Aussie Tank. And don't forget, use your Mario Kart racers. Choose your racer now that you have member emojis. Annie. So I love a little all caps once in a while. Annie Bailey Brown says she had all night to prepare for this. Mistrial in all caps. And imagine all of this stuff is happening. Okay, the camera audio is off. So it looks like they're saying something, but Long Crime isn't picking it up. Maybe it wasn't relevant. But that's kind of pesky when it happens so quick and Long Crime can't turn the sound back on. But back to Annie, imagine there's still outstanding motions for mistrial. Brian Steele yesterday filed an additional motion to disqualify lawyers Love and Hilton. I would not be surprised if we see more filings today. I'm surprised. I feel like some probably were filed right at 8:30 in the morning when the court opened, from the stuff we learned yesterday and Monday. But the judge is considering these mistrial motions. She said she was focusing on Brady issues. And then this happens? Do you think that will influence a judge's decision as she's looking through the rest of that motion and trying to decide what to decide, how to rule? So thank you so much for the 2. And then Bridgetta says, this needs to be a TV show called Unfortunately DAs. And if you guys didn't know, Doug Weinstein has a podcast and he talks about cases like this. And he calls it Prosecutors Behaving Badly, which I love. All right, and now we might have a longer recess, which means the state can't get it together. I don't know what Atkins is doing out there. And remember, one of Love's excuses, one of her many excuses was, oh, we can't get in touch with Agent Berni, the one that did this search warrant affidavit for Boyer's phone or Unk's phone, whatever we want to call him. We can't get in touch with Agent Berni because he's trying to thwart a murder right now. The judge was like, well, get somebody at the precinct, at the desk, to get this information for you. Just crazy. This is definitely an unfortunate DA's office. Miss AB, I agree. And as always, this chat is coming right in hand with Mahadi. And Mahadi yesterday had pointed out, remember, this is the downside of being the state when you've got 6 co-counsel. Well, not co-counsel. You've got 6 co-defendants and each of their counsel, all making their own individual arguments. And there really hasn't been that much divergence where, with these co-defendants, these 6, they don't want to make the same argument as each other. They've really been enjoined for the majority of the actions happening. So not only is the defense team sharp, it's like 6 times. You've got a bunch of people over there. And then Mahadi says, hands up and back away slowly on this trial. And they just walk away. Just walk away. It's like that burning Elmo, or the dog that's sitting in that burning room, like, this is fine. That meme. And thank you so much, More Daily. More Daily says, if you know it, it ain't Brady. What you mean? And that is, you hear criminal defense attorneys point this out. Well, you know it now. So it's not Brady anymore. I mean, it might be Brady, but it's not a violation because you know it. You've somehow been disclosed. And we heard Love try to say, you only need reasonable access to something that's Brady material. You don't need equal access to it. And I don't know where the judge will land on that type of argument. But this is exactly it. Well, you know it now, so it should be fine. Sentinel, thanks for the love. Appreciate you. Hey, Biz TV, good to see you. Are you taking an off day from covering this? So Tay Biz says, hey, Love, get that white flag ready. Prosecutorial misconduct, potential Brady violation, case dismissed, aka Rush trial energy needed. What up, though, Kat? Good to see you. And yeah, do you think this would be, imagine if maybe even Whitaker all the way from the beginning, or someone like Judge Summers, who was presiding over both Rush trials, the one that flat out called a mistrial when she learned that Special Prosecutor Morrissey didn't disclose and may have been okay with things being hidden under another case file at the police department. Different ammunition that was brought into the police station by a Good Samaritan that had said, these were on the Rush set, I think. I believe these were on the Rush set. And they were actual live rounds that were filled into dummy casing shells. So the defense the state had decided, no big deal. It's not material. The judge disagreed. Judge said, well, it's not your decision to make. You should have just disclosed it. Called a mistrial with prejudice. Crazy, crazy stuff. And then Miss AB says, this is bad. It makes her look very incompetent and looks as though the DA's office has not properly handed over all documents. Miss AB, I think you put this at 929. So this was before Love had to buffer, Love got stuck, and she was stumped in her tracks when the judge said, is there anything else? I really want you to think really, really hard about it. Maybe get your team together. She was so close to saying, your little team. Get your little team together. I feel like Whitaker was real close to adding that lil in there. And figure out if there's anything else. So you predicted that. You predicted that question. It looks as though they haven't handed over other things. So thank you so much again for all your support, Miss AB. Rod Factor for 49. That's amazing. Thank you, thank you, thank you so much. And I always love an excuse to see your t-shirt on the screen. Especially it's covering the Long Crime logo. In all caps, we have, get her off the damn trial, please, LOL. I think everybody in the chat can agree. Put a 1 in the chat if you agree with Rod. Or put a 2 if you think she should stay, because it's a win for the defense to keep someone like Prosecutor Love on the opposing team. It could go either way. So thank you so, so much, Rod Factor. I appreciate that so much. Kels, and the lie detector test determined that was a lie. Yeah, man, just... I said, shoot. Oh, shoot. When I realized, I had a realization. Oh, well, it wasn't me that had a realization. Just figure it out. And some of it, I do think there's a dishonesty factor with Love, but I do think a big portion of how she gets tripped up is she is so allergic, like oil and water, to the idea that she made a mistake, to the idea that she's the one that got something wrong, which at the same time makes her so opposed to taking accountability. So she tries to come up with these cover stories to excuse that it was someone before her in the chain of command, which the judge is clearly pointing out, you still lead this team, so there's no excuse if the chain is broken before you. You're leading the team, so it's still your responsibility. But Love still always wants to, like, pass the buck backwards. And I think that ends up making her, I do think she has a dishonesty problem, but I think it makes her make up excuses that also look like lies. They pile up, they're inconsistent. All because she's afraid of being embarrassed. And that's like really not a good way to carry yourself as someone in the position she's in. As a chief deputy district attorney, leading a high profile case. It's just crazy. So the dishonesty and her endeavor to keep her ego above water. Two really bad things. Thank you so much, Kels. SQL knowledge, something that I have none of. I don't know anything about SQL. Thank you for the 199. So nice of you. No comment or anything. And Archimane, you guys are gonna hate me, but on StreamYard, the text is kind of small. So when we're talking about candor to the court, sometimes it looks like condor, like the bird, like the big bird, the big condor. So when you guys are talking about where's her candor to the court, there's no candor. My brain is picturing like a big bird flying into this court and just like wreaking havoc. But yeah, no candor here. And she's already been chastised by this judge. You have a duty of candor to the court. You know, I want you to work on your professionalism, Miss Love, not both sides. So thank you so much for your support. I appreciate it. And every time I see the word candor, it looks like condor to me. So just know if I laugh, it's because I'm thinking of the bird. FFS has had enough. FFS says, shoot your lion self up and just sit down. She stood up that whole time but never grabbed the mic. Not once. Moses Dupree is predicting that there is no affidavit. That would be really bad. That would be really bad. And in any case, if there is no affidavit, that's problematic. If there is an affidavit, I suspect it'll show that we knew something that we should have actually disclosed to the defense at a certain date, and that affidavit should have a date, because the affidavit's supposed to exist before the search warrant. So either way, if it's missing, that's still on the state, because the police agency, arm of the state. If there is an affidavit, I think the defense is going to hammer out, hey, well, this affidavit shows a date and discusses some stuff that you should have made us aware about. So I think this is a catch-22. I don't think there's a way for the state to come out of this except for the judge to show some grace. That hopefully the grace Judge Whitaker has expended on the state is exhausting. So thank you so much, Moses. Cutthroat Radio Podcast says AI is helping Love talk. I mean, we know she was on that screen, that legal AI. Thanks to, I think it was the Hood lawyer that had pointed that out on X. He saw it on his screen. Like, just, like, truth is stranger than fiction. Lisa Dunkley, thanks so much for the 199. I appreciate that, and I love your glasses. TV says I would quit. Pulling Orlinda Johnson, like in the Rush trial, the prosecutor that said, look, I don't agree with what's going on. I'm out. I am out. And then Archimane, okay, so I think this might be talking about Boyer, because I had pulled it up on the screen while we were still dealing with Love buffering, but he's in DeKalb County Jail. So I think you're talking about Boyer here, which is another interesting thing, because if somebody's in custody, the state has ready access to this person. They know who he is. They know that, they wiretapped his phone, and in relation to this case, as part of the investigation into this case, they're looking at his cell phone data, and they have a recording of some call. They should know all of his personal information if they have him in custody. So I don't really know if going back and trying to say, well, we disclosed a possible nickname because there was a nickname used in this call that we intercepted, and we disclosed that to the defense. I don't think that's going to be a strong enough argument if the state also knew actual name, government name of this person, and didn't provide that to the defense. They have him in custody. How do they not know? So great point. I'm like, I could be wrong, but I'm like 99% sure you're referring to Boyer here. And dang, this is a long recess, you guys. It's been about 15 minutes since they went on recess. And Atkins never came back in that courtroom, so Atkins was somewhere doing something, trying to get it together. And Mom, there goes that man again. Says, I pulled it up earlier, but Woody mentioned someone not being on trial. This was yesterday. And I'd seen this over, I think someone mentioned it on X as well, where maybe I think on his Instagram story, Woody had made, and maybe it's still live, or still in that like 24-hour window for stories. I'll pull it up. But he referred to someone who's not actually on trial right now. I don't know, so I'll see. I'll look through his IG stories. But think about that, if Woody's trying to point out, and, you know, there's been some discussion that Woody had friends in If Gang. And he was also friends with people that were with YSL, whether YSL is a gang or just the record label. Whatever the case may be. Woody knew people from both spheres. So, would it be far-fetched for Woody to have some knowledge, maybe not even personal knowledge, but he heard from somebody, that somebody else that's not on trial here could be responsible for something that went down here? He could just be trying to pull a fast one to get this case to fall apart, right? Who knows? But at the same time, these are all things that you would think that if the state has been investigating all of this stuff for this long, why don't we know about this person? Why doesn't the state know about this person? So thank you so much. You're just highlighting the craziness of this case and the state. I appreciate you. MTK became a member. Iron Rabbit, good to see you, became a member. And Iron Rabbit helped 5 more people become members. So shout out to Iron Rabbit. Throw a rabbit emoji in the chat. That's so awesome. I appreciate so much when someone gives gifts, because it supports the channel, it helps me, but it's like cool, it gives someone in the chat something fun to do too. Miss AB says it's a little less icky. And then FFS says, she said, I think he's in jail. I'm not even in GA, and this is great. This goes back, we were just saying if he's in DeKalb. Or is it DeKalb? I'm not from Georgia. I don't know how to pronounce things. She said, I think he's in jail. I'm not even in Georgia, but I'm 100%. You can track them in the offender registry for the Georgia Department of Corrections. The realization happened a long ago. You would think. You would think. And if nothing else, then it's just a sign that these investigators suck. So, you know, no shade to Agent Berni necessarily until I hear more. Apparently he's out here thwarting murders, so good, go do that. But if there's a detective, an investigator looking into something, and they're not aware that someone that they're getting a search warrant for to look at their cell phone data is also currently locked up, and they don't know that, and then they don't think, if they do know it, they don't think it's relevant to put in a report to provide to the district attorney's office. Like, that's just interesting. And if they knew this stuff and they had it filed on this person for a different case, if the state should have looked at it. The DA should have said, all right, we have this data charted out. Maybe we can run this person's name in our own system. Like, it just doesn't make sense. It doesn't pass the smell test. Thank you so much for your $4.99. Raphael Moore says that we need to rename the trial to the new Brady trial. I should make a little overlay, just like, we're watching YSL trial day 107, but make it the new Brady trial. It's crazy because as soon as the judge hones in that, hey, we might have Brady issues, we get this late disclosure. I was thinking, yes, 199, I agree. I was thinking says, doesn't this strengthen Steele's motion? I think so. I think it just gives him a chance to add another supplement or file a new motion. I wouldn't be surprised if he does either one. He could be typing it right now for all we know, running down to submit it. Like, just crazy. Okay, and UNC might be short for unknown. So. But a lot of this is just crazy, and we're still just double checking that I'm not crazy that this isn't starting. Still on recess. And I feel like the number one thing the judge doesn't want to do is take pauses in hearings like this. She wants to keep things moving. And then look what they're boxing her in to do. Okay, cool. So I have it listening. Kathy Roussan posted this, just so we have a face to a name. More info on DeMarco Boyer, the man being talked about this morning in YSL. Man arrested for fatal DeKalb County gas station shooting in November. This is from December 20th, 2023. So I heard the date of August 2022 mentioned at some point, and then also fall of 2023 was discussed. So, who knows? We've got some nice ad here. But he was arrested in connection with a fatal triple shooting at a gas station. The triple shooting took place on November 26th at the Texaco Circle K near Candler and Kelly Lake Roads. 2 people were wounded, and 41-year-old Antoine Lewis was killed. The DeKalb County Sheriff's Office Fugitive Unit, with the assistance from Georgia State Patrol's SWAT Unit, arrested 26-year-old DeMarco Boyer on December 20th at an apartment complex off Roswell Road in Atlanta. Boyer was transported to the DeKalb County Jail, where he's being held without bond and on felony charges of aggravated assault, possession of a firearm by a convicted felon, and murder. Police say that another person, Omni Ali Woodard, who's pictured here, has already been arrested for the fatal shooting. However, that person's identity has not been released. Okay, so that was a quick article there. But shout out to not just Kathy Roussan, but it was Luis Wood that had just tagged me in this so we could all see it and talk about it on here. So I appreciate you, Luis. I'm not sure I've seen you in the chat because I know you go by a different name in the chat, but I'm not sure if I've seen you. It's been going by really quick. So sorry if I didn't say hi when you came in. But I'm going to retweet this. It'll be on my timeline. And there you go. If you want to look at the article, just shared a link to the tweet in the chat, the general chat. So great stuff. I love the crowdsourcing and always appreciate it, you guys. And then let's see. Yeah, and let's talk about this. I talked about it in the beginning of the stream here. But Yada is saying she turned it over Monday night. Right? So what happened on Monday during court? KB, Caleb Bumpus, said KC, Kenneth Copeland, said he knew about the car and someone not on trial. She knew Boyer was a person, that's why she sent it. Right? Think about that. Think about that. You may have heard me call that a Hail Mary yesterday when we found out about the Monday night disclosure at the end of court yesterday. I said it sounds like a Hail Mary based on what happened with Caleb Bumpus, Melnick, everything on Monday. When they mentioned of another car, the Infiniti, and then not for nothing, but also Detective Long, who was called by the state to get up there to tidy up loose ends, was kind of like, yeah, there was something mentioned about an Infiniti, another car. Uh-oh for the state. Big uh-oh for the state. I don't think we really realize the scope of the uh-oh, but maybe it relates to this, even though this is supposed to be related to the Drinks murder. How do we know that this same person wasn't running around having beef with other people? Apparently is picked up on in relation to a triple attempted homicide, because I think only one person died. And they just decide it's not something worth disclosing to the defense. That's really nuts. And before I get lost, I do want to point out one other thing. You guys are going to like this a lot. You guys are going to like this a lot. It was very funny. So brace yourself to laugh. So yesterday, when Thugger Daily had shared the additional motion by Brian Steele, Shada Jimenez, who is the co-host, he's another attorney, he's close friends with Doug Weinstein. He hosts the Prosecutors Behaving Badly podcast with Doug Weinstein. I saw him reply with this. It's so funny. Talking about love. He says, she accused me of spying on her through my printer. Love at some point accused attorney Siri Shada Jimenez of spying on her through a printer. Where does that idea come from? Maybe it's just blatant paranoia. Maybe it's partial projection. Because we've got questions about some of these wiretaps. Were there actual proper affidavits and search warrants to obtain them? You've got all this paranoia from Love and kind of Hilton and kind of Judge Glanville. The defense is in cahoots. They're conspiring. Oh, Max Shardt cursed about Judge Glanville. We have video of it that we don't actually have video of. We're tracking people. And then someone who is no longer, I don't know when this accusation may have came into play, but this could be related to a separate trial, a separate case. Love was still paranoid with this attorney. Isn't that crazy? Like, I meant to start the stream with this. I totally forgot this morning. But I thought that was crazy, crazy. Yeah, she always accuses others of doing misdeeds that she might be committing. Sounds like projection. Prosecutorial projection. Hold on, wait, is this a plot of a Suits episode? No, that's crazy. I have to defer to the chat on that one. I don't know about the show Suits. And guys, we're still in recess. We're not missing anything. But I forgot about that, and I laughed out loud when I saw that. And Suri Shada Jimenez, doesn't really seem like the type to post memes or just make jokes or hyperbolize things. So it was even funnier coming from them. Polo says the whole defense is writing motions right now. That poor court clerk that has to do all the filings. Thank you so much for the super chat. Cash Money Cass says, Love is quick to place blame on her team, but would take all credit for a win quicker. Zero honor or integrity. But to be fair, it is Hilton getting some award this weekend. And I think Fonny did too. I really can't remember who posted it. Maybe it was Young Thug. I mean, Thugger Daily. Yeah, he did. Okay. So you know the drill. If you guys use X but aren't following Thugger Daily, that's the profile link in the chat. But he had shared this yesterday. For those asking why ADA Hilton has been out of court this week, she's in Boston with DA Fani Willis, attending a conference for the National Black Prosecutors Association. Hilton is the president of the National Black Prosecutors Association. Fani Willis was awarded the President's Award of Excellence. So, and then he includes these two pictures here. So, President's message, I guess she delivered. And then there's Fani Willis accepting the award. So, there you go. There's the deets on the Hilton vacation. But yeah, so it is Love getting the award this week. Or Hilton. Or I guess Fani. But Love wasn't invited, she had to stay behind. Catfoot asks, where is the judge's backbone? I don't know, but there's gotta be a simmering, burning feeling going up the backbone. Hearing this, I get pissed off about trials and disclosures because I always think that for the victim or for the defendant, I believe in innocence unless you prove beyond a reasonable doubt that the person's guilty. I don't think that the state should have extra power to just pursue wins in a case without actually pursuing justice. And the judge is supposed to be the referee there. So if the judge is seeing an instance where the state is abusing their power, not following obligations to disclose things to the defense, while also at the same time demanding undue discovery, reciprocal discovery from the defense, just the hypocrisy adds another layer to it. But just come on, just have the backbone. Have the backbone. They say it's not relevant to their case anyway. So how much harm would it be if you say the state can't bring it in? Although, who knows? I mean, maybe the defense will look at something and see that they actually find exculpatory information because of this defendant. I mean, this person of interest, Boyer, that could help exculpate their clients. So I don't know. But I don't know where the judge's backbone is. She definitely seems to be simmering in on the bench. I think she's about to lose it. She's starting to steam a little bit. So thank you so much for the super chat. Sandy for the $10 super chat with no comment. That's so nice of you. Appreciate you. And your name's Sandy and you're at a beach, which is kind of cool. So, I live in Florida. I don't ever go to the beach. I really should. But your picture looks like a nice vacation. Thank you so much. And G Lander says the judge seems deflated. I can see that too. I really don't think she likes taking these breaks. Like, she's just asked for efficiency. Time and time again. And we've had a court day where we're just looking at the Georgia seal for about a third of it right now. We might approach half of it. So thank you so much, G Lander. Lola Dane says, this is similar to the Rush trial. Prosecution didn't know the bullets were dropped off at the police station, but she didn't know. The judge dismissed it instantly for a Brady violation. And when the judge was looking through it, she said, look, keep these separate because they're clearly different. Thank you so much, Lola. Let me note a timestamp for when the court comes back for anyone on replay. That was close to 40 minutes since she asked, anything else you didn't disclose? That was about like 35 minutes that went by. And thank you to all the new members, Marcus, Steven. We've also got Nana Misty, cute cat in the picture. And then Nana Misty also gifted 5 memberships. I love the gifts. Thank you so much. Say thank you to Nana Misty in the chat, you guys. And I remember last week, everybody was complimenting the judge's hair. And it's like one of those situations where it's like, is this case going to make my hair turn gray?
Something else in the meantime?
Yes, Your Honor.
All right, thank you.
They still didn't figure it out. They're doing something else in the meantime.
Your Honor,
Yes, sir.
can I just add one thing to the previous discussion?
Sure.
A lot of the state's theory is that Mr. Williams is in charge of a gang and the gang does crime on his behalf. He asks for it and they do it. We deny that. I heard the court say, and I heard the prosecutor say that this is inculpatory, no exculpatory. Everything could be inculpatory or exculpatory.
Okay, can I just,
Of course.
I didn't say it's inculpatory. I don't know. I said the state, if I said that, I'm repeating the state's maintaining that it's only inculpatory.
I understand.
But, okay, go
And I
ahead.
appreciate it. And all I want to make the court aware as you go through decisions is if we knew about Mr. Boyer, then what I would have done is found out if he has a lawyer, because he's in custody, it sounds like, contact his lawyer, ask if I could go with the lawyer and Miss Adams, when I say me, and Miss
Yeah.
Adams, and an investigator, and interview him. And he may give information that's very hurtful to me. He may give information that is very beneficial to Mr. Williams. I don't know. My point is, though, that the state has no ability to know what's helpful or hurtful to Mr. Williams, and we have a right to investigate. So I just wanted that on the record as well, in case this
Okay.
goes up. Thank you.
Yeah, I don't disagree. Thank you.
Big argument. It's important.
All right, Ms. Lev, if you're at a stage where you can shed any further light on anything, great. If not, we'll take it up after lunch.
I'd like to take it up after lunch if the court
Okay.
will allow me. And I wanted to make clear, I'm not refuting anything regarding the need to provide it to the defense and whether it's inculpatory or exculpatory. I just wanted to make clear and make sure that I told the court and the defense that we're not asking to use it. We just wanted to, out of an abundance of caution, in the event that it is in some way, in any way exculpatory, give it to the defense. We're not trying to use it.
Okay. All right, thank you. All right, let's turn back to Mr. Zachary's statement that we were going through yesterday. And Ms. Love, you are going to take the overnight recess to try to determine if there are parts of the proposed redactions that you agree to.
So,
And Mr. Shardt, I know that, I don't know if it was you or Mr. Atkins that shared the the 3 pages of the proposed redactions with regard to this interview that we're going through right now. And honestly, there's not a date on the binder that y'all gave me, so I don't know what date to reference, but you have proposed redactions for the other interview. Can you share those as well, so I have something to go by?
I will. I'll send them over right now.
All right, thank you.
And Your Honor, just for the record, number 38, which is the next one, according to my records, I'm withdrawing my request on that one.
Okay,
We don't need to-
thank you. And what is the date of this interview?
this one is April 27, 2017.
April 27th, 2017. All right,
No,
thank you.
April 13,
13th,
2017.
2017. All right, thank you.
He's frazzled.
Okay.
Dante, I agree. I think that's possible. I think that's a big possibility. There was never an affidavit. It's being printed up now. Yeah. Would not be surprised. And we shouldn't have to be so skeptical. We should have skepticism, but we shouldn't be able to lean into our skepticism so much.
So
We should have
Ms. Love, I know
confidence.
you're looking for them, but did you get an opportunity, and are there redactions you agreed to?
There were not a lot. There was
Okay.
only one.
But you're going to find whatever that was and let
Right.
us know.
Right.
Okay.
And I marked them in the transcript.
All right.
That's why.
Sentinel, thanks so much for 10 memberships. Shout out to you. Everyone show some love.
Actually, the one that I thought that I did agree to, oh, okay, here it is. So number 76, again, the discussion about the injuries
All right.
of a certain part of the body, and that would be page 259, line 20.
Yeah. So you agree that that should be redacted?
Yes.
And that's the only one between 39 and 75 that you agree to?
Yes, and the reason that that is the case, I'll just say that I went back and was listening to the context. So
Yes.
I did read Mr. Shart's reasons for wanting to exclude it, but I wanted to just make sure that it wasn't necessary for a larger reason, and I'm prepared to express and
Okay.
explain why those are.
All right, well then let's just get back to it. We're on number 39.
So, Your Honor, number 39, I was shorthanding this. When I wrote yak,
Sure.
when I wrote yak, that's Mr. Kendricks.
Okay.
So my understanding from my recollection is that Investigator Dennis has never spoken to Mr. Kendricks about the murder of Donovan Thomas. Okay, that's my understanding. But either way, whether he's spoken to him or not, I believe he's just using a technique to try to suggest that Mr. Kendricks has said things.
Right. Excuse me.
But to the extent, either way, he's putting words in Mr. Kendrick's mouth. Mr. Kendrick may not take the stand. That's up to him. But I don't think it's appropriate for Investigator Dennis to state on a out-of-court statement for the jury to hear what Mr. Kendrick supposedly told him about the events of January 10th, 2000.
And Your Honor, that's at the bottom of,
Yeah.
and I can also provide the court the timestamp for it on the video that we've just given, but it's at 16:32 in the video of this portion of the interview. And when the court is prepared for me to, I can respond.
I'm prepared for you
Okay.
too.
So Judge, I hear and understand what Mr. Shardt is saying. I disagree with it. When Investigator Dennis says that Yak says something different, and nowhere does he assert, hey, I did this. Everyone knows there's not a dispute, I think, that Mr. Kendrick made a statement and said something different. And when Investigator Dennis says that Yak says something different, just to give the court some context, the 2015 interview that this witness gave contained inculpatory information concerning Mr. Kendrick, Mr. Stillwell, and others.
Okay.
By the time we reached 2017, it has been circulated that interviews have been conducted. Jail calls reveal that co-conspirators, at least alleged co-conspirators, people that we allege are co-conspirators, are aware of the content of some of these interviews. And at this point, Mr. Zachary is now saying he's backing away from it. He never denies that defendant Kendrick and defendant Stillwell said to him the things he said in the 2015 interview.
Right.
But now he's proffering theories about their actual involvement. He's saying, yes, they said that. They did say it. And when Detective Dennis says, after Mr. Zachary gives him a rendition of events, and Detective Dennis says, Yak says something different, there's nothing about him meeting, and the argument could be made by the defense. You heard Mr. Kendrick or whomever wants to make the argument, but that is a piece of evidence that will be put in at trial at the appropriate time. So
That piece of evidence being
Mr. Kendrick's,
statement where he does in fact say something different.
yes,
Is that what you're
about
saying?
himself, yes.
Okay.
So,
And he's already made whatever that statement is by the time of this 2017 interview with Mr. Zachary.
he has.
Okay, and so whether Investigator Dennis talked to Mr. Kendrick himself or not, Mr. Dennis is aware that in fact Yak did say something different.
Right, he's
Okay.
saying, right. He's,
And does,
and it's a broad.
okay, does Mr. Kendrick's interview, when we get to the top of page 116, Investigator Dennis is saying Yak said he was on his way to his girlfriend's house, I guess.
He does say that.
Okay. All right, and so,
Your Honor,
yeah,
I don't believe that's an accurate, I know why you're asking that question, and in the spirit that you're asking that question, I don't believe that's an accurate answer. Mr. Kendrick, first of all, a couple of things, and I bear with me. My understanding, Mr. Kendrick's statement has been suppressed.
oh,
No,
I don't think it's coming in.
she says no.
Judge,
All right, y'all,
the portion of the statement that it contains what we're discussing was not. What was suppressed is a portion where another detective comes in and starts talking to Mr. Kendrick.
Okay,
So there's a very long part of the interview.
before the part that is
Yes.
suppressed, and it's in the unsuppressed part that the representations that you
Yes.
just made are contained.
I don't, Investigator Dennis on 116 line 8 says Yak said he was on his way to Bush's house.
Yeah.
And they saw Nut at the barber shop and they made the call. I don't know if Mr. Kendrick's saying that to any law enforcement.
Well, we ought to be able to check that. I mean, right, like the statement is,
And the made the call portion, I'll agree. That part he didn't say, but the part about him being on the way to Bush's house, which is what I think is the most.
No, and he didn't say he saw Nut at the barber shop. My recollection of the statement and Mr. Weinstein's most on top of what was said in that interview and what portions were suppressed. But he said, I did not have anything to do with this killing. I went to my girlfriend's house. That's my alibi. I don't know. So the state, yes, he said he was with Busha in a car with her going to her house. He never said seeing Nut at the barbershop and making a call. That was not stated. So that's a misrepresentation of Mr. Kendrick's statement, first of all. And secondly, I mean, it's just completely confusing to the jurors.
okay,
So, Your Honor, the state's response to that is, when I stated there's information that Mr. Zachary and Detective Dennis exchanged before we reached the point where he says, that's not what Yak says.
Yeah.
And the reason that that is important is that there is a compound sort of statement at the top of 116, and Mr. Shardt is correct regarding Mr. Kendrick not saying we made the call, but the part where he says he was on his way to Bush's house.
right, that's not the part at issue. It's
Right.
and they saw Nut at the barber shop. Does Mr. Kendrick in his statement say anything about seeing Nut at the barber shop?
My memory is that he doesn't say they saw Nut at the barber shop.
Okay,
My memory is that he doesn't say that they saw Nut at the barber shop,
okay, and
but that he
That's-
was on his way to, so I'm not
That-
disputing that
don't-
part.
okay, so then that part needs, I would think, to be redacted out because it is confusing.
I have no problem with that. I just wanted the court to be aware of of the argument that we were making.
Okay.
It's,
So,
if the statement is going to be introduced as evidence, the reason that we were not conceding that part is that Detective Dennis's.
that part's fine. I understand everybody's arguments, so let's get to what we are redacting out.
Yes, Your Honor.
So page 116, line 9, and they saw Nut at the barber shop. Frankly, why don't you just also skip line 10 and line 11?
Okay,
Okay,
okay.
does that satisfy your objection, Mr.
Yes, Your
Shardt?
Honor.
Okay.
Yes, Your Honor.
Oh, yeah.
And yeah, great time for the reminder here. Thanks, Ted. That Fonnie herself, Fonnie Willis, said Cellbrite is unreliable. So we talked about it back during the
Next one
disqualification
is on
hearing.
117.
What about when they want to use the Cellbrite data against the defendant? Thank you so much, Ted.
No, what I'm looking at is number 40, which is what, oh, yes, on the other one, no, 9. Going back to number 39. The Yak said he was on the way to Busha House is fine. So the part that says, and they saw Nut at the barber shop, that part of 9 and then all of 10 and 11. Okay.
And just to clarify, Detective Dennis was one of the 3 in that interview.
Okay. Thank you. All right, as to the next one, Mr. Shardt, your objection is to in the investigator's statement, right? Or also the answer?
It's the investigator's statement, and I don't necessarily have a problem with the extent that he's asking Mr. Zachary a question. I don't think it's appropriate for him to say, see, that's I've done sat through so many interviews, heard so many different stories, kind of pieced
Right.
together about time dates.
In time frame. Okay, so.
You said pokes holes in everybody's story.
So, I would think maybe to avert that issue, can we consider a redaction from 117 lines 23 through 25? And then just start with 118 line 1, beginning with everything you just said pokes holes in everybody's story, because then Zachary says, yeah, you know, it does poke some holes. Because you don't seem to be objecting to the answer.
I would suggest starting on 118 line 2. If getting to
Okay, that's fine. Well,
3 or 4 in the morning.
oh, like 3 or 4 or 5 is the answer. Okay, I thought he was saying this is the number of holes it might poke. Okay, yeah, no, that makes more sense. Okay. So, 118, okay, so redact by agreement then, 117 line 22 through 118 line 2, the word story, and just pick back up with because of Demikian. All right, okay.
Could you please pull your mic up? Thank you.
Closer to me or further from me? Yes, ma'am.
Closer so we can hear you. All right.
This is such an awkward sentence, but it's true. The judge likes Shardt. No affidavit yet, EC. Revisiting that after lunch, apparently. Thanks to
right,
Welsh Lady Reads and Mark Nicholas for becoming members.
Why do you? All right, so the objection as to the 41 is that it's speculation. Is that right?
Right. It's a hypothetical. If it did, I'm reading that as if they did it. I don't think Demikian had anything to do with it. Why he ain't take it like you said, look at me and like little brother. I think in context, what he's articulating is people look at him as a little brother. And I mean, he wasn't there. He's not offering firsthand knowledge. He's just giving his theory that I don't think Demikian would be involved with something like that if they did it. And I just think that's speculation.
Does the state want to respond?
In as much as this is something that is repeated throughout Mr. Zachary's interview, and in as much as there is information that Demikian gave to Mr. Zachary, similar to the way that he gave information to another witness in this case who's now on the stand. The reason that I believe that this should remain in is that Mr. Zachary, at one point, Mr. Garlington was charged, but not by the state. And Mr. Zachary was in a position, he was with Mr. Garlington, Mr. Kendrick, and Mr. Stillwell after the murder, following the murder. So in as much as he makes the assertion, he later says more stuff like, Demekion never told me that he did it. He talks about what each person said to him. But I'll defer to the court. It's just, that's the reason that I wasn't asking or conceding immediately
All right.
that come out.
I mean, that seems like a valid objection. So we're going to strike 118.24 through 119, line 5. I'm sorry, line 4.
Marlena's hoping another mistrial is being typed while we wait.
All right, and this is the witness, Zachary, relating what Demekion has told him. And the objection is hearsay. What's the state's response?
Oh, okay, I'm 121. Demekion's statements to Mr. Garlington, I'm sorry, to Mr. Zachary. Much like the statements that Mr. Garlington made to Mr. Copeland, are statements of a co-conspirator. Later in the interview, Mr. Zachary expressly says, essentially, it was a matter of keeping us all in the loop, the information that was exchanged. At one point, he's asked, why are you all talking for 30 minutes at Doug's condo after the murder if nobody knows anything about it? And if not to that specific question, later on, Mr. Zachary says something to the effect of, we're just trying to keep each other in the loop so that we all know what's going on. In other words, from the way that I would argue it, Nut just got killed. Stuff, we have to keep ourselves.
Okay, so that would certainly make sense with regard to anything that got told to other alleged members of the gang right afterwards at the condo. As to this particular statement, Zachary actually gets asked, when did he tell you about that while y'all been locked down? And Zachary says, yeah, well, I've been locked up. So when was that? When did they get locked up?
So in the latter part of 2015.
Okay, and so if that is when this story gets shared.
So during that time, other evidence will show that as a result of the murder of Diamond Thomas, there were conflicts that existed both in to answer the court's, but I think the question is
Yeah.
how does it keep them safe? So the conspiracy that exists after Donovan Thomas is killed and before Donovan Thomas is killed doesn't stop when they get locked up. Inside the jail, there are conflicts as a result of the Donovan Thomas murder, and the knowledge or belief by members of If Gang that YSL is the entity responsible, or people within YSL are responsible. So the fact that Mr. Garlington is sharing with Mr. Zachary events that happened, I would argue still fall within the co-conspirator exception, or it still makes it admissible as a co-conspirator statement, but it's not something I'll hang a hat on, and if the court sees it differently, then just 1 second. it's not one that I'm going to strongly object to. It's, so it is a co-conspirator statement. These statements within the rest of the interview that are very similar to this are all co-conspirator statements. And for that reason, we object to the co-conspirator statements coming out. I'll just leave it at that. And of course, it's not one that I'm going to, I'll defer to the court's decision, whatever it is. But I'd argue that it is a co-conspirator statement, but there are more statements similar to this made by Mr. Garlington to Mr. Zachary that he alludes to. So I'm going to be making a similar argument about other statements like this. And for that reason, I'm not going to object strenuously to this particular one coming out. Object strenuously.
All right, so late 2015, are there,
Can I give Your Honor a little context?
yeah,
So Mr. Garlington and three other individuals, I believe it was three other individuals, including my client, Mr. Stillwell, warrants were taken out for them in around October of 2015. Based on the testimony or the word of a gentleman named Nicholas Robinson, or Spencer Wright, depending on when you ask him. But he gave these statements to police. They went and Investigator Thorpe went and got warrants for these gentlemen. On subsequent review of the footage from the scene, Nicholas Robinson was not present where he claimed to be on the scene. So at the time of giving these statements, Mr. Garlington, and there's jail calls that I believe reflect this, Mr. Garlington is in extreme prove my innocence, shift blame mode. He's not in any sort of co-conspirator, we're in this together mode. And he is asserting to anyone and everyone that will listen is, I didn't have anything to do with this. I'm wrongfully arrested. He's asking people to get video from the McDonald's on Cleveland Avenue, video that we still don't have, that will show he's innocent.
right.
And so these conversations that Quindarius Zachary is saying Mr. Garlington had with him are, from my perspective, for the purpose of asserting his innocence and shifting blame to others. So that would not fall under 801 D2E.
All right, and that's sort of what I'm trying to sort out is this a time that is, when this is shared in furtherance of the conspiracy, or is it not? And if there are, in fact, still beefs going on inside of the jail or outside, I mean, do they get released after late 2015?
No, it dies down a lot.
No, sorry, I just asked a compound question. So I am wondering about what is the state of the beef back and forth? And then I'm also wondering, do Zachary and Garlington get released after they're locked up in late 2015?
No. So
Okay.
they get released at some point later, much later. For instance, Zachary gets prison time, Garlington also.
Right. Okay. But not at a point in time when like they might be out in a week and so they need to know what's going on the street. So they all need to.
Well, not on the streets.
Okay. So tell me, is there in the jails beefs back and forth where they all need to be on the same page about something? Tell me, how is this in furtherance of the conspiracy?
So while they are in the jail, and this is broadly speaking and not to this at this point in time, while they are in the jail, inclusive of this point in time, there are continued, there are statements made and conversations that are had about different YSL members getting beaten up by if gang members. So there is evidence that we have to show of a continuing conflict within the jail and within.
Okay, how does Mr. Garlington telling Mr. Zachary, I wasn't involved, in furtherance of the conspiracy? Well, and the Woody picked me up after the shooting. I mean, because that's really the thing that he says. How does that further the conspiracy?
Our argument is that it fosters cohesiveness. It is information shared between two YSL members while they are in the same predicament of being confined among other persons who are members of an opposition.
All right, so I mean, I think the fact that on at 122 page 122 lines 1 through 3, the answer being that Garlington said, no, he does not. He says that Woody picked him up after the shooting. That's not, hey, Betty, I've got absolutely zero to do with this. It is still something that could in some way be against his penal interest. So I am going to find that to meet that co-conspirator exception. So I'm going to overrule the objection on that one.
So it just for clarification, so we're playing from 1 to 3 on 1.2.
Yes.
Okay. Okay, meaning I understand the question.
Yeah, no, I understand. I understand. But yes, that's probably a good idea to clarify that for the record. All right, so moving to number 43, which starts at the beginning of page 124 and is most of that page.
Recused Judge Glanville had me laughing so hard. Thank you so much. Thank you, Cassandra, for becoming a member and for pointing out that there's a smell test violation incoming. That was at 10:45. I think you called it. Can you imagine Love and Hilton on the witness stand being questioned? Hilton might not do so badly.
All right.
But Love.
What does the state say about this one?
So, Your Honor, in order for the argument is that it's hearsay about what Demekion said, and
Is that the argument or is the argument here? I mean, at least what's on the, yeah, false hearsay, if you will.
I'm sorry, I was looking at 42, 43.
Yeah. Yeah.
Was my impression and really for my notes, the fact that whether it was truly what Demekion said or not truly what Demekion said, the falsity is irrelevant. I take exception to Investigator Dennis relaying in a statement that would be heard by the jury what Demekion Garlington supposedly said to him. Demekion Garlington is not going to take the stand, to my understanding, in this case.
All right. Is Demekion Garlington's statement going to come in?
No, his statement to law enforcement will not come in. And we won't
Okay.
call him. And for that reason, I don't object to 1 through 4 on page 24, but when we get into, again, Zachary talking about what was shared to him by Mr. Garlington, we would object to that portion, but I don't have an objection to 1 through 4. The numbers 1 through 4, but the objection, the redaction requested is 1 through 22, so I'm prepared to argue the rest of it. So in as much as the argument made just now by Mr. Shardt is his objection is to Detective Dennis relaying what Garlington said, there's no objection to that portion.
Okay. Okay, so you're saying 5 through 22 is essentially just questioning. It's not any true or false assertion of what Garlington said. It's just him asking questions and Zachary answering them, right?
So it is sort of, it's him. So there was one thing, and I'm sorry, I apologize for doing this. It is much as Mr. Zachary acknowledges knowing that the police talked to Demekion Garlington. And in as much as that is contained within 1 through 3, I'd ask that the court keep that in and allow me to change that portion of my previous representation to the court.
Okay, is there gonna, well, what about, then what are we doing about line 4?
That I wanted, that's the part that I believe is not proper. I think that's a testimonial statement to come.
Okay, so then let me go back to Mr. Shardt. If 4 is redacted out, then what is your objection to the rest of it?
I don't have an objection to 1 and 3. I do, so to the extent that these are being brought in for Quindarius Zachary's answers,
Yeah,
and this is gonna bleed into number 44 on my list.
okay.
It goes into, my understanding is this information Quindarius Zachary is giving Investigator Dennis is based on things Demekion Garlington, it's being asserted that Demekion Garlington told Zachary in the jail when Garlington was trying to proclaim his innocence.
Okay.
So that is, I don't feel that these answers fall under the 801 D2E because, again, I don't feel that they're in furtherance of a conspiracy, the statements made in the jail. So that would be my objection to the answers.
Okay,
And those are interspersed in what I objected to in number 43 and then specifically in 44 as well.
okay.
And my perspective on that, for the reasons that I've already shared, are different than Mr. Shardt's. And I would add to what I've already said, that in considering, if it even comes to playing it, in considering what Mr. Zachary is telling the police and making a determination determination about whether to take it as true or not. Mr. Zachary at line 23, when challenged, essentially Detective Dennis is challenging him about what he has said in line 13 through 16. He says, as what's reflected in the transcript, Zachary pushes back, and then Dennis is asking another set of questions, and Zachary is correcting Dennis with information that he got from Garlington, again, still during this time when they are in confinement, and still during a time when there is still beef, if you will, between the two groups, YSL and Anthing. So to the extent that Garlington may want to get out of jail, I'm not understanding there to be any argument that Garlington is somehow an agent or another, just that Garlington wants to get out of jail. And somehow that makes this not a co-conspirator statement.
Right, that he's no longer saying anything. He's saying about, here's what happened, Zachary. Hey, Zachary, here's what happened. Because you're my fellow gang member and you need to know this. He's saying, I'm innocent of all of this in the hope that either, I don't know whether he cares whether Zachary believes it or not, but in hopes that that gets out.
And my position is that would be an argument to be made. Obviously, the jury can take what they hear and throw it.
Okay, but I have to make an evidentiary determination whether this is a statement made in furtherance of the conspiracy, which is what we're discussing.
And our position is that it is for the reasons that we've given to the court.
Thank you so much, Joel. And to think, after all this BS, Fani will get reelected. She just got an award. You guys are like, please stop with Love doing the arguing. Get rid of Love. We don't want to listen to her.
All right, I'm gonna allow it. And that would be what you cover in your item number 43. And then what I've looked at right now is the first part of your 44, which is through page 125, line 15. It looks like then there's a second set of facts. So I hadn't looked at that or made a ruling about that yet. So.
I understand.
Okay.
And we can get to that if Your Honor would like to, because number 45, I'm going to withdraw.
Okay.
So that puts us back at the second part of 44.
Okay. All right. So the second part of 44 is on page 126, well, all of 126, and then half of 127. So let me take a look at that real fast, and then is it the same argument as to this also?
Yes, Your Honor.
Okay, let me just take a look at it.
I was also dying at this comment earlier, the buffering signs for Love. And Anthony, Kat, I thought the judgment recessed to lunch. Thank goodness, no. That would have been such a long time. We would have had to start watching another trial.
All right, let me ask you, on page 126, lines 15 through 18, that's, I mean, seems like there might be a separate objection to that little part. Or you had withdrawn the gun part anyway?
I understand, Your Honor. He says
I
that's
mean, if
what
you don't care, I don't
well,
care
he says
either.
that's what I assume, and then he says that's what I heard. The source, I wasn't going.
So, I mean, yeah, if it
we
doesn't-
assume that the source of that's what I heard is Demekion Garlington, it would fall under the same.
Okay, all right, I just wanted to make sure.
I'll just point out at the bottom of 126, I think Investigator Dennis agrees with my view on these statements. That it's people putting their own version of their defense to try to say that they weren't involved. And that's the point I guess I'm trying to make.
So I suspect we'll see that on a slide during your closing argument. All right, yeah, no, my ruling is the same with regard to item 46. So that is in. All right, that takes us to 47, which is on 129. I'm not sure I follow your objection. To 140, to your item number. Oh, wait a minute. Yeah, I'm sorry, 47. Your item number 47, 129, 1 through 14.
46, I thought we were on. But I will withdraw 46.
Okay. Okay, so now to 47. It says speculation about getting rid of guns, but the speculation about getting rid of guns seems to occur sort of after line 14. And your objection was to lines 1 through 14.
I agree, Your Honor, and I am going to withdraw number 47
All right.
as well.
All right, so moving to item 48 on page 140.
I'll withdraw that one.
All right, seems to help you. All right, 141, line 11 through first part of 142. And is there your objection that the questions by the investigator are based on hearsay?
The questions are based on hearsay. You know, he's declaring, Investigator Dennis, I mean, they're inviting responses, I guess, but they're kind of more statements. He's saying that basically my client is involved in a list of shootings, and then he eventually lists them. One of them, I think we already discussed, Lucci's Mama House is the words he uses. We already discussed that I believe we already discussed that was based on what Mr. Zachary told him, which was based on hearsay. He wasn't there. So it's just based on rumors. He's just recapping what Zachary said, and what Zachary said has already been ruled coming out, is my recollection. So Lucci's Mama House, he said he did the bus. We've already established that Mr. Zachary wasn't present at the shooting of the bus. So Mr. Zachary wasn't allowed to talk about, or we're not going to play what Mr. Zachary said regarding who did the shooting. But so I don't know why we would allow Investigator Dennis to repeat it. And then in the murder, I mean, that's a question for the jury here. And I understand that there's certain things that are helpful. Mr. Zachary says, I don't think he did the murder. I would like that to come in, but not in the context of Investigator Dennis listing a bunch of other shootings that are on this indictment that he's concluded my client has done.
So, Judge, the first thing is, it wasn't established that Mr. Zachary wasn't, it was established that he wasn't a part of the physical shooting, but it was also established that he was with other members of YSL at the compound and had knowledge of who pulled out, well, arguably had knowledge of who pulled out with whom.
Right.
So if we're talking about page 141, starting at line 11, from what I'm hearing, there is no objection to no, he does object to it. Okay, I see what he said. Your Honor, Mr. Zachary he's conveying something about Mr. Stillwell, at least his current iteration of events about Mr. Stillwell. He's saying he wasn't in a lot of shootings and stuff.
Right.
Dennis is saying essentially, what, really? And Zachary is reiterating the point. And then Dennis is asking for clarification. When Zachary says it's probably so many shootings, and then later on he says they go all the way back to 2014. He's clarifying information he's giving to Dennis, and he is giving information that we would argue he does have a basis for knowing. I don't have a problem taking out he did the bus, the murder. But the three biggest ones from line 6 through 7, we would argue that those are events or incidents which Mr. Garlington does have information about.
Okay, so I think that 141 lines 11 through 25. Are okay.
Can
I-
I state my specific objection to that?
Yeah.
Okay, so my specific, on 11 to 25, on page 141, what I'm specifically objecting to is when Investigator Dennis says,
Can you pick up your mic? I'm sorry. I know that's kind of
Right.
annoying, but
no, it's fine. He says, right, and he just basically was, from what I've gathered in basically interviewing people and him, again, I don't know when Investigator Dennis, to my information and belief, only spoke to Mr. Stillwell as a victim in a case where a young woman was killed back in 2015. So I don't know where "in him" comes from. He was quiet until it was time for some action, and then it was almost like sick him.
okay.
So he's like basically saying my client is, I mean, a leash pit bull.
Okay. All right. Okay. So then let's strike that question 11 through 14 because it's really not, it kind of interjects. And if you went straight from Zachary talking his answer from 7 to 10 and then pick up with what he continues to say 15 to 17, I mean, that works just as well. So, and you're nodding, Miss Love, you agree?
Yes.
Okay. So 11 through 14 are redacted by agreement on page 141. And then 15 through 25 of that page, I'm going to permit in. And then,
So
yeah,
my issue with 142 is Investigator Dennis says,
yeah, no, I'm getting to
Okay.
that.
Okay,
getting
I'm
to that.
sorry.
And maybe you'll be satisfied.
all right,
I don't know, but whether you are or not, this is my thought at this point is 15 through 25 are in, and then redact on page 142, 1 through 8, and pick up with line 9. And that avoids all of the Dennis saying something about a shooting that okay, does that work for you, Ms. Love? So Ms. Love agrees to that. So, Mr. Shardt, I
That
want to
works.
make sure that, so that, do you have any further commentary with regard after that ruling?
no, Your Honor.
Okay. Let me.
Yeah, evidentiary stuff like this is painful. Painful. Thank you, Patrick.
All right, moving us to page 146.
And yes, I saw people asking, court will address this morning's fireworks after lunch. Maybe, if we get what we need from the state. So we'll try to address it after lunch. Thanks for giving a gifted membership, Susan. That's really nice. Sentinel says, I feel dumber after 3 hours of Love's the testimony or arguing. Put a 1 in the chat if you agree.
Yeah.
And Paige says, jurors are watching the trial on YouTube. I mean, if they open YouTube, it might just pop up in front of them. Like, they might not even want to tune in. But I can imagine it being on someone's For You page just because they live in Fulton County. So thank you, Paige. Thank you, SQL Knowledge, for the $4.99. FFS says DA Love was phoning a friend when she ran out to the hallway. It was crazy. The camera's off for the state, as you guys have noticed, but you could see Love. She's like, one moment, Your Honor. And then she's like, you can see in the Zoom camera, she was like this on her phone, like speed typing to somebody. Russell says, Love is lying and trying to deflect. Thank you so much, Russell.
Okay.
Judge, good morning. Keith Adams on
Good
behalf
morning.
of Mr. Williams. So this is number 50 on Mr. Shartt's checklist.
Yep.
The entirety of this testimony and the context of it is that this is a conversation where Mr. Sprinkle's involved, the detectives are involved, and they're talking to Mr. Zachary about what they believe to be a beef, for lack of a better word, between Mr. Williams and the Quantas Lamar, gentleman
Right.
known as Rich Homie Quan. You know, in short, my objection for this entire segment of the conversation, starting at 146, line 20, going all the way to 149.3, is that it's speculation. You know, if you read through it, Mr. Zachary is opining about the reason that, well, first he's opining that there's a beef, in fact, a beef between Mr. Williams and Mr. Lamar. And he opines as to what the reasons are.
Right.
The detectives are kind of interjecting their own take on what has happened and why they fell out. And if you know, the most telling part is if you look at page 149, towards the end of that, and it really kind of starts at the end of 148, where Mr. Zachary is talking about how Mr. Lamar and Mr. Williams fell out, and Birdman, a Rich Homie, fell out for some reason. I don't know, he says, continues on to page 149, where the investigator asks him because he wouldn't sign. And then Mr. Zachary says, I don't know, I guess. You know, that kind of encapsulates the fact that most of what he's talking about is what he's heard, what may be on the street. And there's no real basis where that speculation is coming from. So I'd ask that all of that be kept out because it's just speculative.
All right. Well, I think that you're right with regard to the very end of 148, top of 149 about, you know, Birdman and Rich Homie having fallen out, and, you know, the reason that might have happened being speculation on the part of Zachary. But that's kind of a separate topic from everything that they're talking about before.
Well, if you look at the entire, even starting back at 146 and going through, there are portions, for example, let's look at 148, the top of 148, line 1, where Mr. Zachary says something to the effect of, and Rich Homie knew that they were shooting, that they had done shot up thug. You know, there's no way that he would know what's in Mr. Lamar's mind, what he knew. There's nothing to indicate the basis of that knowledge. And I will say that Mr. Lamar is a state's witness. He's on the witness list. We've been noticed that he's potentially going to be called. Birdman is on the state's witness list, Mr. Brian Williams.
Right.
We've been noticed that he may potentially be called. And so these are witnesses that if the state intends to prove their theory, I'm going to say it's their theory, that there was this beef between Mr. Williams and Mr. Lamar, and that's relevant in some form or fashion. They have witnesses that they can call to do that.
All right. But, you know, they can corroborate their own witness testimony with something else if they got something else. So that's not an evidentiary objection. That may just be wishful thinking.
Well, yeah, I don't know if they're going to call those witnesses.
I don't either.
And if they want to corroborate, if they call them and they want to corroborate it, then they can say perhaps that Mrs. Zachary knew this in some form or fashion, heard it from those witnesses, but there's no indication that this is anything other than speculation on the part of Mr. Zachary.
All right. Ms. Love.
So, Your Honor, I think some context is necessary here. There have been repeated attempts by Mr. Williams to rebut evidence the state believes has shown that Mr. Lamar and he fell out after Donovan Thomas's murder.
Okay.
Donovan Thomas's father was one of our witnesses, and some of the questions on cross-examination involved Defendant Williams showing photographs of Mr. Lamar and Mr. Williams together at times that were after, I believe after the shooting, if I'm remembering the exhibits correctly. There were Instagram posts and things of that nature, a video of Mr. Lamar and Mr. Williams, a music video of them that they both appeared in.
Yeah.
And that was after specific questions regarding Mr. Lamar's continued association with Mr. Williams after Mr. Thomas's death.
Okay.
When ADA Sprinkle asks in line 18 through 19 of page 146, so what happened? Why weren't they working together anymore? The answer Mr. Zachary gives, his basis for knowing that information, or at least broadly that information, is contained within the statements that he gives just prior to that, when he's talking about having been on tour, being on tour with defendant Williams during this long period of time. So in line 9, when ADA Sprinkle asks, you know about Young Thug getting up on stage in March of 2015, calling Rich Homie Quan, bitch Homie Quan.
Mm-hmm.
And Mr. Zachary
said that
says,
hard.
I was with him, yeah. And then ADA Sprinkle says, you weren't there? And Zachary says, I was with him when
Yeah.
he said that.
Yeah.
So these statements provide a basis for Mr. Zachary's knowledge of whether or not defendant Williams and Mr. Lamar continued to work together.
Okay, and I mean, I notice on page 147, line 19, no, line 20, I mean, Mr. Zachary's saying like, basically, I stay at the same place as Thug does in that apartment building too. So he's got a basis for knowing what he is saying on 146 and 147 and 148. Now, I'm agree that 149 starting at 23 is kind of a different topic in speculation. So I'm going to strike that, and the objection went through 149 line 3. That I'm going to strike, but
And-
just that, the rest of it.
Judge, I just wanted to make one correction regarding line 20 of page 147. So
Yeah.
it wasn't that reference was meant for Mr. Lamar, not, even though it says you have to listen to it.
Uh-huh.
I think it was he, I think.
Oh, okay.
That's correct.
All right. Thank you.
That's correct. What
Appreciate
you're
it.
saying is that Rich Homie Quan
Okay,
stayed in the same
well, it
building.
says we, but I guess that's
It's-
either a typo or a mistranscription. Okay. All right, so then, what
But
is his basis then for knowing all of this?
I was about to say, but even with that, he's
Uh-huh.
describing he's describing later on how much time he spends in the condo. And I believe at one point he even talks about the fact that he went down on one occasion and let somebody in.
Okay.
When asked, how do people get in? They were trying to ask him about a call box, but he's saying, I went and let them in. No. So he spends
Yeah.
and talks about the amount of time he spends, a lot of time with Mr. Williams in that condo. So my argument is that he, throughout the interview, he gives a basis for that knowledge.
Okay, so,
The only thing that I'd follow up with on that, Judge, is that
all right,
that's a different point, right? The fact that he knows Rich Homie Quan, the fact that he knows Jeffrey Williams, the fact that he knows where someone lives, the fact that he went and let someone in does not give him the basis of knowledge of what is in someone's mind or why someone fell out. That's what the conversation
Okay.
is about.
all right. So, Ms. Love, what's your response to that?
So I would argue that his proximity with Mr. Williams and his association and relationship with Mr. Williams, as reflected in the fact that he's always at the condo, even on occasions when Mr. Williams is not there, is the basis for a knowledge of why they don't work together and a basis for his knowledge of what happened.
Okay, and you have evidence that establishes their close relationship at this period in time.
Yes, his
Okay.
words, Mr.
Okay.
Zachary's words throughout the interview
All right.
are
Then-
reflective of there.
Okay. Then I will stand on my prior ruling.
So just to be clear, Judge, what is the court saying will be kept out?
148, line 23 through 149, line 3.
I like that she's particular. Like, we want to rule on blocks 1 through 10, and then she'll say, well, look, I agree on 1 and 2, but I don't agree on 3 through 10. So she's thinking about what's actually on the transcript in front of her rather than, I'll allow it, or we're not going to let that in.
All right, we're at the bottom of 152 now.
And T, yes, Woody, his testimony and the videos that need to come in through his testimony or lack of testimony are critical to what the state needs to prove about Donovan Thomas's murder. And I think that's why we had a Hail Mary late disclosure on Monday. And D. Critchlow, I'm not sure if this is everything we talked about this morning was Brady info that Woody may have given Hilton, but there's speculation that it could be related and that this person that they don't seem to want the defense to look at is already in custody for a different murder. Could he have been involved in one of the murders in this trial that they're saying these co-defendants committed?
All right, Miss Love, why would this be in?
So we have already introduced the evidence of the Dexter Montgomery shooting. That's what this information is, starting at page 152, line 24. We have already introduced evidence that DK or Walter Murphy and Nard or Demise McMullen were the persons who committed the shooting that led to to the victim's head being blown off, half of it. Mr. Zachary's assertions about who did that, I would argue come from his relationship with members of YSL, with Walter Murphy and Demise McMullen or other members of YSL. The portions where there is commentary by Detective Dennis, for instance, the part about page 153, lines 14 through 19, I don't have an objection to.
Right.
As well as lines 20 through 25, I don't have an objection to. Because those are not things that Quindary Zachary is telling Detective Dennis. That's Dennis.
Well, then how about 154, 1 through at least 14, but that's all just the investigators talking
At least 14.
about basically their own investigation.
I don't have any.
Frank? Yeah.
So there's a portion where Mr. Zachary is you see it on the video, he's looking at what they're showing him. So where I don't have any problem with, for instance, 1 through 4, on page 154, I would ask that 5 through 17 be kept in, because that's the portion where he's,
Looking at pictures.
right, either has just looked at pictures, and Dennis is now saying that right there is DK walking
Okay.
with an assault rifle.
All right. So
And-
that's 5 through 8.
Yes, 5 through 8.
Okay.
And as I think I just said it, but if I didn't, 9 through 14 is, I don't have any objection to that coming out.
Okay, but what about the rest of 154, basically? That's the investigators counting bodies. And
Part of-
all Zachary says is basically like, who are you talking about?
So I don't have any problem. I don't have any objection, rather, I'm sorry,
Okay.
to that coming out. And so that's from.
That's basically 153 line 14 through 154 line 4, and then 154 line 9 through 24.
Yes, no objection.
All right, so let's circle back to 152 line 20. Through 153 line 13.
I don't have any objection to 153 lines 1 through 13. So I guess that's all of
All right.
153.
All right, so what about 152 17 to the bottom? Or 20, I'm sorry, 20 to the bottom. Although I think
love
it's
this,
17
Bridgetta.
to the bottom, because I think that's like the lead into.
It is. He's asking about the Dexter Montgomery shooting. I don't remember the exact words at 18, but it is.
Yeah.
I would argue that as to that,
I mean, I don't know, it may be significant to your case that he's even heard about it, so I don't know, you tell me.
well, that's the point that I was making earlier, was that it was his proximity and relationship with the other members of YSL that afford him the knowledge about Nard and DK doing it. And we have shown evidence that Nard and DK did it. So we would
Okay.
object to that part coming.
All right, so 20 through 22 essentially then, or 17 through 22, you're saying that shows, although it doesn't show the basis, who he heard it from, but
It doesn't, but if us, with the
all coupled together would show he heard it from.
other members of
Okay,
YSL.
so, I mean, I think that then, could be relevant to the state's case, and you're offering it there to show he heard about it and that they kept each other connected. So that I will leave in, but what about, what'd you hear about it? 23 and 24 out.
No, 24, he says, you can't see it on here, but on the tape, I can give you the timestamp. He says, they say DK and Nard did it.
Okay. Okay.
I just don't understand how that's not hearsay.
It is hearsay. It's hearsay that is being permitted under the co-conspirator exception.
Who, I would ask the state who, if I'm permitted by the court, who told him this?
So as I understand Miss Love's representations to the court are that fellow members of the gang told him. Is that right, Ms. Love?
But who?
The basis for his having that knowledge would be his proximity and relationship and association with other YSL members. What I said when I first spoke on this is we would not ask for rank hearsay. We would establish a foundation. And if we don't establish a foundation, if we don't establish that it was a member of YSL, like if he's just like the streets talk, then we would not ask who did it or do you hear who did it and then try to impeach him with what he said.
Okay, so essentially, as long as she lays that foundation, that's the basis of the witness's knowledge.
And just moving forward, and because I don't know the answer to this question, but I do know that Mr. DK is Mr. Murphy, Nard is Mr. McMullen. They were arrested and charged for this event. They may have already been arrested by the time they're having this conversation. I don't know the answer to that. But I just think that there's a lot of different ways that Mr. Zachary could come to that conclusion other than a co-conspirator statement. And I just want to be clear, we are putting, if they don't establish a foundation, should this tape be played, the ball is in their court to make sure all this is taken out.
All right, you clear about that? Okay, so make sure that that foundation is laid before, to the extent you end up needing to play this, that you have laid that foundation before you play it.
That is what I understand the purpose of this exercise.
All right, so we're clear then, assuming that foundation, 152, 17 through 24 come in, 153, all of 153 and 154 are out by agreement. And we hadn't kind of picked apart 155 and the
Vice's
top of
raid?
156 yet.
Did you say all of 154 or
Yeah, that seems to be what you ultimately agreed to.
5 through 8?
Oh, right, I'm sorry, with the exception of 5 through 8. Thank you, sorry, you're
Come
right.
on in, Vice's raid. Legal Vices just sent like 300 people over here to hear the torture of Miss Love making her arguments.
All right, so how about 155?
New stream, DA love torture, ADA love torture.
I don't have any objection to them.
All right, 155 is redacted by agreement. And then the top of 156, 1 through 6.
Well, you might feel like you're in a suitcase watching this. Just to warn you. Definitely welcome to the Brady Bunch.
So I don't have an objection to 1 through 6 coming out
Okay.
of page 156.
All right, that's the end of that one then.
Okay.
All right. All right, so our next item is 157, 1 through 22.
I do think we can give some grace on the pauses here because they do have to read the statements they're about to make arguments about.
Our
But-
argument is that it's co-conspirators statements. And I don't know if the court wants to hear from Mr. Shardt first. So if the court does, I'll just wait. But our argument is that we would object to this coming out because Mr. Zachary is asked on the previous page, page 156 at line 7, about his prior statement.
Right.
And as I said earlier, what he's doing within this statement is he's acknowledging that he said it. He's maintaining what he told them in the 2015 interview regarding what two of the defendants on trial now said to him. But he is qualifying it and asserting, maybe they did. Acknowledging they said that they did, but offering as well his opinion. I don't believe they really did it though. And so when Mr. Bailey at line 7 on page 156, what he's asking him that is listed on the transcript as indiscernible is the first time that you talked to Dennis and Gaither, what did you tell them about Shannon? And Mr. Zachary just sort of says, yeah, and Mr. Bailey asks him again. I think a couple of times.
Mm-hmm.
And then at line 17 on page 156, he's talking about that he says, in line 15 and 16, Mr. Bailey says, what did you say they told you? And in response, it's listed as indiscernible, but that's what he's asking. What did you tell investigators that they told you? And in 17 and 18, Mr. Zachary is saying that they shot at Nut, but later on, he told me he didn't do it though. So we argue that one, there's a reason we would want to play that part and into page 157, because now everybody sort of knows that there's a statement and people are talking, people are telling on members of YSL. There's communication in jail calls and in other places reflecting members of YSL sort of incredulity, they're, like dismayed at the fact that various people are telling.
Mm-hmm.
I think at some point there's a definite call that Lil D, and that's when Darius Zachary is called Lil D. Demekion Darlington is also called Lil D, but there is a jail call where they say Lil D told or Lil D was telling. And Mr. Zachary, now being aware that people know he gave that August 2015 statement, is trying to come up, pull back some of it. So we want to play it to show evidence of the enterprise itself, how it operates, what happens when people tell, and how people react. All of that, we argue that it's relevant evidence and not just hearsay.
Okay.
Well, that is a way to bootstrap hearsay, to say we want to play the hearsay to show the way people react to someone saying the hearsay. But my objection is 157 line 1 to 22. And I'll just say, Ms. Love just keeps saying, Quindarius Zachary is saying what they say, or they said. On 157 line 7, in my notes, Quindarius Zachary it says no, and then indiscernible. What indiscernible is Demekion says. Demekion says that they were all in the car. They were all in the car. In what car? In they rental car. is what it says on the tape. So he's repeating what Demekion Garlington told him in the jail while he's trying to assert his innocence. And Demekion is putting himself out as being dropped off outside the car and putting Demekion, and then eventually putting Shannon, Mr. Kendricks, Mr. McMullen, and Mr. Cobb in the car. So it goes back to the same argument that I'm making, and I know Your Honor hasn't necessarily agreed with me in the past, but I still have to make the argument that these were statements that Demekion Garlington is strategically giving to Mr. Zachary, not to further any conspiracy, but to get out of jail. And he's trying to put his narrative out there, and that falls under, we've provided the cases to the court previously, Stafford, Wilkins, and there's two others, but it's spilling the beans, and there's one of those cases that I've given specifically that had to do with shifting blame. And he's shifting blame, and that's just does not fall, and my argument is that does not fall under 801D to E.
Your
Thank
Honor, my interpretation of page 157, at least lines 1. My interpretation of it is that they are talking about up to a point at the very least, something that Shannon said. I don't disagree that it bleeds into comments about Demekion Garlington, and I'd ask for the court with respect to the finer points to give me 1 second. So in the 2015 interview, Mr. Zachary tells police, and we'll get to that when we address those redactions. He tells the police that he doesn't know what in the world made them do that. And he was asked by Detective Gaither, made what do that? And Mr. Zachary says, people who killed him, Shannon, Yak, Nard. And then Detective Gaither says, Nard in jail for kidnapping. Mr. Zachary says, yeah, and doo-wop. He's then asked what doo-wop looks like. Then Detective Gaither says, how do you know this? Mr. Zachary says, because they told me. Detective Gaither says, who told you? In August 2015, Quindarius Zachary says, Shannon and Yak told me. Detective Gaither says, why did they tell you that? Mr. Zachary says, we were at the house talking about it. Detective Gaither says, which house? Mr. Zachary says, Thug's house. Question, new or old? Mr. Zachary says, the old one, his condo down there. Detective Gaither says, exactly what did they say? And then from there.
My God, it's literally buffering. Stop it. Oh, love.
Say.
She cursed me.
And then from there, a recitation of events that he says he got from Shannon and Yak. So the argument that this information came from Demekion Garlington, who was just trying to clear his own name, is belied, I think, by the information that the court will hear Mr. Zachary give in 2015.
Okay.
In your honor, I don't dispute that Mr. Zachary has said that Mr. Stillwell, that he's claimed that Mr. Stillwell and Mr. Kendricks made statements to him. That's not the point. And when we deal with those statements we can address, we'll address those statements in the arguments. But in this particular statement, and we can listen to the tape, my notes say on line 7, Demekian says that they were all in the car. They were all in the car. This information that we're dealing with right now, the source out of Mr. Zachary's own mouth is the source is Demekian. And that's what's on the table before us right now.
All right, so if we go back to 156, line 7, which is where this objection, I think, begins. No, it doesn't. But no, it doesn't. But if we go back there, at that point, they're talking about what Zachary told them way back in 2015, the source of which was the conversations amongst people at Mr. Williams' old Midtown condo. So close in time to the murder. And so y'all seem to know what a lot of the indiscernibles say. So on 156 at around line 16, I mean, they're talking about, what did you tell them about Shannon? And then line 17, what's line 16 say? Do we know?
I'll tell you.
I can pull that up.
I'll tell you right now. On line 15 to 16, Charlie Bailey says in that interview, what did you say Shannon said?
Okay.
So that clarifies that portion.
Okay.
Need that.
So,
And Your Honor, it's only 1 minute from line 13 on page 1, or line 14 on page 156 to line 8 on page 157. So there are short intervals between them if there is a point at which we can play anything that helps clarify things.
And I understand that, but in that short interval, he switches to say Demekian says that it was all in the car. So I mean, he switches the declarant, and that doesn't take much time to do, and that's what he did in this conversation.
Because I don't,
so I don't know who is, I know I see that it says Demekian told Shannon, but then it says Shannon didn't do it. He's saying they was in the car though. That he could be, who knows?
Yeah,
That could be either of them.
I can't speak to that.
He said they was in the car when it happened, but they didn't see nothing. So I don't know what the basis for that.
Well, and that's Investigator Underwood talking at that point. So I don't know. Investigator Underwood's statement doesn't make a lot of sense in that context to me now, but I believe that the transcript is accurate.
So in 2015, during this first statement, does Zachary say that Shannon Stillwell maintained that he was in the car?
he says, he says that, but in a more assertive.
Okay. And then does he also at that point before say that Garlington was in the car, at least in the car?
You're talking about the 2005, the early 2000,
Yeah.
the earlier statement?
Mm-hmm.
He says,
Not,
go ahead. I'm sorry.
not in the car that,
In either of the two cars.
so in a car, but not the car that is doing the kill,
Right.
shooting.
Okay. But this, whether it was Garlington or Shannon saying that they were in the car, but not that car. In 2015, when Zachary talked to law enforcement, did he at that point as well say that both Shannon and Garlington were in the car, one of the two cars?
Yes.
Okay, so then I don't think it really matters who the he is there. Because he's already said that. So that can't be based only on now Garlington saying some other story to get out of it. So I think 156 lines, well, y'all don't have an issue with that, but 157, 1 through 3 seems fine because he has a basis for knowing that is from before. And when we get down to 7, are you saying that now that answer that I think Demekion said that they was all in the car?
Correct. He said, no, the quote that I have in my notes from this statement is, no, Demekion says that they was all in the car. They was all in the car. And then investigator Underwood says, in what car? When Darius Zachary says, in they car, they rental car.
Right.
And then Underwood says, when it happened, well, and the rest is as described in the transcript.
Okay. I mean, none of that is Demekion saying anything that really is like, I was in no way involved in this.
Well, my understanding of what Demekion's saying, and just to
Is
add
that
context.
I was involved with all of it up until the point when conveniently I got dropped off.
Right.
Right.
My understanding of what the story is Demekion's in the car. They're riding down the street. He gets dropped off. People switch cars.
Mhm.
And then he says who was in the car ultimately when it pulled off. And he wasn't in the car at that point.
And Your Honor, the information that Mr. Zachary shares in 2015, he says that he got that night or the next day. So he got before Mr. Garlington was ever arrested. So to the extent that the argument is, well, at least partially what I understand it to be regarding Mr. Garlington, the information that's being shared is information that Mr. Zachary previously asserted came from his conversations with defendants Kendrick and Stillwell.
Okay. I'm going to allow 156 line 7 through 157 line 22.
Thank you,
And
Tina.
can I just ask one thing?
Sure.
I don't want to disagree with Miss Love about her characterization of what Zachary says Garlington said to him before, because quite honestly, I don't remember until we go over the transcript. But if in fact that transcript from 2015, earlier 2015, does not reveal that Garlington gave him information at that time, could we revisit?
Sure.
And I was saying, and if I said, I said Kendrick and Stillwell.
Yeah.
Well, right, we know, but Kendrick and Stillwell, we know that, but it seems to me that Miss Love is asserting that in 2015, Zachary is claiming that Garlington had already given him information prior to Garlington being arrested. And I don't know that to be true.
I don't know that that's what she was saying. Because what I had asked her was did he already have a basis for knowing all of that fact?
He didn't. Mr. Stillwell and Mr. Kendricks allegedly gave Mr. Zachary information.
Mm-hmm.
I'm not going to agree that all of this information is included in that information. My stance, my belief is that this is information that was given by Mr. Garlington while he was incarcerated, which affects the analysis of the co-conspirator statement. And I don't believe it. And I understood the state's, and if that's not the state's argument, I understood the state's argument as, well, Zachary in his earlier statement
Right.
had said that Garlington had already given him the information. And I don't know that to be true.
I don't think that's what she said, actually. But what I'm saying is, I mean, Mr. Garlington may think that if he puts a story out there that he was with all of the people alleged to have committed this crime as parties to a crime up until, 2 minutes beforehand, hops out and then gets picked up 2 minutes later, that gets him off the hook. I mean, that's wishful thinking, although apparently, I don't know. Anyway, I think he is still inculpating himself to me. So I guess I'm saying I understand, but reject your argument that this is, even if said during the jail stage, is at a point where it is no longer in furtherance of the conspiracy. I'm also saying it appears that Zachary had all of this information the first time around also.
Okay, that's the part I'm not
Okay.
necessarily.
And that may not be true, but if that changes, you can let me know. But my other ruling still is, adverse to your position.
Yeah, that's a
Understood.
plus
All
one
right.
for the state for sure.
But it legitimately, we needed to get it cleared up. So, all right. So 158 lines 12 through 21. Actually, lunch is here. So why don't we break for lunch until, let's say 1:20.
All right. So you know the drill. We'll make sure the court doesn't actually come back. I have been waiting. I've watched so many defendants pop up on the screen with Cedric Simpson's court. So we can get an update on the man, Corey Harris, that was driving with a suspended license. Then said there was a clerical error, but then it turns out he never had a license at all. He has a pretrial conference hearing this morning. He got his permit last month. And, a lot of us have been rooting that he gets it together and gets us behind him. But still no update. I was going to play it during lunch. But yeah, so a couple significant wins for the state on statements that, to me, if I was a juror, I'd tune in and I would listen to. Sometimes we didn't get to hear what all the statements were if we didn't hear it really through. I don't know. Sometimes I don't understand the statement if it's Love that's making the argument, because she just reasons why it should come in. But the defense usually is the one, when they counter argue, they give the context to the actual statement. So some of the things that you said, I'm going to allow that to come in, or I'll allow it if you lay foundation. I didn't actually get the full context, the full statement. But other times she said, no, we don't really need that. We can strike that. Or, yeah, we can let this in partially, but not all of the lines that you want in. But I think as far as if we tilt the scale, this is definitely a bit more win for the state. But at the same time, if we zoom back out and these same questions were on the table previously in the trial, I think the scale would have leaned like this to the state. So it's kind of a win that it's only leaning like this. If that makes sense. And then so much to catch up on. Thank you so much for all the support today. Right here, Tina had just sent this. Maybe that's how Love spies on people, through her printer. All of the tracking and such. Referencing what was said in the June 7th transcript. Now, if you're joining late and you didn't watch the beginning and you started with us live, earlier in this chat I pulled up a X post, a reply from an attorney in Fulton County, Siri Shada Jimenez, where he said that Love accused him of spying on her using a printer. So we talked about that earlier in the stream, and that's what Tina's referencing. Just crazy to think about. But it kind of makes you wonder where Love gets her ideas and theories and the information she uses to make her case. Because it sounds a little bit like projection. So thank you, Tina. Vacation Granny became a member. Heck yeah, thank you so much. And then yeah, I had seen this earlier. I tried typing in the chat. Guys, to gift memberships, which is really sweet of you to do, if you click the money symbol next to where you chat, there should be an option to gift memberships. So that would be the best place to look. To become a member, either click that same $ symbol, or if you're on an Apple device. And I didn't know that it worked like this until Moses Dupree had sent in a how-to. Because I guess on Apple devices it's different. You have to go out to look next to the video name and click this area where there's like a button here that says See Perks. And that's how you can actually become a member on an Apple device. So that's kind of, you know, I guess a lag on YouTube's development there. They're still on the struggle bus. Which is weird, because usually Apple gets the faster updates, but who knows. But that's so sweet of you, Yayas. I appreciate you. And then Charlotte became a member. Thank you so much. Deanne, good to see you. I always love your comments, especially I catch a lot of your comments, I think, in the static comments, not in the chat all the time. Always love your insights. So thanks for the kind super chat. Thanks for being awesome, Kat. Tabiz TV, I had dropped, if you guys want to grab his link while I go through these. Tabiz TV seems to be taking a day off from covering the YSL trial himself. He has a great channel where he's also done a lot of videos talking about concepts like prosecutorial misconduct. So great stuff, especially if you're looking to binge something other than just a trial stream, which he's also covering when he's not hanging out with us. But he's also doing great like on-demand videos that talk about different concepts with law and trials. So shout out to Tabiz TV. He says, back from a meeting, heard Love's voice, and put a shot whiskey in my coffee. I mean, you know, 5 o'clock somewhere or whatever. It's got to be 5 o'clock for somebody in this chat, so we'll just co-opt their time zone. Hilton's absence is really exposing the picnic table cover. I think she was really rough and struggling this morning. I think she's picked it up a bit with some of these statements. Maybe she was more prepared for the ones she's answered recently. Or maybe when she started doing this evidentiary stuff, she may have really been frazzled from everything this morning relating to that late disclosure. I don't know which one it was, but she's tightened it up a bit now that we're at the lunch hour. So thank you so much for supporting everything that we're doing here, Tabiz. And then Amber says, ATL, be honest, is gun crimes down now that 28 of YSL is locked up? I think statistically, crime rates of like violent crimes involving weapons and homicides has dropped. But there's a small problem here. Because Fani Willis tried to say that these co-indictees were responsible for, I think her figure was 75 to 80% of these crimes. And the drop doesn't come close to meeting what she attributed to YSL. So you are right. There's an extra layer here that has nothing to do with your comment. It's just an outside and a side comment where we overclaimed and we overshot how valuable this RICO prosecution would be, even if we get full convictions against these co-defendants. So great food for thought there. Love the water gun emoji. And I wanted to say thank you to Joel again. I didn't get a real chance to address, you sent a $50 super chat. That's so nice of you. And you had said that to think after all this BS, Fani will get reelected. Unbelievable. And I think that goes hand in hand with what we just talked about. Claiming that this YSL, this RICO prosecution, is going to be the game changer for violent crimes, gun crimes in Fulton County. And I'm not sure if we're living up to that campaign promise. So thank you so much again. Hood Info says, hearing Love talk is like hearing a 6-year-old who just got in trouble. She doesn't know anything. Her buffering is funny. She goes by he say, she say. And sometimes it has to be what comes in, right? Just because something is he say, she say doesn't mean it can't come in. But they have to argue for the exceptions. And based on the judge's ruling, she has gotten some wins there, arguing that there is an exception through something being a co-conspirator statement. Where I heard about this, the reason I know about this is because somebody else that's part of this gang activity told me, and I'm the one now telling it to a detective. And Judge Whitaker has agreed with some of that stuff coming in. A lot of it with the condition that foundation still needs to be laid. But other times you're absolutely right. It's almost like her theory of the case is he say, she say. Like, too much of this, like, cool, the statements, if they're backing up something else we had other evidence of, I'd have a lot more confidence in it. But part of me is wondering, not just can they prove their case, but could somebody else have been the person that did these main crimes, these murders? And the state just didn't look in that direction, especially since they were focused on following the lead that they may have gotten from either a snitch or somebody that was trying to divert attention away from one direction to another. So I don't know personally where I stand on actual guilt for all of the co-defendants. I have doubts that all of them are guilty. I'm not convinced that the state will meet their burden. And I welcome everybody in the chat to, you guys aren't the state, right? You guys are not the ones tasked with having to prove your opinion beyond a reasonable doubt. We should be able to talk about different things. We could learn something from each other. But I will never give the state the benefit of the doubt to say below their burden is satisfactory. They've got to do their job. Thank you so much for the super chat. Pierre says, if these breaks were because of the defense, it would be a different story. So yeah, if you missed this morning, we had quite a lengthy recess. I think it was like 35 minutes or so, because the state was scrambling to figure out, do we have an affidavit that was used to back up the search warrant for the thing that we disclosed late? Oh, what date could have been on there? Just two basic questions. And Atkins went out of the room. Love was like, I'm just going to sit here during the recess. She ends up going outside. And it just seemed like a waste of time. They come back in and the judge is like, I guess we'll revisit this after lunch. So, but if it was the defense, and especially if it was still Judge Glanville and it was the defense, oh, we would have heard some yelling in that courtroom. So I do think the judge gave the state grace there. And I can't wait to see what we come back to after lunch. Thank you so much, Pierre. And then earlier, FFS was saying, what Whitaker is saying, what else you hiding, V? And did anybody else catch Love when she was reading that statement? She said the hard B. It seemed like she was so excited to curse out loud in court. Because she censored when she was reading the Melnick email that was about her. Then it was F you. When she's reading someone else's statement that has nothing to do with her, she seemed excited to say BITCH as loud as she could. It was louder than any other word she read in that statement. But yeah, so Whitaker's definitely looking to see what else Love may not have disclosed. Dave911 says, thank you so much for providing the best and most informative coverage of this circus. I've learned so much from you, and I have to give my flowers to other places in my downtime, which when I'm covering documents, it's like an hour, maybe 2 hours. I have more time to be in other chats. So this week I feel like I'm missing being in the chat room for other channels because this is like 9 hours a day. But I have to give my flowers to the others out there. You guys know I love AV. I tune into TLA, especially I love when AV is also co-hosting over there. I've recently gotten to learn about Dear Woke Christian and T-Biz TV. I've known Nick Starro for a long time. He's traveling today, so he's going to do a recap tonight. And maybe I'm going to try to host his panel. He does a panel show that's been focused on YSL every Friday. I'm going to try to host it for him if his service in the hotel sucks. And he'll syndicate it to his channel, but, we can bring all the guests on. But I've got to give my flowers to everybody else out here. And of course, the Honorable Thugger Daily over on X. Because without that, it would have been hard to find all the information. And I think it's just such a powerful testament to the power of crowdsourcing. In the chat, you guys are part of it too. I mean, right on stream, I think we pulled it up earlier. Luis had tagged an article about DeMarco Boyer, who we were talking about all morning. He's the one with the cell location data and this telephone number that there may be stuff that should have been disclosed to the defense that wasn't disclosed and still hasn't been disclosed. But on Monday night, they just dropped some chart mapping of cell phone location data over on the defense. So Luis pulled that up right in the middle of the stream for us to look at. So I think it's just a really, really cool thing. I appreciate the support and the kind words to me. Thank you so much. D. Motley says, Fani said that, speaking of cell phone, Fani said that cell phone data doesn't work in her trial, but it works for everyone else. And we recently saw something similar with the Karen Reed trial. I don't know how many people in the chat here followed the Karen Reed trial, but the prosecutor there and the defense, they went back and forth because suddenly we want to rely on cell phone data when it shows that the defendant may have been doing something. But when it shows that the defendant may have already left the scene and not have been present, when it's estimated that the victim was struck by the vehicle at the center of all of this, suddenly we're not sure if that's reliable, and we're going to call our own experts to rebut it. We have experts that say something was searched, a Google search happened at 2 in the morning. Well, we're going to call an expert to say that that doesn't mean that it was searched for at 2 in the morning. But we've seen other trials where prosecutors rely on Google search data as inculpatory evidence. Well, you know, it's kind of a weird thing to make a Google search of how long to die in the cold, is one example. There's been other cases where people who are the ones charged with the murder, they're looking up things like, can blood be detected after you bleach a floor? Like, just Google searches that come into trial that, you know, they look really suspect. So it's always interesting to hear a prosecutor say something doesn't work, because the next time something in that same district needs to use that data to prove their case against defendants, it just seems hypocritical. It seems like a double standard. So thank you so much for the super chat, D. Motley. Black Butterfly, good to see you. Wouldn't it be hilarious if that is a straw that breaks the camel's back? And had they severed Nichols, this would be moot. That would be crazy. That's a great point. Because the cell phone location data is really with the murder of Drinks, the Drinks murder, is really where we see Nichols have some relevance tied in here. And I know it seems like it was mentioned that, my recall's getting scrambled. I got a buffer for a minute here. But I think maybe Yak and possibly Shannon Stillwell are tied into this scene on Water Street, the Water Street murder of Drinks. So it seems like maybe it would still be relevant for them, but if they're saying that Nichols is the one that is identified in this one wiretapped call, that's the only person named, really might be irrelevant to Shannon Stillwell and Yak, if those are the two that were mentioned in this actual instant case. So that would be hilarious. Like, Bruce just keeps asking, like, can you sever my client, please? And then nope. Thank you so much, Black Butterfly. And then Canadian Crispy Bacon. Keep hearing Judge is mad, but not hearing mistrial. I had looked at this while we were in the middle of the stream, but I don't know. I think the judge has some important decision-making to do. Remember, she's taking the day off Friday. We do not have court on Friday. So we'll have a court date tomorrow. And she wants to have Woody present on Monday, ready to go. She wants the jury to be there on Monday. But she's got Friday, Saturday, and Sunday to think long and hard about certain things. And I don't know if I can predict where she's going to go. And Heart of Inspiration, good to see you. I don't know how many more chances the state is going to get. Hashtag mistrial. Yeah, and I think they're getting their wins today. I think she's being fair with the rulings, but you know, I don't know. I think she's said some stern things to them, but the words aren't enough forever. You can't just keep, hey, don't do that, and then just letting them keep doing it. So thank you so much, Heart of Inspiration. Steven wants to be a fly on a wall during Love's next job review. Well, it's funny you mentioned that because shout out to, I'm going to put the link in the chat, but shout out to the Hood Lawyer. The Hood Lawyer saw this conference schedule for this thing that's going on in Boston. YSL District Attorney Willis is at a conference teaching a workshop called Lyrics in Limine, Evidential Use of Speech or Protected by the First Amendment question. Prosecutors weighing the pros and cons of using rhyme in crime. So this is what Fani Willis is going to be speaking on today at 3 p.m. at this Boston conference. And then Will Bowman says, what are the chances that the Fani Willis prosecution team eventually gets tried for RICO themselves? Wouldn't that be ironic? I mean, I think they're in the clear. You know, I do think that there's a sense of some degree of immunity for prosecutorial behavior. I think it takes a long time and it has to reach a high bar, and people have to be willing to go the mile to hold a prosecutor accountable. I mean, it's really interesting to think that Fulton County might be conspiring within and amongst themselves to find leads and look for big cases that they can get these major high-profile convictions, even if the merits to get them there aren't actually there. I don't think it's far-fetched to consider that possibility. But for someone to actually prove that that happened, for it to actually be happening, for it to be proven that it's happening, and then for there to actually be repercussions is kind of like, if it happens, it'd be years down the road anyway. So I hear you, and it's like kind of sad to think that there's enough here that we could say that's a possibility. And then Annie Bailey Brown says, this is a cartoon now, mistrial now, Mama Smurf. Yeah, everybody wants a mistrial. And again, what do you guys think about the argument for a mistrial versus disqualifying the prosecutors, but continuing? Living My Truth, thank you so much for the super chat. Jenna, this is so nice. I love seeing your channel grow. You're the best. I appreciate you. And I love you have a sleeping dog in your picture. It's very cute. Positive masculinity. When your incompetency exposes your corruption, is Woody the most honest person in the court? You need to play the owl and the lollipop. Yeah, let's go find the owl and the lollipop. Did I retweet that? So thank you so much, Positive Masculinity. And this owl and the lollipop is an animation made by none other than Flesh of the Gods. So if you give me a second, I will go find his channel link and drop that as well. But this animation was great, and if you haven't seen it, you should probably see it. What day was that? My timeline is so boggled. So I'm going to keep looking for that. We're going to pull that up. Bridgetta, I love this. I have PTSD. Pretty tired of stupid DAs. Arminos, thank you so much. Good to see you. There's probably a line at the state HR department with lawyers handing their 2 weeks notice. Like, yeah, we don't want to do this anymore. We don't want to be associated with this mess. That to this creation. Thanks for becoming a member. She Loves Fantasy says, Woody is the real Kaiser Soze. He probably did it all. And he's got the immunity deal. Got the immunity deal. And I do think defense is going to hammer him across about it. If it gets to that point, as Judge Whitaker likes to say. And yeah, you guys, I think we're adopting, so Ken Thompson, thank you. I think we're adopting the Brady Bunch name. That's what we just call the two tables that the state sits at. Dustin Davis says, Kat, I think there's a way to incorporate the Brady Bunch into the thumbnail using all the main characters from Trials Faces instead. I might, if we do this Friday panel show, maybe make the thumbnail like that, like the Brady Bunch. That'd be great. And then Archie Main says, Judge is trying to box Love in. So this was back at 10. So this was still during some of that conversation about when did this affidavit happen? When did you find out about this? When was Agent Berni looking into this? Versus when you actually disclosed anything to the defense. So I agree. And I like to watch the judge box people in. Stephen T. Satchel says, wiretap of a cell phone means Stingray or something like it. So Stingray a program? Stingray. Okay, yeah, Stingray, a new frontier in police surveillance. So definitely a program. Yeah, and that makes sense because it's not literally tapping into the wire when you're dealing with cell phone. It's like we call Band-Aids Band-Aids, but they're really bandages, and Band-Aid's the brand name. Or Google to mean searching on any browser. Thank you so much, Stephen. G. Lander says, we need that attorney who went viral for Zoom court hearing with a cat filter. Oh my god, I didn't see that. So someone was just wearing, like, I don't know, were they on a cell phone or something? Like, does Zoom have face filters, lenses? So an attorney had the cat filter on accidentally. We need them to show up today and assure Judge Whitaker they are not a cat. There is also, what's that guy's name? I know his screen name is Roaring Kitty and Deep Effin' Value. He was making videos about GameStop, GME, when the stock was like surging through the roof. And the SEC had a hearing about it. And he gets on to make his statement, and he's like, I'm not giving financial advice, I'm not a cat. Because like the meme about him was that, you know, the internet's always talking about cats. So they always joke that he was actually a cat. Well, it's always funny when goofy things pop into courtroom moments like that. Will Bowman says Fonnie Willis's office will eventually be tried on some RICO. There you go. See, a lot of talk about Fonnie and RICO, but it's being about them and not these actual RICO cases happening. And yeah, I still think it's so questionable, this Georgia RICO statute that is being used the way it's being used. I just don't think it's right. It just seems like the whole theory is based on he said, she said, and I get that snitches are a big part of RICO. Like, the mob, the mafia. You know, that evidence is important. But it's different when that's like the only evidence you have and you're missing the reports on the things that, you know, could involve forensics or details from the actual scene of the crime. We've got a lot of hard evidence that could be present, in my opinion, that's missing. Or we're hearing about it through a detective's recollection, and they don't actually have their reports. And it just doesn't seem like a fair way to pursue something in this way. So I appreciate you, Will. And then Garrett says Steele's point earlier was huge. Oh, so I think, are we going back to the intentional versus we didn't know, we just had a realization. It was inadvertent. So Garrett says Steele's point earlier was huge. Love knew Boyer saw Nutt's murder. She hid both this witness, existed and existence and cell location data and analysis for months. # Brady in all caps. I agree. So I'm missing details on this, but I see why you can't just argue that because the state thinks it would be inculpatory, that they shouldn't have to disclose it to the defense. The defense should know if something is out there that's inculpatory because they should be able to prepare a defense against it. They have the right to do that. But the interpretation's also a problem. Why would Love not want to bring in evidence? She said she didn't plan on bringing this stuff in anyway when Whitaker asked. And that's exactly, Whitaker was like, all right, well, they say they don't plan to use it, and it was for a different thing. It wasn't for the Donovan Thomas. It was for the Drinks murder. And then she was like, wait, pause. Strike that. She's like, forget I said that. Because she realizes it shouldn't make a difference either way. Just because the state is saying they don't want to bring something in doesn't mean it couldn't be helpful and might be inculpatory to the defendants. It could be exculpatory. Something hidden in here could go to proving the innocence of one or more co-defendants. Or at the very least, you know, possibly bringing a credibility issue on one of the other witnesses that's supposed to testify against the defendants. So great point here. Thank you so much, Garrett. Robert gifting memberships. Thank you so much, Robert. Everyone in the chat, show Robert some love. You can say RB for short. And you guys know I love the gifted memberships. And Jess also became a member. Starletha became a member. So thank you so much. So glad to see you guys with green names. Natasha Vega says, I think the state is purposely dropping bits and pieces of Brady, hoping something will stick with this judge to get a mistrial. As in, they're goading it. That's interesting, too. They know it's over. They want to say there was some mistake. In this case, Love, even though it's her team, it seems like she wants to blame it on either a legal assistant in her office or on Agent Berni. Right? So if Love was doing this, she'd be able to say she wasn't personally responsible. Which I seem to think Love cares a lot about that. Like, that's like her number one priority, is not looking at fault for something that goes wrong. This is a good point. What do you guys think about the idea that the state is goading for a mistrial? They want to make a mistrial necessary. So they can lose a case because APD didn't turn something over, rather than because we didn't have our act together. Great food for thought there. K1 says, we will have gone through a whole rat beef and got a new present before this trial's done. My kids will be in college. YSL Nicole, I mean, it's an attorney. She's not really YSL Nicole. It's a meme name. But she had a baby. She had a baby. She was representing one of the co-defendants that's not enjoined in this specific trial. But she had a baby. 9 months went by. Got pregnant and birthed a baby. Like, that's crazy to think about. And Rachel Kaufman, who's an attorney in Fulton County, she's on Inside the Law a lot. She was guesting on, I think Nick Starrow's panel. And I had found out that she was pregnant, and she said she was due sometime in spring. And I was like, okay, you're going to be our trial countdown. Whitaker's predicting this timeline she wants to end. So are you going to have your baby before this trial ends? You going to have it after? She's our new time meter. Thank you so much, K1. And then Steven Satchel, I think we changed the name, so we're just going by Satchel now. I'll re-ingrain that. So Stingray is a cell site simulator to do man-in-the-middle capture. Cool, can we watch something on that during lunch? Let's see. I see articles, but if I can find a video, that'd be cool. Okay, we're gonna watch a video. Hope I don't get stricken for it.
Here, or at one of these. It doesn't matter. Technically, a cell site simulator. First developed for military use, it's made its way into local law enforcement. It can track a person down to the room they're in if they have their cell phone on them.
The room. And if they have their cell phone on them.
Stingrays turn these into homing devices, and that's just the beginning.
These are tracking devices. This is emitting a signal. This is GPS.
Mike Mino with the North Carolina branch of the ACLU has been watching the spread of stingrays for years.
It's my understanding that the software that a lot of these devices use is capable of capturing things like your text messages, the numbers you're calling and receiving calls from. We know for sure they're getting people's location.
Here's how it works.
I don't see captions, you guys. Sorry.
Cell phones are always trying to connect to nearby cell towers. A stingray acts like a cell tower decoy. In what's called a man-in-the-middle attack, it tricks cell phones into thinking it's the nearest cell tower, phones connect to the stingray, and police can access a range of personal information. But they don't just get intel on one phone. Every phone nearby is forced to divert to the stingray. Calls are passed on to a real cell tower. Data scooped up stays with police.
When you ask them why they're using it, they'll say, well, we're targeting certain individuals, but the nature of the technology is so expansive that you cannot use this without countless innocent people having their data captured as well.
Cool, so a broader problem of, invasion of privacy, surveillance for individual citizens, where in order to track one person that you may be looking at for a crime, that tracking will involve you gathering data on people that aren't even involved in your search, your investigation. So no wonder the ACLU is on this. Like, this is a violation in general of citizens' rights to privacy, and individuals' rights. I'm sure they have a lot to say about how it's used in prosecutions as well. So, and yeah, it's just gathering all the time. And then maybe they need a warrant to actually go and get the report that actually exists. So, and then, yeah, so J. Capoti says, there was a problem in the Melly case with phone records, especially phones that are all under a business plan. They said that since all the phones are all tracked as one, you couldn't tell what number. So, like, what device tied to which number was somewhere. And then we'll do that brief. I feel like ABC is going to try to strike me if I keep going. But I'm going to paste the link to this if you want to... Or actually, let me pull this up and get you a better link. That was like through Google search. Here's the Stingray. More on Stingray. So now, thank you for the opportunity to have us look that up, because like as soon as I got the visual, I'm like, oh, I get what Stingray is actually doing now. It's not just something that parses data the way, you know, when you get a Cellbrite extraction from a phone, it's pulling activity and it's pulling messages. Then that's a little bit different than tracking location. But again, we're not dealing with extractions from a device. We're dealing with location data. And maybe, Satchel, maybe you'll know. This seems a little bit different than some of the triangulation. Is this the same as just triangulation tracking? Like, here, we think that your phone was at this location based on pings off 3 different towers at one time. Because they said that they can tell that your cell phone is in your home. And that seems pretty accurate. Like, that seems like the GPS accuracy. Like, I don't know if your phone... Guys, do you have your phone, like, if you walk from, like, your bedroom to your kitchen, your phone knows that you've moved? Not just because of your step counter, but it knows that you've, like, actually, spatially walked a couple feet in distance. So, very interesting stuff. Kind of scary to think about. Kind of scary to think about. And then Chloe Albert's revenge. So shout out to the Karen Reed trial watchers. It seems a lot of prosecutors recently aren't interested in forensics because it will make it harder to tweak their case to fit the theory. And I mean, when you think about it, you've got things like the Innocence Project that are out here. The cases that the Innocence Project tends to take are cases that have DNA evidence. And that DNA evidence could exonerate somebody. It could prove that they weren't the one that actually did it, even though they've been convicted. And this goes right to that point. Prosecutors sometimes don't want to look at the forensics. It's more difficult to tweak their case to fit their theory of what actually happened. And I think the Karen Reed trial is a great example, because based on new affidavits filed by the jurors, there are some jurors that came forward and said, look, we were all unanimous on the top charge. None of us believed that Karen Reed was proven guilty of murder. But we did have, some of us were torn, there was a split on whether or not it could have been manslaughter. And, you know, part of that could have been the state could have adjusted their theory of the case. They could have decided not to overcharge her. They wanted to keep out evidence and experts that were from the feds. It wasn't the defense that hired a bunch of expert witnesses. These expert witnesses did their reports, their investigation, their accident recreations through their line of work for the feds. And the defense happened to just subpoena that information to bring it forward. They didn't go seek someone that would help them. Yeah, I agree with your theory. The feds did that independently, and the defense said, we want to present that to the jury. And the prosecutors didn't want this type of forensic work to come in. And it's just so insane to me. And I did follow the Karen Reed trial pretty closely. Feel like Chloe Albert's revenge, you've probably followed it from the start, because that's the Chloe dog that went missing. Nobody knows what happened to Chloe. The dog that may have scratched up John O'Keefe's arm while somebody may have been fighting him. That was a crazy case too. And again, that ended in mistrial because of a hung jury. And the prosecutors are determined. They say they plan to retry Karen Reed. So crazy, crazy stuff. And then while we're still here on the same topic, Satchel says, no, triangulation tracking is at the cell company. Stingray is more invasive. Okay, that makes sense. So the triangulation would that's why the devices look different. because triangulation would be the actual cell towers that are owned and or rented by the different companies, because, you know, they all rent each other out. But Stingray, those devices were different and separate from that. Yeah, and I bet it's better technology too, because I think a corporation might want to cut corners and not invest too much money on infrastructure. But when it comes to the invasion of privacy, maybe we want to invest in the best. So that's another crazy thing to think about. Sean Farmer says, so why go over all redactions and not rule on mistrial motions that she claimed she would rule this past week? Her words. So there were additional filings. Shardt made a new filing on Friday. And Brian Steele filed a new motion for the disqualification of the prosecutors yesterday. And the state does get time to respond. So now that's kind of all, it did expand the timeline. So the state does have a right to respond before, if they wish to. If they don't respond, then it moves on. But she gave them until Friday to respond. So she still, it kind of makes sense why she hasn't ruled on that, because new stuff has come into play and the state has to respond. That will be in writing because we don't have court on Friday. So Friday, if the state's on time, because they don't seem to be on time, we'll have a written response to the outstanding motions for mistrial and motions to disqualify. We'll look at those, and maybe Monday we'll get an actual answer from Whitaker. She did hint that she was very concerned about Brady and very concerned that there's no way to fix the absence of the defense at this ex parte meeting. She said she hadn't determined yet if she legally thinks that the ex parte meeting was a critical stage of the trial. So definitely have to wait and see. I'm excited to see it. I don't know if I'm optimistic, but you know how that goes. Thank you so much, Sean. And then, let's see. Canadian Crispy Bacon says, the judge getting the pick of what the defense was going through the last 9 months. Love needs to get lunch, to get a hairdryer, make sure the ink's dry on that affidavit. Yeah, we're floating that theory in the chat here that maybe the affidavit doesn't exist or they can't find it. Can defense use DA's and Fani's argument against Cellbrite data use? Now, this might be a little bit different because it's actually, it could be different technology. So, did they say it was Cellbrite, the reports? So, I don't know if we know exactly the technology, but that's a problem because that's exactly why it's important for the defense to have access to the affidavit and the search warrants. They would actually know what they could make an argument about. And they weren't provided this. We heard from Shardt today that he still doesn't have the affidavit or search warrant. So, and if all of this happened, there should have been an affidavit and a search warrant, and I don't understand why it wasn't turned over. So, great question. The defense will probably make that argument if it is Cellbrite, but they don't know until they know. And they're, oh wait, so we're saying yes, so maybe they know it was Cellbrite. So I wasn't sure. And then Chloe Albert, Netflix's series Web of Lies has a 2-part Stingray episode. Okay, cool. So I can binge watch something. That's Web of Lies, you guys, on Netflix. That goes all into this Stingray technology. Do you happen to know, Chloe? You don't have to super chat. I'm about to toggle back over to the live chat, so I'll see it without a super chat. But do you happen to know if that's also involving the ACLU and who's really spearheading, helping do that research? Because I always think it's interesting when the ACLU is the one backing something, because, you know, the ACLU will also put their own attorneys in the courtroom to fight that battle in the courts. And then Sean Farmer. So I saw this come through, but so why go over all redactions when outstanding motions for mistrials are still pending when she stated, Judge Whitaker, she would rule on last weekend? So I think this was a duplicate. So I feel bad. So if you have another message that you wanted to write, put it in the regular chat. We'll definitely read it. You guys are still predicting mistrial on Monday. And then Bilo, On September 21st, 2017, the DC Court of Appeals ruled in Prince Jones v. United States that using Stingray requires a warrant. So, somebody at the very beginning of this stream was mentioning that they don't know for sure if this wiretap that maybe it was Stingray. We're trying to find out. I'm sure the defense is trying to find out. Was there actually a warrant for it? Was it proper? And the defense should have the right to know what was used to justify the affidavit for a search warrant if there was one. But now you're saying there's case law, it requires a warrant. So if we find out that there wasn't a warrant, that's a major, major problem in general. But now there's case law saying unequivocally, boom, problem. And then Chloe, I want to get this update from Chloe in the chat before it moves away. A lot of the current rules regarding Stingray came about after all the drama in this guy's case. Okay, that makes sense. And then it's regarding a specific case where it was used in an investigation to convict someone. And that was, I'm going to say his name wrong. Kaiser Soza. Was that it? No, that's a character. Hold on. What name did you guys say in the chat earlier that this case was about? Unless it was this specific case. If it was Prince Jones. Let me see. Prince Jones Netflix. Okay, so is this it? No, I think I have the wrong show. It's called The Stingray and not Web of Lies. Is the show possibly called Web of Make-Believe? Because everything when I search Web of Lies Netflix is giving me Web of Make-Believe. But I think it just wants to be difficult. And then also double checking on Corey Harris. I don't know if we have an update there either. It doesn't look like it. Oh, I think we would all like die a little on the inside. The state gives a weak one-page response and the judge still denies the defense motions. Can you imagine? Okay, Chloe, yeah, whatever I'm getting here, yeah, Netflix is just giving me, the search result must be trying to promote that show. Okay, we'll just go to IMDb. I think this is it. Unless, would it be Web of Lies 2? Okay, so maybe it is Web of Make-Believe. Then let me present this because, you know. Wait, so they were using Stingray to track a counterfeit Beanie Baby maker? What? Oh my goodness. God, I forgot about Beanie Babies. So from counterfeit Beanie Babies to very real tax fraud, 2 skilled hackers revisit the cyber schemes that landed them in the sights of law enforcement. Dang, I didn't know Beanie Babies were that serious. Ah. They will definitely like kill this video. And guys, if there's like if someone claims copyright during a video, it ends up killing the live chat replay. Because we can take the clip out of what's ever claimed and the video can still live, but it destroys the live chat replay entirely. So if I play something that were to get claimed, it would just, we'd lose the important part to you guys. And then, thank you so much, Wacky. Is this Krona too? Oh my gosh. I'm learning what different currency is. So about $20 for your commentary. Thank you so much. I'm more interested of the lawyer's play than of the trial's determination of guilt and innocence. Yeah, I agree. At least in this trial. I'm so happy to listen to the discussions you all have. Yeah, we love it here in the chat. And see, I'm playing something on the screen right now as I'm talking about, you know, whatever. And then nothing, just checking. I don't really see anything new over on X. But thank you so much, Wacky. And Nismi, what did you miss this morning? My job keeps interrupting. Oh no, tell them to stop. So the morning started with some fireworks about late disclosure, late discovery. The state is trying to say that they thought it wasn't relevant. They don't plan to use it, but it's some cell phone information, location information about DeMarco Boyer, who's currently in custody. And the state's like, well, we don't know, we could have disclosed the name, but maybe the defense could have found out on their own. And we also thought it was, you know, inculpatory, so why would the defense even want it? And Brian Steele and Max Shardt were all like, first of all, you should have just turned it over. Yesterday, you said it was inadvertent, it was a mistake. Today, you're saying that you knew and intentionally didn't turn it over because you didn't think you were going to use it and that it was inculpatory. So which one is it? The judge butted in and wants to say, you know, when did you get this? There have to be affidavits. There has to be a search warrant. Do you have those documents? Atkins runs out of the courtroom trying to look. Love is like, can we leave the courtroom to look? Yes. Okay, we're having a recess. I'm just going to sit down. Like, it was a hot mess, if you ask me. And then we're supposed to revisit that when we get back from lunch soon. But the other stuff was all evidentiary stuff. Still looking at those Zachary statements. Can this come in? Can this not come in? And I do think the state has one more in that regard. Judge Whitaker's overruled a lot of the defense's objections to certain statements. But there are some that she's saying no, we're not going to get that in, or we're going to not let these lines in out of the portion that you're asking for. And again, a lot of it still depends on foundation being laid at the time of. But she is agreeing with some of the co-conspirator exception arguments to the hearsay rule. And then Chloe Albert, thanks for the $4.99, says, yep, corrected myself. It is Web of Make-Believe is the main title. So guys, if you were looking for something to binge watch on Netflix and you want to learn more about Stingray and how it's used, check out that show. Go binge watch. It looks like 2 episodes about it. So Web of Make-Believe's main title, and you guys in the chat said that it was episode 5 and 6. There was also something, before I forget, it came through as a CashApp yesterday, so it's in parts, and I might need your help digesting it. So Clarence, if you're in the chat, help us out. But Clarence had said, Go back from beginning to opening statements in YSL. Thug was signed to us first. Archive Entertainment. State has a murder one already in evidence. And for falsified documents from detectives and state DA. So that's all like rabbit hole for me. Like, I want to figure out more about what that means. And it's interesting that we hear a lot of arguments from Shardt today, and Judge Whitaker acknowledging, we heard that in opening, which of course is in evidence. Or I might see you make that argument in closing, right, Mr. Shardt? But I think maybe what these cash apps were talking about was opening statements, maybe specifically what Shardt was saying. So maybe that'll be something worth looking back at and replaying, because I don't think we replayed Shard's argument. We had gone through Love's, of course, her opening statements. We saw some of Steele's and Jay Apt on behalf of Diamante Kendrick. But yeah. Okay, hold on. So, Truth here was saying there were some. We've got like 20 minutes. Do you guys know if she said 1:30 or 1:20 return today? I had liked some case law I saw yesterday. And I'm not going to lie, I don't know if this is the same account or if you went and saw the same thing, Truth. But let's pull this up while we're still on lunch. So this is from Priceless Audio. And Priceless Audio said, here's the post. Oh wait, what are we talking about? 1:20. Yeah, we're coming back at 1:20 for lunch. Okay. So first I saw 120. I was like, wait. Okay. But here are some Georgia cases backing my claim that the tracking of Woody's cell phone location at the time of Donovan Thomas's murder is not sufficient evidence to prove that he was in fact the person in possession of the phone during the commission of the crime. So these are screenshots that we're working with. If you ever need to screen share, I always find it easier to open the image in a new tab, because X doesn't really let you zoom in within X on an image. So I always like to open in a new tab and see it a little better. State v. Bagley says, in this case, the court emphasized that while cell phone records, including location data, can be critical pieces of evidence, they do not irrefutably establish the identity of the person in possession of the phone at a specific time. The prosecution must provide additional evidence linking the defendant to the phone's location data. Another case, Georgia v. Jones. This case underscores that cell phone location data alone cannot definitively establish who is carrying the phone. Additional corroborative evidence is necessary to tie the phone's location to a specific individual's actions. And then they gave us a third case here. State v. Thomas. The court highlighted that cell phone location data, while indicative of a phone's location, does not automatically equate to the user's location. The burden remains on the prosecution to demonstrate that the defendant was the individual in possession of the phone during the relevant time frame. So 3 Georgia cases here that would call into question what can actually be ascertained from cell location data, especially in the absence of other evidence that could corroborate whatever theory is being applied to the cell location data. So great stuff. Truth, totally don't know if this is you or if it's other cases. I wouldn't be surprised if there's more cases. Good to see you, Pantene Pro V. A lot of people seem to think this Judge Whitaker is using Pantene. And then Ayanna Davis is all the way back in the beginning and just heard the, oh shoot, I forgot, from Miss Love. FFS, thanks so much for the super chat. I would have killed figuratively to have DA Love as a prosecutor on my past cases. My attorney would have destroyed her career. She'd be working at Walmart. Oh, shout out to Walmart. Shout out to Walmart and Target, But can you imagine can you imagine working in retail and Love was your coworker or manager? Oh my God, I'd quit. She just gets over the walkie and it's just like, And holds the walkie the whole time she's buffering to talk. Oh my goodness. Yeah, exactly this. But thank you so much, FFS. I mean, I feel like I kind of want to watch another case that she, like, if she's still a prosecutor after this, I might tune into a live stream and watch what she does next, just to see. And not greeting people angrily. Oh my gosh. Can you imagine telling her she gave you the wrong change? Oh my gosh. Holy moly. And yeah, great reminder here, the 13th juror. You know, outcome is more important than the mishaps or entertainments of these witnesses and the attorneys. We're just trying to get through a tedious trial stream. You know, when we watch it live, we're not skipping ahead. We're not skipping the recesses. We've got dead space to get through. But you're right. There's still more important things than we have funny moments in the courtroom. There are still outcomes here, and outcomes that don't just impact the individuals that are parties in this case, but there's broader implications on, should this be how we do things? And then, yeah, we would quit. We wouldn't want to do that. She would complain that the receipt printers are spying on her. Oh my goodness. I always love, like, having a pleasant experience with a retail worker. I'm big on trying to, when sometimes I don't get a receipt, like, I'm always hitting automatically, I don't need a receipt. When I do get a receipt and I have a good experience, like, especially if I need help with something, I do love to do those little surveys at the bottom of a receipt. Because we definitely want to give some feedback when we appreciate a good employee that doesn't yell at us or think the printers are spying on them or something like that. If she was the receipt checker, we're not leaving. Yeah, so everyone's thinking she would be the one that checks the receipts and lets nobody leave. Well, so Lady Red, they're not going to swap who's calling the witness. And in Georgia, you can call a witness to impeach them. Some states you can't do that. But if Woody tries to plead the fifth, it doesn't really, it won't work. He can say the words, I plead the fifth. But what's going to happen is the judge is going to look at him like, that you don't really have, you don't have the right to invoke the privilege of the Fifth Amendment because we gave you immunity. So there's just no necessity for it. The privilege is irrelevant. You can't use it. So you can either answer the question or are you refusing to testify? And if you're refusing to testify, then we go down the contempt road. Now, I was wondering, what if Woody says he wants to testify one day? They transport him, you know, he was held in custody for being in contempt the day before. You have to have the right to purge yourself. He says, oh, I want to testify now. They drag him all the way to court. They clear the schedule to know that he's going to be the witness taking the stand. He gets back up there, answers like 3 questions, then doesn't want to testify again. They hold him in contempt a new time. At some point, they're going to end up saying it's disruptive and switch which type of contempt they're holding him in and why. But I don't know. It's a loaded question because there's so many ways that the testimony of Woody could go. Like he said, it all comes down to how he feels when he wakes up on Monday morning. And then Garrett S. says love micromanages but fails with dates, details, and documents. That's why she would be excellent at checking receipts, telling people they can't leave. That's not all the items in your cart. Thank you so much, Garrett. And Sean Farmer, thank you so much for the $49.99. Sean Farmer says, how can it not be a mistrial with procedural errors, misconduct, prejudicial statements? Since she's by the book, this is a no-brainer. Ray Charles was noted when he was living. Now he's dead, and he can see it's a mistrial. Yeah, I agree. And thanks so much for, that's a huge super chat. So thank you so much. We have a new motion, you guys. Woo! Okay, Brian Steele. We've got 10 minutes. I think we can do it. It looks short. Yeah, it's short. It's 1 page. We got this. So shout out to the Honorable Thugger Daily. I'm finally getting that right. Changing my vocabulary up a bit. All right, so yeah, he did file an amended thing to the thing yesterday, but I think it was just he was correcting which ruling, prior ruling he was referencing. It wasn't really a change in the argument itself. But that is true. That is accurate. But here, let's look at this. Motion in limine number 54. Oh, what's 1:01 p.m. It's filed at 1:01 p.m. Shout out to the Honorable Thugger Daily. We're like a couple minutes after this is filed and he's got it already. So, I'm sorry, let me pull this down just so you can see. Thank you so much again, Sean. Imagine we just start putting honorable in front of every name in a motion. So this is from Brian Steele, Jeffrey Williams, probably Keith Adams, motion in limine number 54, filed at 1:11 p.m. right now, or 1:01 p.m. Comes now Mr. Jeffrey Williams, by and through undersigned counsel, and hereby files this motion in limine number 54 to exclude late notice of expert reports / charts in the above referenced case. In support of this motion, Mr. Williams shows as follows. Mr. Williams is innocent of all charges in the above referenced indictment. On Monday, August 5th, 2024, the state of Georgia provided additional expert reports / charts concerning cellular telephone data of a new person unknown to Mr. Williams, as well as Agent Berni's never before produced report / analysis of the April 26, 2015 incident. And then we also get a footnote here that this cell phone analysis is also cumulative. So another reason to keep it out. This is abuse of process and time, as Mr. Williams now needs to go back and consult independent experts to review all work. The time to share this discovery ended, and same must be excluded in the state's case in chief as well as rebuttal. Wherefore, Mr. Williams respectfully requests a hearing on this motion, and at conclusion of same, asks this honorable court to grant the above requested relief and exclude, in the state's case in chief, as well as rebuttal, any and all discovery not already disclosed to Mr. Williams. The 7th day of August, 2024. Brian Steele. So there you go. There you go, you guys. Let's do a refresh here, just to make sure, because, you know. Yeah, so that's the most recent thing from Thugger Daily. Nice and short and sweet, but it puts it in writing, puts it on paper. And we're getting close to that time, so keep this up here. I don't know why, I like to see the heads roll by the camera. That sounds bad. I like to see when someone walks by the camera and you see the top of their head. The first way I said that sounds really bad. That's not what I meant. But I like to see the first action we get back from lunch. Steele had lunch and then filed. You know, I can imagine him being the type of person that puts off eating to get this work done. Wouldn't even multitask. And then thank you again, Sean Farmer. Yeah, and that's okay. Yeah, the ray was blind. It's just a typo. That's okay. We got what you meant anyway. It was understood. And Dublin Mug, thanks again for your email with the... I'm not sure if you were there early yesterday morning, but we did look at that Lil Rod body cam a little bit yesterday. And I actually I got some info from someone, I don't know if they're in the chat with us now, but they had mentioned that these body cams are set to turn on, and the first portion that's recording, the audio doesn't kick in right away. So that's why when you're watching body cam footage, I used to think they turned on the audio manually, but they don't. It's actually the device that it starts recording the video, and then the audio pings in. That's why you hear that weird beep. So thanks so much, Dublin Mug, because I was thinking of your email. But you say here that can't Melnick negotiate a better immunity deal for him? It might be fine, or maybe, guys, Melnick and Copeland, maybe they didn't talk that long yesterday. I guess we won't really have much to go by until we see exactly what happens on Monday. Now, Melnick might not be fully aware of what Copeland plans to do. If Copeland feels like he'd lose Attorney Melnick if he tells Melnick a certain thing, maybe Copeland just made the decision not to tell his attorney something. How do we know? So, it's possible he could ask for better terms, but I do think it's a big win and big understanding that Melnick will be present while he's testifying. And it's actually been clarified that, yes, there should be no derivative use, but perjury and these false statements, which, what was Copeland's question or statement? Well, the state, they told me I couldn't do two things. One of them being I couldn't say that I killed Donovan Thomas. So now Melnick actually gets to be present, and the judge has explained that, well, technically, if you're lying, or if you refuse to testify, you commit perjury, there could be actual issues. But there just shouldn't be any derivative use of anything that you say in your testimony that can be used as a lead to find something to prosecute you on. So I don't know how the immunity changing would necessarily get much better. Okay, I thought for a second there was a new motion, but it's just Bodhi saying that was a short motion for Steele. But yeah, I don't know. I think Melnick probably has more confidence because he knows that Whitaker wasn't going to let a false representation and misinformation about how immunity works fly. But he probably couldn't have the confidence in that when it was Love, Glanville, and Hilton. And then hold on, speaking of the owl shout out, I never actually found it. I can't find it in my mentions. Let me scroll again and look, because that clip was so great. I'm not used to getting... Oh, I found it. Okay. All right, we've got 30... This is 37 seconds, you guys.
How many... Mr. Owl! How many violations of the Georgia Code of Judicial Conduct does it take to get a mistrial with prejudice?
Let's find out. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13.
I love it. I'm going to drop the link. Hold on, give me a second with the link, because when I backed out, it put me all the way back at the top again. That's so good. And I don't know if that's actually like lazy loading, but I really hate when any application, Facebook is really bad with it. You're looking at something and then it just like refreshes right in front of you and it's all gone forever. There we go. And yeah, you guys want to, let's do a poll while we wait. Let's do a poll on if we think more Brady evidence is coming. There we go. Vote away. Oh, I did say today. I could have said before Friday. So if you think they will, but it'll be later than today. Everybody in the chat saying Brady, Brady. Not today. More Tom Brady. Not by the state's choice. Great distinction. 100% more is coming. Friday data dump. While the judge is off. Can you imagine it's your day off? You're the judge. You're already simmering in what's going on. And then there's a data dump. Oh, man. I don't know if they would grant. I don't think that would be negotiable. The full immunity. I don't know if they would grant that. It's possible he could ask for it though, right? So he could make the argument for it. 100%. And Wayne Brady, don't forget about Wayne Brady. Good point. This, you know how they do like the AI summaries of what a live stream is about? They're going to be like, this was talking about how people love Tom Brady and Walmart. That's true. Okay, Sheila K., great point. Fair. It's a trick question, Kat. The state will have late discovery, but I highly doubt anything they do can, quote, surprise the defense, no matter how bad at this point. That's very, very true. Yeah, we're overdue. We need a rant from Brian Steele. And heck yeah, let's super chat here from Ray. Great point. Drea's got a birthday coming up this weekend. She's gonna relax. She's been pumping out every day with this trial, and I appreciate her so much for that. But we gotta remember it's her birthday week all week. So, big hearts for Drea in the chat. Drea's really humble. She's not using a YouTube channel. So no link to promote, but Drea, just know if you ever want to start a YouTube channel, we're gonna support the mess out of you. And I've gotta go. Let me get over to YouTube so I can find easy emojis. Yeah, love in the chat for Drea. We gotta show Drea so much love that the YouTube AI summarizer also puts her in their summary. And I think maybe they're gonna lean into this 1:30 lunch return. Aw. If anybody's coming in late and wondering why we're dropping hearts, it's for Drea's birthday. I saw someone say they came in late. A lot of fireworks this morning, and we might finally...
And in searching through the discovery that has been turned over with respect to the representation that I made to the court about the number being on the wire, within the discovery that was served in 2022, the phone number that we've gotten the records for and the last name of Mr. Boyer is provided within the Sumlin-Dorsey conspiracy. And I said wiretap. There are 2 wiretaps that were gotten. This name and this number appears in both, and the name for the number appears in the Sumlin wiretap.
All right, and you produced that to the defense as a part of the Sumlin-Dorsey conspiracy package of discovery in 2022? Is that what you're saying?
Yes. You distilled that much
Okay.
better than I said it.
And do you have anything more specific than that to point out to show like exactly when that discovery got served?
I do. Hold on.
Okay.
Just need to know the date.
So they're saying they at least disclosed the last name, Boyer, back in August of 2022, which I don't think the defense has disputed that. So we're still missing on the question of interest. What about the affidavit? And now there's two different search wiretaps. So were there two different applications? Yeah. And to be clear, Steele said that yesterday already.
2022.
All right.
And the folder specifically that the number and the name appear in the discovery cert August 2022, it's folder 1, counts in indictment by act 181 through 182, Sumlin, Dorsey, count 55, 181 through 182, discovery 2, Dorsey conspiracy. And it is the 6 call down,
Okay.
which has on it, and I will submit this as states 1 for the purposes of today.
Okay.
It has the phone number 470-957-2893 dash Dorsey and Boyer.
All right. Okay, that appears to clear up that issue.
Does it?
Y'all can double check and make sure it's, says what she said it said. I don't know. Let's ask.
Can I pass it around or I'll give it to the court first?
Sure.
We just screenshot the trunk.
Okay, if y'all got a screenshot of it, maybe send that email around to everybody so they can see, but.
And also we sent it a second time when we organized the discovery for the defendant. So it's in 2 different sets of discovery. The first one is from August 2022.
Okay. I mean, I'm happy to pass that around at the time because she's got it highlighted. Y'all can all take a look at it, but she's going to email, or she or Mr. Atkins are going to email that as well. And then it sounds like it got reserved later in 2022. Thank you, Ms. Love, for digging through to figure that out.
But this is what they mentioned yesterday.
All right. And then do you have hands on the affidavit and search warrant yet?
I label it states 2.
Okay.
Okay, so maybe she's doing this piece by piece, so no issue about the 2022, which the defense didn't raise an issue with that. They're saying that's the only thing we were given. So now we're on the next spoke of the problem, which was actually addressed as a problem by the defense.
I mean, I guess the court reporter is asking about the labeling. So yesterday we had a states 1 and 2, and we sort of had a motion, I guess, with regard to, I guess that was.
We labeled it differently. We labeled it states 1 Melnick proffer.
Okay.
We labeled today's states exhibit 1 as states exhibit 1 August 7th, 2024, if that's today's date.
Okay, so it's weird, I guess, because I'm sure there are 100 million, I exaggerate, but a number of states exhibits that have already been in for the jury trial. We're sort of paused on the jury trial and kind of doing, we're doing motions in limine for the most part, really, sort of, but this isn't that either. This is, I don't know what to call this. Just don't know what to call this. Let's just say it states 1 and 2 to the Boyer discovery matter.
Okay.
How about that?
Yes.
Okay.
Can we get a stapler?
I've got some paper clips.
I think we know where it's secretly kept.
Yeah, I do think the judge is looking at step by step.
I mean, I'm not stapler.
There used to be one, Your Honor.
A stapler?
It's fine.
That would be perfect, Your Honor. Thank you.
I mean,
Thank you.
gotta give it back to me.
Can I respond to what we're talking about?
Yeah, come on up to the.
I'm not sure if anything's being cured or.
There we go.
I don't know.
So let me first start off by saying that the discovery in this case, including, I call them dumps, whatever okay, 1 and 2 came together. And all the different additions, 3, 4, all the way up to, I think there was 13 or 12, they're divided by counts.
Okay.
Okay, so count 55, I believe.
Is the conspiracy
It's
that is connected to the Drinks murder, right?
no, it's not.
No? Oh.
No, that's one thing. It's a conspiracy. It's count 55 in this
Oh.
indictment, which involves.
The murder of Harold Clements,
Well, he's not dead.
right?
It involves, well, that's not in this indictment. It involves,
What is
Oh,
in this
I'm sorry.
indictment? It's not a
The
count
overact.
against anybody. The count 55 is not a count against any of the 6 co-defendants on
Correct.
trial currently, yes.
correct. So it involves something completely and wholly unrelated from the
Okay,
Drinks
right,
murder.
true.
Okay, I want to play for you. So I can show Your Honor the screen, but basically, if you click on that jail call, which I guess is Mr. Dorsey talking, it comes up on your screen. It says 0428-2022. I guess that's the date, 4/28/2022. And it says 2218. And then it says a phone number, 470-957-2893. And it says Dorsey and Boyer. Okay, it doesn't give a first name. It just says Dorsey and Boyer.
Okay,
There's no context for us to know who Boyer is. And this is the call that the state is saying puts us on notice that Mr. Boyer is somehow suspected and involved in the Drinks murder.
Okay.
This is the call, and I just
All
want
right.
to play it.
okay.
Your Honor, Mr. Shardt, Your Honor, if I may just make one point of clarification. We did not represent and are not representing that the content of that call puts them on notice. What we're saying is that the wiretap, the content of the calls in the wiretap are the basis for our search at getting the records. That's what
Okay,
put us on
and the connection to the Drinks murder, but it is this service of discovery that says, hey, that phone number from the wiretap is connected to the name Boyer. Is that what you're saying?
That's what we
Okay.
saying.
It says
That's all I'm
Boyer,
saying.
and it just says Boyer. And
Okay.
if you play this, I would like to be able to play
Sure.
this.
This is a free call from
You already know who this is. Shout it out.
an incarcerated individual.
That's
at
Mr. Dorsey.
Shardt County Jail. This call
All right.
is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number. To accept this free call, press 1. To refuse this free call, thank you for using Securus. You may start the conversation now.
Oh, that's it. Oh, the fuck going on? The fuck blaze? I'm in traffic, so I gotta hit back. All right, I get back at you. 2 guys.
That's it.
All right,
So someone says, I'm in traffic, I'll hit you back.
all right.
And
Okay, no, and Ms. Love's clarification is, it's not that call that gives y'all that notification. It's the wiretap that gives you the notification, because the wiretap has all these communications back and forth between this phone number, 404-957-2893, and Mr. Garlington's phone number. And then it's this bit of discovery that Ms. Love just told us about that says, and that phone number belongs to somebody last name Boyer. Okay, but they say they're not using it in the drinks murder evidence anyway. So that actually, I think, takes care of Mr. Williams' motion in limine.
Dang,
filed
already shot down.
very recently, within the last hour or so, I think.
He's gonna come argue.
Saying keep that out. Is that right? And I have to confess, I have not asked you that particular motion, looked at it myself yet. I'm just basing it on Ms. Pursfield's review of it. Is y'all are saying we want that kept out, and the state's already maintaining they will not introduce it. And so granted, but also unnecessarily so.
Thank you. Well, I added not only case in chief, but in rebuttal for that, Mr. Boyer. And then there's a second part to it. We received on Monday, for the first time, Agent Berni's expert report as to a April 26, 2015 shooting of Mr. Carter's tour bus.
Okay.
It's been referred before this honorable court as the Lil Wayne bus shooting.
Okay.
And the state has already put up, they said they didn't need to qualify Agent Racy. He's with ATF now. He's former detective in Cobb County. Racy, which is, I'm going to tell you, R-A-C-C-I, but I may have misspelled that. They've already put up painfully. It took days tracking phones. They have 3 to 4 different exhibits to your honorable court's right of your bench. They're against the wall, or they should be. I believe that's what they are. Anyway, the point I'm trying to make is now, for the first time, we're getting another expert.
Okay.
Never gave us this information before. And yes, I've had the records. I'm not complaining about that. But, you know, we look at everything and we test everything with our own
Right.
independent experts. So
Okay.
I want that excluded too. That was in the motion as well.
All right. So with regard to, that's two entirely separate, the issue, I realize, is way late discovery is what is being alleged.
Way.
But we're talking about two different sort of pieces of evidence. So with regard to this Boyer plotting of the, wherever the cell phone location is, the state has represented that they do not intend to use this. I'm granting the motion limine with regard to particularly, is at least this case in chief. But with regard to if it potentially needs to be used in rebuttal, at this point, y'all are on notice. Yes, it should have been produced before now, but we're also, I would say, pretty far away from hearing any evidence about the Drinks murder anyway. I am not going to make a blanket ruling at this point that it can't come in rebuttal either, because y'all got time. I don't know if it might need to be used or not. I don't know, but I'm going to
It's
leave
rebuttal, you
that
guys.
for
The discovery
another
timeline's
day
different.
if and when it does come up. Now, with regard to this second sort of chunk of information that's just been produced, Agent Berni's analysis of what does that have to do with cell phones too, or just the incident?
He's a cell phone expert, so that's what it deals with.
Okay.
And it's
As
April
to
20.
the, okay. So what do you say as to that, Ms. Love? Because if y'all have already presented your evidence, or what's your plan with regard to Agent Berni's report and analysis?
Your Honor, will the court permit me to address the first part regarding the Boyer records and get it tender the evidence, and then address
Yes.
the second
Yes.
part of the motion? Okay. So the state is tendering for the court's consideration states 2A Boyer records, which is the affidavit for the search warrant, and states 2B Boyer records, which is a search warrant itself for
Okay.
the cell phone records, and the court is correct. We stated earlier and state again that we are not attempting to use them in our case in chief. As well, Your Honor, I am marking as State's Exhibit 2C, Boyer records. It is a screenshot of a search of the wiretap data for the number of calls that involve 470-957-2893. And the number of calls within the wiretap that involve this number are 501. So
Okay.
I'm tendering this for
Okay.
the court's consideration.
All right, thank you. And 1 as well as 2A through C are admitted. Okay, turning now to the Berni
set
matter.
of plots regarding the Little Wayne bus shooting, the data, the cell phone records, and their cell site location information was turned over, I believe, in July of 2022, if I am not mistaken. I'm almost certain that we turned it over in the first set of discovery that we served.
Okay.
So the data that the plots are derived from have been in defendant's possession since July of 2022.
They already disclosed the data, but they should have disclosed it. Should have told them we plan to call a witness to
that
talk
were
about
made
it.
at the request of our office were requested after testimony and cross-examination, testimony elicited from through direct and cross-examination of our witnesses in the Little Wayne bus shooting.
Okay.
As a result of some of the questions and answers and the direction that we saw that questioning going, we asked for the plotting
Okay.
of the.
And when did you ask for that?
I'll get an exact date.
Give me a ballpark.
Hold on.
Give me a ballpark.
When? You've had all day to figure out when on these issues.
Well, when did these?
In the last 6 months, that's the,
All
I'll
right.
give you a narrower ballpark because things were delegated and we did.
Okay, when did these people testify to the Lil Wayne shooting? When was that testimony roughly? January, June, April? Okay. So at some point after April.
That's a good one. Yes.
Okay, let me ask you this. At the point in time when you think it might be relevant to have a plot of whatever cell phones might have been involved, we've already heard everybody's testimony. Man, we'd like to shore that up with some expert rolling back in here and taking the stand again. We're going to get him to plot this. Would it have been possible at that point in time to share with the defense, hey, y'all, we're going to have our expert that y'all already know about anyway. Go ahead and plot this too.
Yes, that would be. Yes.
Okay. Why was that?
They actually said yes.
So Bernie did not testify about these. He has.
I know.
Okay. Your Honor, if I may, I'd like to give the court first the more precise time that we got those records.
Not when you asked for them, not when you got them, when you
Asked for them, that, yes. Before I go to that second question with the court's permission.
Okay. Go ahead. How long is it going to take to get that information? Can Mr. Christian work on getting that information?
It's already being worked on. I already.
Okay.
sent that request.
I mean, will the answer differ based on when you asked for the information as to why at the time you asked for the information, no matter when that was, you did not, even though you could have, say to the defense attorneys, I'm going to be getting this. I don't know if I'm going to use it or not, but I'm going to be getting it.
That is the best practice. And we did not, but I don't have as
A
to-
good answer. I mean, and the answer could be because, man, there are only 24 hours in the day and this is chaos and, you know, we're doing the best we can. That could be your answer. I don't know.
The accountability struggle.
It's still not a good answer,
Yeah, we know.
but let's just maybe nip this in the bud. Because I did ask you also to, at the lunch break, huddle with your team and see if there might potentially be anything else outstanding, whether Brady or not, because none of this sounds like Brady. It's just information that might come in trial that it would be, you know, just kind of like the way we're supposed to try cases is to sort of share each other's evidence to, you know, with the other side so they know what to expect. So were you able to sort out yet? Is there anything else out there in the universe that you think you're going to use?
Judge, I used the lunch break to get that information I gave to you
Okay,
earlier. We
all right.
were feverishly getting that.
All right. So, all right.
Right now, what I have for the court is that Racy testified on between May 13th and May 16th. So
Okay.
I need to clarify
Okay.
that.
Okay.
And the defense challenging him and as I said earlier, the questions and answers and the follow-up cross-examination elicited during that time period, May 13th and May
Okay.
16th, is what caused us to request them.
Okay. That's fine. Okay. And essentially, you acknowledge, yes, we could have gone ahead and let the defense know we were going to try to get this plotted. You just didn't. And I guess what I need to have happen going forward is that as this trial is going on, first, if there's anything outstanding like that, whether you've got results back or not, or if you're just like, after somebody testifies, you know what, this would be a good thing.
Okay.
Share it in a timely manner, which is like, not necessarily at the time it occurs to you, but at the time you decide to do it.
Okay.
Don't wait for the results to get back. Don't wait till you're going to call the person to the stand. At the time you say, we're going to do this, you give that information to the defense, okay? And then when you do get the results back, you can say, we're not going to use it after all. Or we are going to use it, here's the result. And that is going to be the rule, be the requirement moving forward for everything. So if there's anything out there right now that's kind of
Again,
in progress, tell them about it. And moving forward, as things come up, when you decide I'm going to be doing something about this, tell them about it, okay?
Yes, sure.
So what amount of time do you need to get with your team and figure out, is there anything in process?
buffer.
Friday at 5 too late, or you want me to?
How about Friday at lunch?
Okay.
Well, okay, I don't know what our Friday is going to look like, but yes, you can share it with them without it being in court. So yes,
Okay.
Friday by lunchtime. And you can just copy Miss Persefield on whatever it is you tell them.
Okay.
All right? And
The judge just
I
went off.
expect that to be the rule that gets followed moving forward. Okay?
Okay.
All right. Any questions about it?
No.
Okay. All right. Anything from the defense on that topic and that rule? And I know it is not ideal, but this, it seems that up until recently, this trial was sort of everything was on a rolling basis. And I can't do a whole lot about that, but moving forward, that's what it's going to be. Yes, ma'am.
So, Your Honor, that's, everything was, no, sorry, everything was not on a rolling basis.
Well,
And the rule that you just implemented was already the rule.
okay.
Chief Judge Glanville, at a certain point, because we were receiving late discovery disclosures
All right.
all the time.
Okay.
And at a certain point, he said he was fed up. He spoke to the state. He said he was drawing the line there.
Okay.
And that any late disclosures after that, and he did exactly what you did today, maybe not in those exact words, but he
All right.
said, is there anything else?
Okay.
So he gave the state this opportunity already, and he told Ms. Love specifically that if any other late disclosure of discovery came after that date, that it would be met with remedies and sanctions. So we're
Okay.
here again, and I'm just asking that before you exercise patience.
Don't exercise patience. Okay. That it was already supposed to have been in place and be aware of that. Okay. So, I mean, I think that's probably true. I wouldn't be the least bit surprised if Judge Glanville had already at some point said, all right, y'all, we got to
Judge Glanville.
sort all this out.
In fact, he has, and did in fact say, hey, turn over everything you have.
Right.
And I'd only say that as trial goes and as we see the direction
Mm-hmm.
that
Okay. Mm-hmm. I
manifests
understand.
itself.
Yeah. I mean, trials are kind of living things. I get that. But if even if it took you 2 weeks to decide, so like by, Memorial Day weekend on May, whatever it was at the end of May, you were like, yeah, let's get this. It's now August. So you had all of June and all of July. So, I mean, the motion on the floor is to request that the plot by Berni be excluded from this trial.
Your Honor, we would ask that the court, since that is the motion on the floor, deny the motion because the data that has been plotted has been in the possession of everyone. That's including cell site location.
It's about the
data,
expert in report.
since July of 2022. The counsel for the defendant is correct that Judge Glanville said, turn over everything that you have, and you have a continuing discovery obligation.
Right.
So moving to exclude a summary of what has already been given, we would argue is an extreme remedy, given that the information that is contained in that plot that was given to them has been in their possession since July of 2022. And this is something that we requested. I haven't yet even told, I don't yet even have the exact date that we received it back, but we did request it around May 23rd or shortly after that.
All right. And the plotting that Mr. Berni did, is that with regard in the report that's come back? Is that in regard to the Donovan Thomas murder?
No, the plotting that they're referring to has to do with the Little Wayne bus shooting
Oh, right. Y'all told me that. I'm sorry.
that we put up the evidence of.
All right. So have you had Berni testify yet?
No.
So when I see on your witness list that you've most recently provided to everybody, that Berni is listed as your expert or not. I don't know if he's, expert with an expert report and phone records for count 2.
That's
which
in the
is
next 30.
Dominant. Okay. So
we
is he then listed again for where?
Yes, he's not in he's also in the last 30 set of witnesses for a different act.
And is that the bus shooting?
The Chamel drinks. No, the bus shooting, we've already put up
Okay,
evidence of.
so are you planning to call him to say, and here's the plot of everybody for the bus shooting?
No, what we did was we introduced Detective Racy to do that, but the defense challenged Detective Racy's ability to do that.
Okay.
And so for that reason, we had Agent Berni to plot them.
Okay. Okay. So Gracie you had attempted the plotting through that witness.
Yes, we had introduced,
Okay.
we introduced and attempted to introduce plots of various numbers. There were challenges to Gracie's ability to plot various numbers.
Okay.
There were,
All right. But you at no point after you knew you couldn't get it in through Gracie said, all right, we may be trying to get this in through Berni.
did not, no, we
Okay.
never did that. And I want to be clear that it had to do with the line of questions that were put upon Agent Racy.
Okay. So, I mean, sure, it only came up that this was a possibility after Gracie testified.
We only decided to do that after that. We were
Right.
intended to be done with that.
But it's still been 2 months since that time.
Yes.
And,
I can
and
see
so
that.
why is an appropriate sanction not at this point saying you cannot use that information through, period? You can't use that information. I can't let Berni testify to that.
Because 2 reasons. The remedy of exclusion, as the court is aware, is one that is extreme, and generally it would be appropriate when there has been some kind of harm and there has been some kind of bad faith. I'm not saying that that's the only time the court makes the decisions. Our argument would be that it should only be employed if there's something prejudice.
Yeah, I understand. So how is it not bad faith? And I don't mean this personally, but how is it not bad faith when you've been ordered by a court, probably orally and in writing, that you need to produce things as they come into being and as you know about them, and then you don't do that?
Bad faith would be holding it back for some kind of advantage, tactical advantage. And if we're saying we don't have to put that up until the last 5 witnesses, and we are at witness 80 in a list of 175, giving them the records or the plots now, literally when we have people, when we
Okay, so that sounds more like an argument that they aren't really prejudiced because they still have plenty of time to handle it, right?
It's actually for both, because what I was saying is, to say it's bad faith would mean that we held it back for, I mean, that's still not the only definition of bad faith, but we did not hold it back for any. We did not intentionally keep it from them.
Okay.
It's.
So how is it that it came out on Monday or occurred to y'all over the weekend and you produced it on Monday? Is it because because y'all finally got together and said, all right, y'all, what else is there that we ought to be giving them? Why 2 months later?
So the moment that precipitated this disclosure, I have to rewind and go back over everything that has happened. And I can only say that it may have been that the court, it may have been that as we were looking at 30 witnesses out and looking at Berni, we realized, oh, Berni.
Okay.
But you still don't have your list of 30 witnesses, do you?
So it basically was just the court saying, it's time to get organized and it's time to share the details about what your intended trial evidence is going to be, that finally made y'all get organized enough to realize, oh, shoot, there are some things we have not shared yet. Fair?
It is the court's order that got us to do that.
Okay. All right. So that is probably not bad faith. That is it being
Or it's an
smoked
excuse
because there's a
for
lot of
trial by
evidence.
ambush.
But I am And I am exercising patience despite the suggestion that I not do that. And I hear that you probably think enough patience has already been exercised. There is a long time before this witness is going to be called for this purpose. It is more difficult to prep for evidence as the trial is ongoing than it would have been before. It's more difficult to do it with 2 fewer months' time than it would have been with 2 extra months' time. This needs to be the last of it. I mean, it's sort of like when somebody comes before me on a probation violation and it's the first time I'm seeing them. I don't know what they thought about getting away with anything before that. But once I talk to them, I expect them to abide by it. I expect you to abide by it. So between now and noon on Friday, you better make sure you have got all your ducks in a row and you have shared those ducks and ducklings with the defense.
Yes.
Okay.
What a metaphor.
I'm about ready to move on from this, but yes, ma'am.
Okay, Your Honor, I'll be brief.
Speak into your mic.
Yes, Westmoreland.
I'll try to be brief.
All right.
Your Honor, in all candor to the court, I believe that the state is arguing as if it's a first argument to you because they know you haven't been here for 19 months. These arguments, I've heard them so many times, it's countless.
I understand.
Right. And for the state to argue it's not bad faith, I'll give you an example of things that we've been through before we had the opportunity for you to be presiding.
Can I ask you a question before you do that?
Sure.
Is this something that is not already included in one of the numerous motions for mistrial or to disqualify these prosecutors?
I don't think so, actually.
You don't know?
I said I don't think so.
I don't
Okay.
think
but
so
I'm not
either.
sure.
Go ahead,
But this
share
is
it.
specific about discovery, disclosure,
All right.
and timely disclosure. The state's been caught before. Specifically, I remember a late discovery disclosure that once it was disclosed, it actually had a comment on there that was supposed to be internal that said, "Do not serve yet." They did it on purpose. And how many times can you say, oops? How many times can you repeatedly, systematically make the same mistake as an experienced litigator and say, it's not bad faith?
Okay.
Your Honor, I'm just asking that the rules be enforced. Because if they're not really rules. They're just aspirational.
All right, I understand. And we are instructed ad nauseum by our appellate courts, they probably won't like my use of that term, that exclusion of evidence is an extreme sanction, and that prior to a trial court instituting that as a sanction, the solutions that need to be thought about include a continuance, which is not going to happen here because we've been on a continuance for a while here anyway. A continuance here, it's, no, they cannot bring it up next week. It needs to be way far down the road, which they are representing that it's going to be anyway. So it'll give y'all time to look into whatever it is. And I understand what you're saying and I hear you. And the answer to how many times can it happen? Maybe 0 more times. Okay.
Not trying to keep us from moving on, but related to this.
Yes.
My understanding, I'm sitting way back here. My understanding is the state admitted some court exhibits to include the affidavit and the search warrant
Right.
for Mr. Boyer's
Yeah.
phone records. Is that correct?
Yes.
Could the state, we still don't have those.
Okay.
So could the state send those to us?
Can y'all share those by email or should I have copies made of these?
And additionally, my colleagues are correct. We would also like all reports. The statement that the state has made is there's been a continued investigation into this case, into Mr. Boyer, and we would like all associated reports, investigative reports, summaries, supplements involving the continued investigation since our client's arrest.
Reasonable. Ms. Love, you understand?
Yes.
Everything with regard to the police investigation of Mr. Boyer in any kind of involvement of his in any of the crimes indicted in this case.
Ducks and ducklings.
And let's ask for it before the end of the day and make sure you have it before, I mean, it should be by like sometime mid next week. And if it is going to be any longer than that, you let us all know why. Okay, and so sharing the affidavit and search warrant and whatever else it was, is that something y'all can do electronically, or do I need to get copies made?
I'm actually checking to see if we brought over physical copies
Okay,
of both the warrant and the affidavit. We have.
all right, let Mr. Adkins look for that, okay? Huh?
Yes, it is. We can provide physical copies of the
Perfect.
affidavit. We do not have a copy of the screenshot of the number of times the number shows up in the,
Okay. All right, but you put that on the record, and y'all, 2C, and y'all are welcome to walk up at the next break and look at it, but it essentially is just this one line that shows however many, 500 and something times, okay? And she's going to share hard copies of 2A and B. Okay,
Just
yes.
during the trial, you're going to be met by Mr. Williams with an objection to Agent
I'm sorry,
Berni's.
say that again.
I'm going to raise an objection to Agent Berni
Okay,
about the going backwards, what's testified to, and I heard
okay,
what the prosecutor said about, oh, this came up because of cross-examination. My memory is strong. My memory is that all of our objections to Agent Racy
uh-huh,
testifying about cell site location data was overruled. The state put in all this evidence for a long time about where
Okay.
every phone was. So you'll be getting a cumulative.
okay. If that is in fact the case, yes, please point me to where that is. And I mean, if it all came through Agent Gracie anyway, then I may revisit my ruling. But let's not take that up now. Y'all can file something and point to that part of the testimony. Okay.
And that was his footnote.
All right. All right.
That
so
shouldn't
back
come in
to
anyway
the
because it's already been talked about through another witness.
plotting detail that we are engaged in with regard to Mr. Zachary's April 2017 statement. And let me, before we get back down into that, I was going to go back and listen to a portion of the video that had to do with item number 13. Let me find my list.
And thank you, Mahadi. Super, super great to hear Mrs. Westmoreland make
Gotta
her
find the
argument. She's
list.
great to listen to. And yes, 7 verse 1. I also like the court reporters pink with the gray hair.
Y'all have
Silver
your
hair?
lists, so. Nah, that's fine. I'll just need to have somebody from my staff walk into my chambers and find the 3-page list with my scribbly handwriting all over it and bring it up here. But I've got an electronic copy of it anyway. I don't know where it is. Anyway, it had to do with, oh, here it is. Here it is, I found it. Page 54, lines 18 through 22. I was going to go back and look because I was trying to figure out who they was. So having listened back a ways and listened forward a ways, it's pretty clear to me that Mr. Zachary at this point, when they say, when the investigator asks who they say killed him, and he responds, shoot, they say Woody and them. I don't know that for a fact. That the they there is who do the people that you were with at the condo later that evening say. So I am gonna actually go ahead, and I think I had tentatively ruled that out before, but I'm gonna permit that after all. Because that's, to me, pretty clear that he's saying that very evening, this is what the group was saying. All right. Okay. All right, so I think we are were we on item number 53 at this point? Anybody?
We had gone up at least to 150, page 157, the last address on.
Okay, right. Great. So then item 53 is on 158. Okay. So 158 lines 12 through 21. Okay. Okay. So then we're at 159, 6 through all of 160. And I guess the objection is this is incidents entirely unrelated to anything that is a part of this indictment and that it's hearsay? Okay, and what's the state's response?
And thank you again, Mahadi. And also, I saw this earlier, Miss Love, just let the journey end. They all do.
I changed my prior representation. I don't have an objection to that.
Okay. So that is out by agreement.
Thank you, Rob O'Neill.
So just, I'm sorry.
Go ahead.
Starting at line 6 on page 159.
Right.
Yes.
Yeah. Okay, so the next is 170, lines 10 through 17. Oh, well.
I think all of us have rejected Love's proffer. We don't want it.
I've made my objection about what the deacon said being not in furtherance of the conspiracy, but I would concede, I'm not withdrawing my objection, but I would concede that this would fall under that same
All right.
reasoning that you've already admitted the other ones.
Okay, thank you. Essentially, we don't need to re-argue it. Got you, thank you. All right, so my ruling as to this will be the same for the same reasons. And are the items listed in 56 essentially the same again? Same
I
argument?
believe so. I'm just reviewing it to make
Okay.
sure there's nothing
All right.
additional.
What flavor popcorn do you guys think the jurors like? Butter,
It's all over
cheddar cheese,
one example.
caramel.
All right, looks like the first chunk, 174 through 177, is all this kind of same thing we've considered argument about. Do you agree with that?
I do.
All
I
right,
also agree that the second chunk
okay,
as well.
all right,
I'm looking at the third right now.
all right. Same for that last one too. Do you agree that the last one's the same as well?
I'm almost done, Your Honor.
Okay, I'm sorry, I don't mean to be rushing you. I just don't want to be thinking that you're done and you're waiting on me or anything.
I would agree that it appears that that is all based on what Mr. Garlington said to Mr. Zachary.
All right. Okay, and so for the reasons stated before, I am going to admit those three portions of the transcript over objection is obviously assuming they end up needing to come in and foundation is otherwise laid.
I do have a motion, and I believe that, or not a motion, but an issue that is in this section and is going to, it's interspersed throughout both.
Okay.
And when Mr. Zachary
Okay,
advised, presumably.
can you talk into your mic?
Yes. So my concern, I understand that I disagree with it, but I understand that Mr. Zachary has claimed that my client made certain confessions to him. I would argue that we need to figure out on my client's behalf what we're doing with the confessions that were made allegedly by Mr. Kendricks to Mr. Zachary, because that is, as I understand the law, I don't see, that seems like it's spilling the beans. It does not seem like it, and I understand that statements made by Mr. Kendricks, if the jury believes that he made them, can be used against Mr. Kendricks. They should not be considered against my client, Mr. Stillwell. And I would assume that all the other attorneys who are representing neither Mr. Stillwell nor Mr. Kendricks would have an argument that those statements should not be considered against their clients if they're being admitted as statements by a party opponent.
And for what it's worth, Judge, if I can just join on behalf of Mr. Williams, I was getting ready to kind of jump in and say the same thing, that I understand the court's pronouncement previously. I understand the state's position as to what they contend those statements are. But in so much as we're charged in this indictment, and we believe that those statements may be admissible against those particular individuals who made them, we do not believe that they're admissible against us. We believe that they do fall under the category of spilling the beans, and that they should not be. They may be admissible against that person, but not against us, and we'd object to those statements being admitted.
All right.
Your Honor, if it were that it was, we were only saying statements of a party opponent, in that world, I would have one argument. In this case, we have that they are co-conspirator statements, and all of the defendants currently on trial and the people who are making the statements and the persons to whom they are making the statements are alleged co-conspirators,
Right.
which makes them admissible for each of the defendants.
It makes them admissible as long as it is still a statement made in furtherance of the conspiracy.
Right.
And so y'all are going to need to talk detail to me about when in time and to whom and under what circumstances co-conspirator statements were made, because I can't make a blanket ruling that everybody on trial or everybody indicted, everything they ever said to each other falls under that exception. So let's maybe sit that to the side, but come back to it to the extent I haven't already made a ruling, because it just is going to depend. Okay. So, I mean, I don't know, let's just, let me add that to my list of things we still need to do, but y'all are going to have to bring to me the detail about what and when and to whom and all of that.
So, Your Honor, that is for sure. That is what we expected. What we were undertaking here is not even an assertion
Right.
that, okay.
Yeah, so we'll do that another time. One other thing I noticed in what we just were looking at is there was mention made of a McDonald's video. And I think just maybe in passing, Mr. Shardt, you mentioned that nobody's ever produced that video. And I just want to make sure, does the state have possession of any video from McDonald's? And if not, did y'all or somebody from law enforcement go see if any such thing exists?
Your Honor, yes, evidence through testimony has already come in that at least one investigator, along with her partner, attempted to obtain McDonald's video. She was not able to. The lead detective was not able to, did not. We don't have any McDonald's video, and we don't have evidence that anyone has McDonald's video.
Okay.
And as the court already knows, in the portions that are reflected in the transcript, it says someone was trying to get McDonald's
Okay,
video.
just want to make sure. Okay. Then item 57 on page 185. You're going to withdraw it? Okay. All right. Item 58. Well, I'm sure these, it started out as kind of notes to yourself.
Yeah, yes,
So
I
don't
did
worry
not
about
do
it,
the
but-
best job of laying out exactly what my objection is, but it starts out with speculation, it seems to me, about on behalf of Mr. Zachary about why people are not hanging out with Woody, who's Mr. Copeland, anymore. And then they get into a discussion about a word that I don't even use, quote unquote, snitching. And I just don't know what relevance any of this
All right.
discussion has to this case.
So to respond to Mr. Shartt's relevance objection, what the court has, just to give some background, in 186, on page 186, starting at line 1, Dennis flat out asks, after Woody came down here and talked to the police, it was almost like everybody was distant from him. And Mr. Zachary says, yeah, we have, and I anticipate we will here, we'll see through Mr. Copeland. But there are multiple statements that Mr. Copeland gives regarding his distancing from other members of YSL after he went down and talked to the police. That's one thing. Later on, as in line 8, so in line 6, Detective Dennis says that, did they distance himself from them because they thought he was snitching?
Mhm.
And Mr. Zachary clarifies, it's not about that, but he snitched on the person who shot at him.
I mean, it essentially ends up being a conversation like, no, it's that he got the police involved at all. These kind of things ought to be handled amongst the people that have issues with each other.
Yes, and
Okay.
so for 2 reasons, it sort of tells how they operate, and also to the extent if Mr. Copeland says, no, I didn't say that.
Yeah.
It would serve to impeach that and to further show that this is how we operate.
Okay. I mean, I think it's certainly relevant to showing how they operate. Now, if there is something more in particular about, a certain phrase or a certain question that you think could be excised, let me know that. But I think the overall concept is a relevant one in this trial.
Judge, let me interpose this if I can.
Okay.
I hear what the court's saying. I hear what prosecutor's saying as well. But for it to be a relevant issue in this trial, it's got to be relevant to, for example, someone's testimony. And the discourse that we're looking at here isn't them saying that, for example, Mr. Copeland isn't saying something or is saying something, or people are getting upset at him for snitching. They're having this and I'm going to use Mr. Shaw's word, kind of this philosophical discussion about whether people should be talking to the police or not.
Right.
And you can have that discussion. They can have that discussion without it and have that opinion, because quite frankly, the detectives are also interjecting their thoughts on why people do what they do. That doesn't make it relevant. They're having this discussion about whether it's appropriate to talk to the police or not. But there's nothing about that discussion in and of itself that really tells us anything germane about the facts of this case. You can say that, for example, the state can say, for example, well, this goes to show how they operate. Well, a person can have an opinion without it going to show that they operated in this particular manner in regards to this case.
All right. I agree, and you can make that argument to the jury. Thank you.
I think it also goes to, it borders on propensity as well. To say that someone has a propensity to act in a certain way that might be
Show us,
consistent
Mr. Adams.
with whatever their theory is for this case. So I just think.
Okay, well, it's not specific other acts. And if it were, it's intrinsic to this set of charges anyway. So overruled. Thank you.
And thank you, Paige, by the way,
All
for the
right,
popcorn
moving to
combo.
191, item number 59.
And thank you also to FFS, Mag Shart's quote, "Your Honor, I'm hot. Steam has been coming off my bald head all night." That's definitely a quotable from this trial that's got to be memorialized.
I withdraw that.
All right. Then 192 is our next one.
Then great point, Satchel. Love has been wrong so many times here. It could just be that her use of the word wiretap may well just be a record of location data. So just not precise in
that's
what she refers to.
Lines 16 through 21, Miss Love.
We up to 20. Yes, we don't have any objection
All
to
right,
that.
16 through 21 of 192 out by agreement.
I withdraw 193.
Okay. All right, so that's, you'll withdraw as to your item number 61?
Yes.
Okay.
I'll withdraw 62 as well.
Okay.
And shout out to Yaya. Yaya says, Whitaker has me looking at her sideways now with the sad face.
And Your Honor, for 63, if I don't want to withdraw it, because if you saw the way, if you agreed with my arguments about Demikion's statements, I think it would be inappropriate for Investigator Dennis to repeat Demikion's statements. But I would, for the purposes of this exercise, I would concede he is repeating alleged facts that Mr. Zachary is saying Demikion told him that fall under your previous ruling.
Okay. All right. All right, so that's based on the same rulings as before. Okay, now we're at item 64, which is on page 206.
And Your Honor, I know you have no context for this at all. So in discovery, there is I would term it as completely innocuous social media post of my client that may have been posted on January 10th. I believe it was taken at New Year's.
Okay.
January in 2014 turned to 2015 with my client just kind of standing there, and it said something to the effect of looking at the city with a lot on my mind,
Right.
or something like that.
Okay.
Somehow that's being posited as some sort of confession, or
Right.
which I don't really understand. It has not been admitted into evidence yet. I'm going to argue that it should not be admitted into evidence because it has no relevance. So there's reference to this
Right.
picture, and
Okay.
I
Do
guess
we,
pending.
sorry, go ahead.
No, you're tracking.
I understand. So do we even have any idea what time it got posted in relation to Mr. Thomas's murder?
Your Honor, the time, I believe, is on the post, so it's after, make sure. The time is on the post. And I
Okay.
at the time. And my memory that I'm gonna confirm is that it's around 10 something in the evening, but I'm gonna confirm that. I may have
What time was the
7
something PM?
Yes, it was a little.
Okay.
7:22 to 911 call
All right.
at night.
And so it was posted by Mr. Stillwell on January 10th at 9:58 PM is the time and date of the post, on the post. So,
January 10th at 9:58 PM.
yes, after yes.
Yeah, that's gonna be permitted.
In that case, Your Honor, there's nothing there's nothing about this discussion of it
Right.
that is by itself objectionable. It's just, I object to the evidence itself. So that's why I
Okay,
was-
yeah. And I mean, I don't know why on earth this part of this would end up being something that gets submitted as a prior inconsistent statement. Who knows? But to the extent it does, it can come in because I think that the evidence itself would be admissible considering it's the post and the commentary is 2 hours after the murder. Okay. All right, takes us to 2:15.
This is more y'all's. You like it? Go ahead, Keith, you answer it however you want. Withdraw? Oh, we'll withdraw that objection.
All right. All right, now we're on to page 222.
I am, on this one, it's a very simple objection. They're talking about the phone records and alleged communications between Mr. Winfrey and Mr. Williams on the night of the shooting of the Lil Wayne tour bus.
Okay.
Mr. Steele and Mr. Adams are, Investigator Underwood interjects and says, Mr. Zachary is saying that Mr. Williams didn't answer the phone. There was no communications.
Right.
Investigator Underwood interjects and says, that ain't what them phone records say.
And that's not true. Right?
That's correct.
Okay. Any issue with taking that out, Ms. Love? Just lines 24 and 25 of page 222.
I don't mind.
All right. Thank you. Okay.
You guys look at 223 lines 1 through 3 and make sure you guys are. Or really 1 through 12.
You're going to make an argument that this should not be redacted?
So yeah, I don't have, I'm sorry.
All right.
I don't object.
Okay, so item 67 as listed is out by agreement.
And the next one,
Yeah.
I don't have any objection.
All right. Thank you.
And so part of the reason that my initial response or reaction to it was to keep it in is only that he was, Mr. Zachary, throughout this conversation, this portion of it, he's talking about his own observations as he was with them.
Right. Not this particular part. So that's essentially, I mean, I don't know if the overlapping conversation actually, y'all can understand it adds anything, but at least what's on the transcript 20 through 25 is not additive to anything. So can we just strike the entirety of this page by agreement?
Yes.
Okay.
Yes, John.
All right. All right, the next one, 225, 1 through 6, appears to be admitted speculation. Unless I'm missing something.
One through I agree and don't object, and I was actually looking further down.
Okay.
I had no objection to 1 through 6.
Okay.
The crazy part about all of this is half of this still will need foundation laid in the moment of. Like,
Okay. Now turn into 228.
All right.
All right, Ms. Love.
So Judge, this portion of it, the reason I wanted this in is that
I know why you wanted it. Why is it admissible?
That's the question.
so, all right, so I don't have any objection to 11 through 17.
Uh-huh.
But Mr. Zachary's assertion that they, and the way I read it and understood and listening to it, YSL knew that Donovan Thomas's gang had shot up Thug's car. I believe that statement reflects a general understanding that he shares and that his cohorts share within YSL. And I would argue that part goes to prove count one, and it provides not that we need a motive for murder, but
The Woody get on Instagram flashing money and junk, and the Nut Gang had done shot up Woody, I mean Thug's car.
no, when he says when you listen to some nuts gang, if gang, shot up and.
But I mean, is that the part that you want? Is that like basically lines 17 through 19?
Yes.
But Judge, you don't look at it in a vacuum, right? If we're talking about looking at it from line 11.
Yeah, no, I'm just trying to get a handle on what everybody's even arguing. So if she's saying, trying to figure out now, like she's saying, I don't have an issue with some of it. I'm not making a ruling right now. I'm just trying to get a handle on things.
Yeah, I'm just trying to point out that the analysis is the same, whether we're going from 11 to 17 or 11 to 19, is still the same analysis. That what the speaker, what Mrs. Zachary is doing is he is giving his assumption as to why something is happening, what people are thinking, and it's clear, right? Where he's talking about, well, that's what everybody thinks, and it's because Woody got on Instagram flashing money, and people think that the Nut Gang had done shot up Woody or Thug's car. All of that is assumption and speculation on his part. And it's just not. It should not be admissible.
Okay, I don't think it's an assumption on his part that Woody got on Instagram flashing money, is it?
No, not that part.
That's a fact.
That's a fact. That Woody got on Instagram.
And it's also, I think, a fact, but I don't know, y'all can tell me differently, that people from IF shot up cars in the parking lot that night.
They believe that if gang shot up.
Right. So someone's belief, though, is not evidence, and there's certainly been no evidence. That's an issue for a jury to make a determination about.
No, the fact that this group of people thought that this other group of people that they are beefing with have done some shootings against people in their group is relevant, whether it is true or not. Their thought about it is relevant to the issues on trial right now. So to me, the only way this 17 through 19 comes in is if Mr. Zachary gets on the stand and says, no, I had no idea that Woody got on Instagram flashing money, and or no, nobody that I ever hung with ever thought that IF did anything about the shooting in the parking lot that broke a windshield on Thug's car.
Right, it would have to be an inconsistent statement. He would have to,
All right, so 17 through 19, that little portion, if he gets on the stand and says one of those things, then whichever part of that is inconsistent, you can say, didn't you on whatever day basically say this? But that doesn't mean 11 through whatever the next page is. That means that Woody got on Instagram flashing money, or Nut Gang done shot up Thug's car, okay?
yes.
The rest of it does seem like, well, you know, if other people think such and such, here might be the reason they think it.
They don't, am I reading? I don't see that they have an objection beyond 19.
It's page, I believe it's supposed to say 2, well,
I thought it went all the way to 229, line 19.
yes, that is correct.
The one that I have, it.
No, I know, it just says 2219, but he means 22919.
Oh, so I have a different response with that understanding as to 228, 20 through 24, and.
Okay.
further data.
All right, so 228, 11 through 15, or the beginning of 16, is out by agreement. 17 through 19, only in under the very limited circumstances I just relayed. So now 20 through 23.
So throughout this trial, again, there have been battling contentions regarding the relationship between DeQuantez Lamar, who is Rich Homie Quan, and defendant Williams. So when ADA Sprinkle asked whether Rich Homie Quan, and actually this part has, there's an evidence that Rich Homie Quan was affiliated with
Okay.
Donovan Gang.
Okay.
So when he asked Quindarius Zachary that, and Mr. Zachary says yes,
Yeah.
and began talking about it,
Uh-huh.
This part, as it states, it challenges the notion as he goes further on and explains. And I want to get to the part that we can do this.
Well, let's just deal with this part right now, 20 through 24.
So when he said, when Mr. Zachary says yes,
Yeah.
and then talks about the fact that Thug and Nut were hanging together.
Right.
While Woody and Shell Kell were shooting each other.
Right.
It's just his observation. I mean,
Okay. Yeah.
I don't
That
have a
part,
problem with 20.
you don't have a problem with that part. All right, so that part is in. There's no objection to that part. Okay, so now we turn to 229, 1 through 19. And what's your objection, Mr. Shardt, to 1 through 19?
Mr. Zachary seems to be talking about not just generalize how this isn't a situation where previously it was argued kind of how the group felt, but he's talking about very specific instances, it seems, where they were asking about Jeffrey calling, Mr. Williams calling, speaking with Mr. Thomas, and then he's saying, no, Woody called Shell Kell, though. And those are very specific instances. And I don't know that I don't know what his source of knowledge of that is.
Okay. All right, so hang on. 1 through the beginning of 5. Ms. Love?
So there have been, assertions regarding this call and, there have been assertions.
Okay, so is any of the assertions that there's evidence to back up the assertion suggested in Investigator Underwood's question on about what Thug did? I know that there were suggestions that Nutt might have tried to quash something. Is it just pure speculation that if he did in fact do that, that Thug said F you?
I don't object to that kind of.
Okay. All right, so 1 through at least 4, the answer no is out by agreement.
And thank you to Praying Grammy Pammy for the super sticker. Good to see you. And Marcus Miller for the 2. You've got the goose, the ducks.
All right, what about the rest of it? Beginning, Woody called Shell Kell. Nutt's hanging with Thug. And Nutt really doesn't get involved with this.
Your Honor, my major opposition to this is well, I'm going to defer to Mr. Adams on this if he has a problem with it. I don't really have that much of a problem with it.
All right.
Neither do I.
Okay.
Okay. Then the objection to 129 line 4, beginning with Woody called down through 19 is withdrawn. Thank you. All right.
And, Your Honor,
Yes.
I would endeavor to establish a foundation before I made any kind of proper or ask flat out that kind of question.
Okay. I mean,
As with the rest of it.
sounds good. Okay, moving to item 71, page 235.
And then this was earlier from FFS. I smell more Brady. I do think the judge and the state, they had a save there with that name and phone number for Boyer, for DeMarco Boyer. But that disclosure, man, that warning was, it was funny, but it was harsh. Just 0 more chances. This is it. All the ducks, the ducklings, and someone in the chat said all the eggs. So thank you so much, FFS. Recused Judge Glanville says, Adrian, get out of there fast, fake a heart attack.
Okay.
This is where I think I have a problem. And I know that in some ways this answer is helpful to Mr. Williams. I don't at the Mr. Zachary, he's saying he doesn't know.
Yeah.
And who killed Donovan Thomas when it comes back to it. He's saying what he heard from Demekion Garlington, but then in a conversational, the way we all have conversations, he puts out a hypothetical. If you're talking about Jeffrey Williams, if your circle kills somebody, they're going to think you or that all of them together. So,
Yeah.
and the hypothetical, if your circle kills somebody, I don't think it's appropriate to have that hypothetical thrown in there because it assumes my client's guilt.
Ms. Love?
Your Honor, this is two things. We're talking about a circle, we'd argue he's describing a group. He's acknowledging the existence of an association. And he's saying these words to the police after he is, according to him, told that two of his group have caught someone down bad. And he's essentially saying, if your clique, if my gang, calling it a circle, but they also at various points throughout and the earlier interview, they referred to it as a gang in 2015. If my gang kills somebody, they're gonna think that all of them be together. So he's acknowledging the association, and in it, he's speaking on something that defendants Kendrick and Stillwell, according to him, have relayed to him. And that's the way that he tells the police that Mr. Kendrick and Mr. Stillwell told him, we caught that in down bad. And he talks about what we caught him down bad means in the 2015. And even in this one, he talks about, I think Mr. Bailey asks, what does caught him down bad mean? He's asked during this interview, and he clarifies.
We talked about this one already. Didn't we get a ruling?
He says that. So I would argue that this is relevant, and it goes to prove count one at the very least. And that's it.
All right, so because that's just his circle, if Mr. Zachary gets on the stand and says, none of these people hung with each other, you can cross him on, well, you called these people his circle before.
Okay.
Okay, the rest of it, out.
Okay.
That's pretty important for the defense, but I swear we had a ruling on that already. I swear. And then bear the buffering card of injustice, the BCI. Thank you so much.
And the judge, my number 72 is cut off. So is it 239, 20 lines 23 through 24?
I think so.
Yes.
Okay. I didn't have any objection to that. That was the one that
Okay,
that's like 70.
all right. That is. $72 out by agreement. All right, moving to 245 through the top of 240, the very top of 247. Bless you. Miss Love.
So
seems inappropriate to come in.
right now, yes, right. there's obviously going to be discussion about what he's given and all of that. But right now, I agree. I don't have any objection.
All right.
To that.
Thank you.
But up to, and I'm just not objecting to all of what's on actually lines 1 through 18, because when he's asked.
Wait a minute, 1 through 18 of which page?
245. Because that whole conversation up until that point is about who's going to jail, what time you should get.
Okay.
And all of that. But at line 19, when he's asked, do you realize how much you contributed to what's going on?
Okay.
He's acknowledging some things.
Okay.
I mean, he's pled guilty to these charges. I mean, I don't really foresee him.
Okay, well, this is only if he says, I had no involvement. Then if she presents the guilty plea and he says, I only pled guilty because I just wanted to get out of jail and I had already served enough time, then she can say, well, I mean, it's also because you actually did them, huh? So under that circumstance, 19 through, 245 line 19 through 246 line 1 would be okay.
I think it's helpful to the defense to be able to ask that. You did this because you just wanted to get out, because we've heard that with other witnesses.
Lines 2 through 14, depending on how he testifies. So, Mr. Zachary at first pushes back on the getting guns for them, but he was also convicted of straw purchasing.
Yeah, and he's busy saying, yeah, I did it. I was young and stupid, but I did it. So, okay.
So actually it goes down to 18.
All right. So that's 3 through 18, potentially.
Yeah.
Okay.
And I don't have any objection to 19 through 25.
Okay, so 19 through 25 out by agreement.
And then thank you, Waki. I think this is a fair perspective, and obviously we have to wait and see on certain
So would that
rulings.
go all the way to line, okay, so through 247 line 2. Okay. Thank you.
Yeah, she has to start from the beginning, and I think that really goes to Bruce Harvey's motion about mid-trial substitution of a trial judge and why you can't really know the context of how we got here. So she may let some things go, but just one time in front of her. 0 more chances. So thank you so much again.
In Your Honor, 74, the next one is would fall under your previous rulings about Demikion's statements
Okay.
to Mr. Zachary.
Okay. So on that same basis, that part would be in. So now we're looking at 249, line 22 through 252:15.
So Nancy knew. Does anyone remember if the state said who they plan to call after Zachary?
I don't have any objection to 22 to 25 on 249. through 15 on page 2.
Was that just another co-conspirator statement, or is it actually third in line?
This is just a little clip that I want in, and it's just not gonna play well trying to get in that one. Demikian's your boy, it's. not
Yeah,
gonna-
okay.
all that.
All right, so it goes all the way
Okay.
through, at
I
least the
think so.
objection goes all the way through 252, line 15. So let me know about 251 and 252.
Consensus is Antonio Sledge is third in line.
Now, 251, again, only assuming that, you know, he makes some assertion that makes the fact that he's sitting right there with his attorney relevant, I mean, he's doing a proffer.
Okay.
Um,
Okay, so
and
if he gets on the stand and says, man, everything in that statement y'all coerced me into, then you can say your attorney was right there.
there's no reason, I mean, I don't,
Okay.
absent of reason, I don't object, absent.
All right. So it, but otherwise, you are good with. Okay, so what about all of 251? And then on to 252, line 50. Which may,
All of it, rethinking how I was looking at it, I don't have.
okay, all right. So that is out by objection with the one caveat that if he says, you can't believe any of this because I was being coerced, then we can say, didn't you have an attorney with you? Okay.
And also, Judge, I'm not, there's a portion of 252 that wasn't objected to. I haven't voiced to the court the two areas that I would argue need not come in. Because I think that we should, for clarity, just go through what has been requested by the defense, but I'd like an opportunity to just.
Okay, so we are now at the end of the defense's requested redactions, exclusions as to this statement. So if you think that there are things that the state believes should not come in, now would be your time to present those.
So, actually, that part that I was going to say, that part is already, I don't have any objection to the 252 up through line 15. That was actually.
Right. Got it.
And I think this is a great point. So thanks again, Nancy
And then
New.
so-
Probably be here Friday afternoon based on things that she said, but she has that appointment in the morning. So she didn't want to bring the jury in for a half day.
The part that the state had concerns about it were page 205. Page 205, where Dennis says, who you believe has something to do with it? Just Rudy by himself? And Zachary says, yeah, think about it. And then Dennis says, but they had to know what is their motive, what would be driving them to participate in it, and Zachary says, Rudy. Essentially, now it's him saying, I think, despite what Mr. Kendrick and Mr. Silva have told me, I think this. I don't have I would argue that it is a false assertion, and understanding it is an inconsistent statement with what he has said earlier. One could argue that it's admissible, but just because he's saying, he's asserting that it's speculation.
I don't follow you. Are you saying that 205 lines, I guess, what, 4 through, I don't know, 1 through 23,
No, it was
7, I don't know,
through-
11, okay. Well, 11 starts with by itself, so there has to be some reference to Woody before then.
9.
Okay. And maybe the indiscernible part on 8 is where he mentions Woody. You might want to go look back and look at that or listen to that, but okay, so he's saying, Zachary is saying, I think this was Woody.
Let me
The judge knowing more than love once again.
And if the others were participating, then it's because, you know, he got good talk with them. So when would you be planning to use that?
I wasn't, I think I was, the court. didn't-
You want it,
Yeah. I was-
you want it out.
Yes, that's what I was saying.
Okay, and why?
It wasn't addressed and I was saying that it should come out.
Okay, why?
Because he is asserting that I'm just speculating. I don't believe he's,
Where is he asserting that I'm just speculating it?
when he says,
Oh, who do you believe? Okay, so this is like, here's what I think. So I mean, yeah, it's relevant if he's saying these two people told me that they had involvement.
that's where I was.
Yeah, okay, so I'm thinking this is not redactable unless, yes, okay. Any other parts?
No, that was,
Okay. So we've gotten through the April 13th, 2017 transcript, that interview with Mr. Zachary. Let's take a
One down.
bathroom break. Be
She said,
back
please.
in about 12 minutes at 3:30.
yes, ma'am.
Okay.
And no, not Nelly Furtado. Nelly the rapper was arrested for ecstasy possession and having no insurance. So, I mean, yeah, the insurance question, like, come on. It's not something to play with. They'll get you on that if you let them. Oh, so it's older? All right, I'm late. I just saw it now. No, not Nelly Furtado. Nelly the Nelly. Shout out to Nelly Furtado too, though. That's not meant to be shade to her. Yeah, Dad had said earlier, telling him how to testify so you can impeach. So speaking back to Kenneth Copeland and looking at those transcripts has to be misconduct. I want case law on if they can pick and choose which lie they charge him with perjury. And that's the thing, like they're saying that they know one thing would be a lie, but if the supposed evidence that they know Kenneth Copeland wasn't there at the time that Donovan Thomas was killed is cell phone data, but there's case law saying that cell phone data isn't a reliable indicator of whether or not the person who owns the phone was actually in a location while the crime was being committed, then what? So, appreciate you, Yedat. I don't know how the state's going to try to argue that when push comes to shove, or if Woody just gets on the stand and says, I did it, I did these crimes, right? Like he tried to show them in the ex parte meeting. He seemed to want to say it in open court, if you ask me. I'm sure he would say the same thing in front of a jury. He's on the record. So thank you so much again. Nancy New, thank you for your support. Sorry I got to you late. And also, you had this other part here where you mentioned, whatever this judge decides, she won't decide while Weinstein is not there to argue his point. And remember, Judge Whitaker has given compliments to Doug Weinstein. Doug Weinstein has a sense of humor where he kind of humbles himself down and lifts up his colleagues is part of his humor. But Judge Whitaker has actually praised Doug Weinstein for his written arguments. So I think this is a great observation that, maybe we're not addressing certain things because Weinstein's not there to lead the way. Although the guy sitting there, I still don't know his name. I don't know if we've gotten his name mentioned out loud. If it did, it went over my head if we heard it. But he's jumped in on to make two different arguments. I thought he did a good job. Tanika Battle says, why does Judge Whitaker, give them so many chances? Sheesh. And it's so funny because this was from a bit earlier, but it seems like it applied a bit more recently. Lemuel for the 199 with no comment. Appreciate the love. Recuse Judge Glanville. An opportunity to see Judge Glanville's tatted face on the screen. Now, folks, despite how this currently looks, thank you so much. And by the way, he clearly ran to Canada, because this is Canadian money here. Catfud says, come on, Judge, it's BS at this point. Enough warnings. And do you think zero warning really means zero warning? Or if next time we'll hear, that's it, 0 more warnings, no more. And then we keep hearing that repeated. Miss AB, they rushed to put this case together. The DA office is still investigating. Good job to whoever gave the history of past warnings. Yeah, that was Mrs. Westmoreland. I really like listening to her. I hope we get to hear more from her, but a lot of the stuff, especially what we're dealing with today, it seems to be centered heavily on Shannon Stillwell, so of course we're going to hear from Shardt a lot. But there isn't really so much that we've needed to hear argued by some of the other co-defendants in these evidentiary issues relating to, Kenneth Copeland's jail calls, and then also now with Zachary's statements. So thank you so much for your support. Shout out to Esquire and T So Dope for becoming members. You guys remember the Mario Karts, you can choose your racer. Danielle says, if I'm Steele, Harvey, or Bots, I'd be asking Whitaker for a refund on the fundraiser I sponsored for her re-election. This is painful. So it was Bots too. I remember the other two. But yeah, I don't know. It is painful. It's frustrating. I think, to Harvey's point, it's this mid-trial issue. But unfortunately, to flip your perspective here, I do wonder if Whitaker was there from day one, there might not have been this issue of what Miss Westmoreland was getting at. It's over and over and over, and in all fairness, Judge, you haven't been here. But maybe that wouldn't be the case. Maybe it would. But I hope she makes good and fair rulings as we continue. I am enjoying seeing her chastise the state. I don't think the state will learn, and I think they will put themselves in their own hot water, especially if Judge Whitaker is true that this is the last warning. So I appreciate your support and commentary, Danielle. And then Gwennon says, the defendants and witnesses in her court have names. She keeps using gang names. It's prejudicial. I agree. The jury might not be there, but I have a problem when I start referring to people a certain way. And now, like, for example, when there's like more than when really any public video that goes online, I don't want to just start talking about somebody with their real name to tell a story, because I don't want to put that person in the public view. But if I'm used to calling them by their actual real name, and maybe I see them pop in the chat and I'm not used to looking at their username, my brain wants to use their personal name. It's really hard to unstick something like that. So even though the jury's not there today, the more she keeps saying Thug instead of Jeffrey Williams, it might be more innate. It might become more ingrained for her to use these names that could prejudice the defendants in front of the jury. So I agree with you. And even though it might not literally be relevant right now with the jury not present, it's just one of those things that it's reinforcing a habit that could get it tripped up, and she could be calling people the wrong name when the jury is actually present. So great point there. Thank you so much. And then SQL Knowledge says 0 chances, maybe 0 chances. Yeah, that's exactly it. Will we get another 0 chance next time something happens? Could be today we find out something more. Who knows? And then Rick Reese, so nice. So for $49.99, Rick Reese says, thank you for all your hard work, Kat. You are so welcome. I am so glad to be doing this. You know, you guys know I like being in the chat as well, but it's really awesome that we can we can have this chat going. We can say, wait, who's next in line? And the chat's like, it's Antonio Sledge. And maybe I saw Drea had commented that it's actually going to be it looks like a police captain might come in as a witness, then Zachary, and then Sledge. So technically Sledge might be fourth in line. But it's great, great, great. Even the funny moments where today you guys with the buffering image, I think J Capo T started that. But that has been hilarious all day with the chat. So you guys make it so enjoyable to have like a 9-hour block of time doing this. So I appreciate you, and I appreciate you so much for your super chat, Rick. Resist Impulse says, Woody's attorney should argue to the release of contempt upon the state resting their case in chief, because that is the point when he can no longer purge. Great point. And to be fair, that might be the bulk. So say the trial goes until April. The bulk of that time might still be the case in chief. But still, if you can get someone out for, 2 months earlier than you would think, because, hey, there's no need to purge themselves because nobody plans to call this witness again. There would be no more opportunity to try. That's actually a decent argument. I think that'd be interesting to make and see what the judge says. I don't know if there would be case law that hones in on that point. But what do you guys think? Like, if April, I think March and April were floated around today, that 30 weeks, I think Woody might do it. I think he might do it. What do you guys think? Thank you so much, Resist. And then Nancy New says, do you think these lawyers will open a law group? Can you imagine if you had like a law firm that was like Steele, Shardt, Adams, Harvey, who else we got in there? Matthews. You just lay them all in there. Westmoreland. Westmoreland is a nice name to have on a building, I think. So we got to get Westmoreland in there. All these great names. I don't know if they'll do it because they might be established in their own practices. Bruce Harvey might be getting close to retirement. Botts might be getting close to retirement. I guess I can't just judge by looking at them. I shouldn't just assume. But they might have their practices well established already. But wouldn't that be cool if they all formed together? The dream team. Can they call? But who would he rebut? So that's the thing. Who would they bring in Copeland to rebut? And that would really be hilarious, though. They bring in Woody to challenge what somebody else said, but Woody's credibility is completely shot. So I'm not saying they won't try it, Don and Doodle. I hear you. But my commentary is about the logic of the state and how that would probably backfire on them anyway. Yeah, General Westmoreland sounds cool. The defense has been largely quiet today, but I think, these statements, they're still subject to foundation being laid for the most part. I think they've gotten significant parts excluded, and there was a part that the state wanted redactions, and the judge said, the state was making the argument that they wanted something, and the judge just ruled against them. It sucks sometimes because we're not hearing what the actual statements are. We only get the context if the context is given through the arguments. So I can't really say like, ooh, that's great that they're letting that in, or that's not a win if they're not letting that in, because we don't always get to hear exactly what it is. But it has seemed to kind of go both ways today. And then, thank you guys in the chat. Speaking of how great the chat is, you guys hit 2K likes. That's amazing. And you guys had shown so much love to Drea for her birthday coming up this weekend. That was also really nice. And I also loved that interaction about all the popcorn flavors. If the jury's watching and eating popcorn, what flavor are they eating? Yeah. If I'm ever on trial, you can use my street name. You better use my street name. Put me on the record as kattnotwilliams. Harry says, is she waiting for to have the jury back before she can declare a mistrial? Now I thought people give this idea. Well, what if she wants to poll the jury and kind of let the mistrial call rest on whether the jury's been tainted. Maybe they've seen stuff they shouldn't have seen. And that way she can call a mistrial based on the jury's exposure. Or maybe the jury comes in, they're like, 3-4 of us can't do this anymore. Now we don't have enough jurors to keep going. Maybe she could use that as a reason to call this mistrial without having to give one of the other reasons. So I think that's a great question. It might be. I think I do want to not just completely write someone off as ignoring the legal questions in front of them, the things that are in front of her, on her plate for her to make a decision and ruling on. I still think, I hope, even if I might disagree with her rulings, that she at least goes through the ruling instead of completely waiting and hoping that there's something out of left field that removes the responsibility from her to make a harder decision. So I definitely hope she tries to make these rulings, but I think the jury, this is a trial of attrition. It's a big ask to have these jurors sit around for so long. They've been on break for 2 months. You want them to come back and continue doing this through April for $25 a day. Like, come on. Julie says nothing would surprise me at this point. And Legally Brown Girl, good to see you, says they all have well-established law firms, but they are the most for real dream team. Yeah, that would be like one heck of a building placard. They run a close second to OJ's dream team. Now, but with OJ's dream team, they were already working with each other before that? Or did they start a new practice and combine after the OJ trial? I didn't really follow where everybody came from. Yeah, and I agree. How do we expect the jury to not see this? It's just so unrealistic. And Torres says, Judge Whitaker has shown that she really wants to try this case. I hope she keeps her word in sanctioning the prosecution. This is disappointing. Yeah, and it's like, honestly, guys, I don't think it'll take too many days for the state to do the same thing that she's told them, this is it, no more, don't do that. I don't think that it'll take very long, unless Adrian Love, wakes up, has a renewed sense of self, totally approaches this case better, and can just get it together, which I don't see that happening. I just personally don't. My opinion. I think the state's going to walk them right back into the same thing that Judge Whitaker's saying, stop doing that. So thank you so much for your super chat. I don't know, but I do feel like if jury duty pay is taxable income, $25 a day, that's gotta fall below, the standard deduction. Yeah, the oh shoot was crazy. We're gonna get another oh shoot within, before Monday when the jury's back.
All right, before we
Okay, it is taxable.
dive into what I think is going to be our task for the rest of this day, which is going through the other statement, I don't know what date, what is the date of this?
August 5th, 2015.
Okay, the August 5th, 2015 statement of Mr. Zachary and potential objections to that. Is there going to be a 4:30 to 4:45? Hey, Judge, guess what else happened? Revelation.
You said bombshells. Where are they now?
So go ahead and tell me now.
Atkins.
I'm going to think
That is not a disappointment. Okay, so where are we on, and I know we've got all day tomorrow. I don't know if I have told y'all or not, Friday morning, we will not be in session. I think I mentioned that I had a conflict and that I just didn't know with regard to Friday afternoon, and we probably will make that call a little later. I mean, hopefully we can have a really productive day tomorrow and we can have Friday off from active court. And then have the jury on Monday. But I still need from y'all, if you want some kind of a 105 limiting instruction, that contingent type instructions for our various scenarios we might face depending upon Mr. Copeland's Monday morning decision about whether to take the stand or not. And then if he is going to take the stand, I think y'all had said everybody's happy with, well, not happy with, but everybody is in agreement that what he then said on June 7th, 10th, and 12th prior to the motion to recuse is fine and is in. So with regard to after the motion to recuse, and it sounds like, honestly, there was kind of almost a clean break with regard to prior to the motion to recuse, he had not really gotten into any of the testimony concerning the Donovan Thomas murder or questioning about that. And of course, honestly, I bring notes up and then I don't know what happens to them.
So they're not striking all of Woody's stuff and having him start over, unless they're about to argue against it. Maybe the state will argue against it.
I know. And that, does everybody agree that basically, I mean, I think it was like on the, I don't know, because I wrote it down, now I can't find it, but that none of that was before the motion to recuse. Everybody agree with that?
I agree, Your Honor, there was definitely a clean break.
Yeah.
And the majority of the days after the motion to recuse consisted of
Playing his January 22nd and his February 10th statements, right?
yes.
Okay, so let me ask you this. You disagree? Okay. What's your recollection of it?
There were questioning and
There it is.
the video audio of the early morning hours of January 11th, 2015, recording with Detective Thorpe, Thorpe, and Mr. Copeland was played in its entirety for the jury before the motion to recuse was filed. And then there was a second audio video, January 20th, 2015, that was also played. That day.
After. Did you say January?
Yes, it's hours after the God forbid killing. The killing is January 10th,
Right.
7:22 p.m.
Uh-huh.
in 2015. Early morning hours of January 11th, Mr. Copeland is with Detective Thorpe.
Right, and that got played after. And then what was the second one you said?
January 20th. I'm going by my memory.
January 20th, not February 20th.
Well,
Okay.
no. There's maybe January 21st. There's a 2 in January, 2 in February.
Right.
1 in.
Well, anyway, whatever those two statements were, somebody can go back in the record and look. But that was most of what occurred afterwards.
Before the filing of the motion to recuse.
Oh.
That's what I'm trying to
Okay,
articulate.
all right.
There was discussion of Donovan Thomas before the motion to recuse. That's why I wanted in. There was a lot of exculpatory information.
Okay, so y'all can agree to whatever you want to agree to in terms of things that are before the jury post recusal motion.
This is pre-recusal motion. That's why I wanted it.
Pre-recusal motion.
Yes.
Okay.
I thought she was fine with that.
I think, Your Honor, there's no, we don't have differing opinions about pre-recusal motion as long as
Yeah.
he continues to testify.
Right. Agreed.
So
Agreed. Yes, so whatever is, if he continues to testify, whatever has already been tackled pre-recusal is fine. And you are saying that part of that, there was at least one, maybe two videos played pre-recusal.
That's true.
Okay. And so those videos, y'all, was it like the entirety of it, or? I mean, it seemed to be most of the day's transcript was video played. But
I'm going over.
but then video was played on the 17th also, which was post-recusal, right?
Yes.
And that was maybe, I thought maybe that was January 11th and February 20th. Okay.
Yeah, I'm a little confused because I thought it seems like Love didn't know if she agreed, but she said she agreed about stuff before the recusal motion can come in. What was confusing was Whitaker was talking yesterday about like striking all of it. And Brian Steele made an argument against it. And my conclusion, the takeaway I heard yesterday was Brian Steele agreed that if Copeland decides not to testify at all, Steele would agree that all of it should be stricken. So I'm not sure if they're just having like a barrier of communication here. And I'm also probably guessing that Adrienne Love doesn't exactly know what she wants either. And then Miss AB had said, it was interesting to hear her reference, Judge Whitaker's reference to the Court of Appeals in regards to how she is handling the case. She's thinking long term, down the line. Yeah, that's really interesting too. And she laughed a little bit with apprehension when she said it, like, oh boy, I gotta think of that. And then Garrett, we gotta poll the DAs. When is their next violation date? They'll tell us they won't do it again. Don Dada says, shrugging my shoulders because they mine.
Those were played prior to recusal motion.
Yeah, now I'm asking about afterwards. I mean, I'm asking about before and after, I guess. I thought on the 17th, which is obviously after, that the January 11th and February 20th video statements were played.
I believe that is correct, and I'm making sure. That was my memory. My memory was that the full video, she played portions of videos prior to that, 17th of the last.
Right, but some little snippets, right.
But the full videos were not played, and that was what we had discussed internally, and I thought that was what we came to, that the full videos were not played until after the motion for recusal.
Okay.
And the questions that led to them, so there were questions, and then there was the playing of the videos, the ruling.
Okay.
That's true. January 11th was played, and January 11th and February 20th
Yeah,
were played on 6/17. That is true.
okay,
There were snippets before that and discussion before.
all right. So in general, in terms of an instruction to the jury, a couple of different things. All right, yes, the January 11th and February 20th videos were played post-recusal motion. The contents of the January 11th and February 20th videos are not going to change. Are y'all proposing that we have the jury watch the entirety of those again? Simply because they watched them after the recusal motion? And I'm just asking that because I'm trying to figure out the logistics. And y'all can huddle on that if you want and give me an answer tomorrow. But in terms of thinking through how we instruct the jury and how we handle this, that is an issue to be considered and for y'all to come up with an answer about, okay? And then is there, other than those two videos, however y'all want to handle those, is there other testimony, questioning and answer, testimony that y'all want to come to some sort of a stipulation about? And yes or no, either of those is fine. Just, I need to know how to deal with it. And then if no, then is the instruction going to be, was there anything substantive about the Donovan Thomas murder prior to the motion to recuse? If there really wasn't, then I can say that we're doing everything about that over again. But if there was, then it needs to be a more nuanced instruction. So y'all, I would really like those by tomorrow so that we can discuss them. And okay, because, all right, okay. And
you guys
then
keep the Brady Bunch picture.
it would be nice to have the 105 proposed limiting instruction by then as well. But I'm certainly not going to give it before I get a proposed one. So that's kind of
I thought
on
Harvey
you,
filed
Mr. Harvey.
And Your Honor,
Yes.
we had addressed in writing and will, if necessary, if the court tells us to address in writing again, that a 105 instruction in a RICO case is not appropriate, but we'll.
So if you want to you don't have to refile the same thing. Just point me to when and where it was filed. But what yes, I know that everything gets to be considered that is alleged as an overt act in furtherance of a conspiracy, a RICO conspiracy and a RICO count. What I am contemplating instructing on is something to the effect of everybody here is charged in count one. Anything you hear that's an overt act can be taken into consideration when considering whether the state has established guilt as to count one, as to each of these individual defendants. With regard to, whatever count it is. If we're talking about the Donovan Thomas murder, that evidence can only be considered as to the people charged with it when determining whatever those counts are, 2, 3, and 4, or whatever they are. So that the jury knows what they are appropriately considering everything against. I want to give a legally appropriate instruction.
Understood.
Okay.
But we did allege the Donovan Thomas murder.
Oh, I know. And so it is 100% appropriate for the jury to consider that evidence when considering count one against each of these defendants. It is not appropriate for them to consider it in terms of the guilt of any of the defendants to any other counts other than the people who are charged with the murder and the corresponding whatever it is, ag assault or gang or whatever. Okay, so that's my thought as to that. And y'all work on what Mr. Harvey is going to take the lead on, and then I'll listen to objections on and I'll formulate something. But I think that is appropriate upon request, as long as it is an accurate statement of the law. Okay? All right.
Love Mrs. Glanville right now.
That all being said, let's now turn back to the scintillating task of how to redact this statement. Laura, can you make
Elander, we still need the attorney that went viral for logging into the Zoom court hearing with the cat filter. We could put in the animated character that Flesh of the Gods made for me with the cat ears. And just have him show up as like a VTuber.
Ms. Love, I asked for my stapler back, Mr. Atkins, and it is not back yet. So I may not land it to y'all again.
She wants to be the one to give it back. She said no, Atkins.
Thank you for letting me borrow it, Your Honor.
Okay. All right. Everybody ready on our August 5th, 2015 statement that we need to get through? I'll take the silence as a yes.
Yeah.
Okay. All right. All right. So, Mr. Shardt, if you could do us the favor of making your proposed redactions another part of the record somehow.
Would you like me to put like the heading, the title of the case and style of case on it?
I mean,
make it look official. I didn't file them in, obviously. But-
you know, it can just be a notice of filing, and you can do a cover that says notice of filing of, you know, whatever, and then just attach this. Is
Yes,
fine
Sean.
with me. I'm not really that particular about how it gets done. I just want it to be a part of the record.
Yes, Sean.
Okay, thanks. All right, item number 1, page 24 is where we start.
So, Your Honor,
Yes,
in regards to the state's position here,
yes,
it is not, we are introducing this kind of like what the court alluded to earlier.
Mhm.
It is important that the YSL members believed it was Ifgane. Whether
Right.
Ifgane actually did the shooting or not, what happens immediately after this is
okay,
they get in the car and go and do retaliatory shootings.
right,
So it's the fact that they believed it was Ifgane, whether in reality it was or not, which came from Summer Good, who is Cordelia Zachary's at the time girlfriend.
okay. Oh, and let me ask, actually, are there any of this list of 43 items that the state agrees should be redacted?
Yes, Your Honor.
Yay, tell me what those are.
Your Honor, I'm going to it. I know off the top of my head, there's one that references the Sandy Springs search warrant of defendant Williams' house, that's out. I'm trying to figure out what number that is.
Okay.
Yeah, Miss AB, I think this is exactly how the defense feels. And thank you so much.
Mr. Shardt, do you happen to know which item number that was? Sandy Springs search warrant? Are there more than that one?
Yes, Your Honor, there are.
Okay.
There's also one where, and I'm finding this number, Your Honor, but there's a line where Mr. Zachary says that defendant Stillwell is hot-headed. There's a part after that, but the state agrees that calling him hot-headed,
Okay.
the state would concede that. So I'm going to I have this in order, but
Okay,
I didn't
so
separately draw out which ones.
it's fine. I guess just then, whenever we get to it,
Yes, Your Honor.
you can say, before I read it and Mr. Shardt argues, just say, okay, for that one, we agree.
Thank you.
All
Your
right.
Honor.
The first one that Mr. Atkins was referring to is number 34 on my list, I
Okay.
believe, which is 149 page 149, line 19.
Okay.
That's correct, Your Honor. Thank you, Mr. Shardt.
All right, perfect. Okay, so back to number 1 then.
Yes, Your Honor. So as articulated, the state's position here is it's important that they believe that Ifgane was who shot at Demekian at Club Crucial, because after that, Quadarius Zachary, Antonio Sledge, Demekian Garlington, and defendant Stillwell, they get into a vehicle and go and shoot 1428 Adele Drive, 1903 Drew Drive. And so it's in result of if gang shooting at them. So I see the objection is hearsay about who did the shooting at Demekian at the club. And so the state's position is it's the effect on.
Right, you're not offering it for the truth of whether those people did the shooting. You're offering it for this was what this crowd believed.
Yes, Your Honor.
All right, any response?
I believe that it's hearsay. Mr. Zachary was not present. I heard what the state said. My stance is Mr. Zachary was not present at the club when Demekian allegedly got jumped, and he wasn't outside the club when shots were fired. So any information about what happened outside the club that day was something that Mr. Zachary does not have firsthand knowledge of.
All right, and so essentially 24 and 25 relay a lot of, I guess, details about who did the shooting.
Yes.
Yeah.
Outside the club earlier that night.
All right, so and again, all of this is if he, if you have to impeach him because he is not testifying as you thought he was going to consistently with these interviews. So if you are then impeaching him, and your purpose is, hey, at that time, you told us, it needs to be phrased in a way that what you're impeaching him on is not A, B, C, and D people committed this. It's you thought at the time it was this, right? And so I don't even know that you need to go through 2 whole pages of that to accomplish that.
Yes, Your Honor.
Okay, all right,
Understood. And agree, that's the state's intent with this portion.
okay.
Corey Harris got his license, you guys.
And y'all, I'm making all of these rulings prior to us coming back with these witnesses on the stand in hopes of there being an understanding by everybody what comes in and what goes out, and us not having to take it up while the jury's here. But if for anything, at the time we arrive at it, it looks like, okay, this is not what we agreed to, or this was not my understanding, don't just sit mute. I mean, raise it to me and say, remember, Judge, you said he didn't need to get into all of these details. It was for the purpose of, y'all believed at this time it was IF, okay? Y'all are on notice of that, okay. All right.
So, Your Honor.
Yes.
The second one, this transcript is very incomplete. So
Yeah.
could I'm sure Your Honor can flip to the page, but it's probably not going to help. May I convey what I believe?
Absolutely, and that has been helpful to the extent that both sides have done that so far. And from the portions that I have listened to with the transcript in front of me, watching the videos, yeah, I mean, the transcription is less than stellar. So yes, please do. Please continue to do that.
So on page 48, line 7, Quindarius Zachary says, and he and Thug, like, nah, I ain't cool with the N-word until they pay for my window.
Okay. Until they pay for my window.
And then it says woman, and I believe that's Investigator Gaither says, but why they shoot up the dugout? And then Mr. Zachary, Woody and Cal had something personal going on, I guess, who was big and bad. And my objection is is with the statement that Mr. Williams, according to Mr. Zachary, said, nah, I ain't cool with N-words until they pay for my window.
Okay.
I don't have any understanding or belief that Mr. Zachary had any firsthand knowledge of any conversations that Mr. Williams may or may not have had with other individuals about this subject. And I think he's just passing on information that he's heard.
Your Honor, the state's response here. So just to give a little context to Zachary at this gambling house, Zachary says, I was inside. I didn't have a gun on me that night. And the way he says it in the state's opinion is that when defendant Williams walks outside right before who they later go on to believe Kelvin Watts, Shell Kell, shot and broke his window, that he kind of comes outside afterwards. I mean, so
He's Zachary?
Yeah, Zachary's inside when the shooting happens. So he's not physically outside. He doesn't like spot Shell Kell in the bushes and say, oh, I saw him with my own eyes. But it's kind of the state's, with the way he describes it, you know, he walks outside soon thereafter because he just heard a bunch of gunshots. Right. And I think it's reasonable to believe that, you know, they would all be discussing, and he kind of alludes to that, like going to the parking lot, and there's a lot of broken glass and bullets. They don't immediately know it's Kelvin Watts, but at the same time, the state believes that between either excited utterances of people out in the parking lot after this shooting that hit multiple cars and or speaking with fellow co-conspirators, what he says here, and this is relation to something else that comes up down the road where a female who Shell Kell ends up confiding in, Zachary classifies it as flexing, like bragging about doing the shooting. Right. That's how they end up believing or thinking that he did that, to confirm that. So when he says here, you know, he's explaining about defendant Williams' reaction to the window being broke, I think there's reasonable assumptions, I believe, that given his personal being there, interacting with these individuals on a regular basis, and also the key part that Kelvin Watts is the half-brother of the deceased Donovan Thomas. And so I'm not saying that the murder of Donovan Thomas was 100% related to this broken window, but it is, you know, relevant in that sequence of events and escalation of shootings in the state's position. So with all of that said, the state feels that this is not as speculative as it may first seem.
All right. And you've got evidence somewhere else that Zachary walks outside while the, you know, aftermath of it is still going on?
In this interview, Your Honor, he ends up saying, so everybody's walking him to the car, him being defendant Williams, then hears gunshots still going off. And so he says, I'm still gambling. I didn't have a gun anyway on me. So no sense walking him out there. So Zachary tells the police in this same interview, I was at the gambling house. And then he says, then gunshots go off, and then everyone runs out the door. Everyone in there with guns ran out, started shooting. So like he kind of alludes to, after this gunshot, everyone in the house ran outside to include himself.
If he says everyone with guns ran out, that does not include himself.
Yeah.
If he just said he didn't have a gun. So is there something more?
So, Your Honor, he also goes on to state that a bunch of people he's inside the gambling house. He said he posted a bunch of pictures, Instagram photos, and he says, when the windshield got shot out, did they confront Kell about it immediately? Zachary says he didn't know because they didn't initially know. They have to find out down the road. And so I'm trying to find where this is in terms of, he says, you all come outside. Zachary says, I didn't have a gun. And so there's other, I guess, evidence, so to speak, in some of Copeland's interviews, taking aside what's in evidence right now or not with what we're redacting, he describes this gambling house incident as well. And so for purposes of, in this hypothetical universe, you know, defendant, or not defendant, but Mr. Zachary is going to testify after Copeland.
Okay.
And so the state believes that with the combination of, you know, I can't find in this moment, Your Honor, where Zachary himself walks outside,
Okay.
but he does state in this interview that there was a lot of gunshots. It was chaotic. People ran outside. I think it's fair to assume he walked outside at some point shortly thereafter, didn't just stay gambling after they shot up. And he interacts with these people on a nearly daily basis or a frequent basis, that this shooting of the window is something that gets referenced by multiple
Right.
interviews.
Yeah.
So it's the state's position. I don't have like a definitive piece of evidence where he's like, this is exactly how I know, but I think it's reasonable to think that he would have a pretty good basis for what he says in this specific clip that we're arguing about.
Okay.
And also, you know, when he says a part of this as well is Rudy and Kel had something personal going on, he interacts with Mr. Copeland, who his nickname is Rudy. And so I think he would have a foundation to know that Kenneth Copeland and Shell Kel did not interact
Okay,
well.
and I'm not even honestly sure that when he's saying that Thug says, no, I'm not cool with them till they pay for my window, that he's necessarily, that the assertion is necessarily that is what Mr. Williams voiced to anybody that night out in the parking
Right.
lot. It's just,
So my understanding, based on what Mr. Copeland has stated
right.
in this courtroom, whether it's in the evidence right now or not, there's a shooting at the gambling house. Shell Kel was not initially thought to be the
Right.
person, and then later has pillow talk, and he's thought to be the person. I agree that Mr. Zachary was present at the gambling house per his own words, but this conversation about I'm not cool with people until they pay for my window
Right.
never is alleged to have happened that night. There's a
Right.
subsequent conversation
Right.
with Mr. Copeland, and Mr. Copeland is apparently there, and Mr. Watts is apparently there, and allegedly Mr. Williams is on the phone with Mr. Copeland. That's Mr. Copeland's testimony. Mr. Zachary, to my understanding, has nothing to do with that conversation. So
Okay.
he's just passing on hearsay that he would have heard from Mr. Copeland, presumably, but I'm speculating.
Okay, well, even if it's hearsay, I think this would come in under the, what's your theory as to why this comes in? If he hasn't heard, I mean, if you can show that he at some point heard or overheard Mr. Williams saying, "Yeah, they can pay for my window and then we're cool, not until then," great.
Yes, Your Honor.
Point that out. Otherwise, it is hearsay. What would the exception be?
So, Your Honor, the exception here would be, or at least the state's argument is that, and I can't directly point to the moment in time where he believes or hears someone state, I'm not going to be cool with him until he pays for my window. What I will point out, and I will, in answering the court's question, is shortly thereafter, in this interview, Mr. Zachary says, Thug comes in crucial, throws money. Kel doesn't want him to do that. The Thug, he's not clicked with him, or it may be cool with him. He didn't like them. They shot at his window. So he later on in this interview states it definitively that like he doesn't like them. They shot at his window. And
Okay.
so the state's position is that for an exception, and again, I don't have direct evidence of which individual told him this, but the state's just given this event of the window being broken, repeatedly being brought up by either defendants or co-conspirators in relation to this, and it being a somewhat significant event that it's reasonable to believe that this is either a co-conspirator statement that was made
Okay.
or something that he has a good faith basis to believe that defendant Williams does not like Shell Kel because and what Mr. Copeland says on that is basically Kel's like, I'm not paying for the window. And so it kind of ends on that note.
Yeah.
This all
So
seems
I don't
reasonable
have
without it being gang
that
activity.
definitive moment in time, but that's the state's position on that in
Okay.
terms of Zachary making that
All right.
statement.
Okay. I mean, yeah, I would think that this could come in under 801D2. Maybe.
You don't stop searching. Don't search.
E or. Yeah. Yeah. Or A, really. Okay, so that is going to be admitted over objection. Yes.
Number 3, Your Honor, is Mr. Atkins kind of leads us to number 3, which is the conversation that he just referenced. Mr. Zachary, and you don't get this from the transcript, but he says, I'll start in the top of page 49. Zachary says, you know how they do, Kel wasn't like thug coming crucial, giving out, throwing stuff. Kel didn't want them to do that. And then Gaither says, right. And then Mr. Zachary says, yeah, Thug wasn't, he ain't click with them like he didn't like them. And then Gaither says, he ain't like, Kel shot out his windshield. And then Zachary says, they shot out his window. My objection to this is that he's testifying to the thoughts and feelings of Mr. Williams, who Mr. Williams likes, who he doesn't like, and to the mind state of Mr. Williams. I don't believe that that's appropriate.
All right, so the throwing money parts as to the incident that happened at the club.
Correct.
Right, where some people.
And for context.
Right. So I mean, is Mr. Zachary there, or does he know about that incident having occurred?
So, Your Honor, there's a specific incident reference where Mr. Copeland gets jumped at that nightclub after flashing money. But in Mr. Copeland's own, and maybe in other statements, but certainly Mr. Copeland, he kind of regularly went to Club Crucial and flashed money.
Okay.
And so they kind of referenced that Woody flashing money in Club Crucial was not like a one-off event.
Right.
And so the way I take some of this, what he's saying is, they come into Club Crucial almost every Monday or every other Monday or frequently, like to come to that same establishment where a lot of Shell Kel and his crew, which is the If Gang, and the YSL are there at the same time. So with that, I just wanted to clarify that for the court.
So who's the he that we're talking about then in 49, 1 through, I don't know, 8 or 9, where there's a he didn't want me doing that, he ain't clicking on me.
They're talking about Defendant Williams, like.
That's what I thought.
Yes, Your Honor.
He ain't clicking with them.
With.
The opposite side as
Okay,
well.
well, I mean, so that's just mistranscribed.
Yes, I believe so.
Okay. I mean, okay, so y'all are going to or have established that Mr. Zachary also has a close relationship with Mr. Williams, right?
Yes, Your Honor.
Okay, I mean, he's got a basis to know those things. So overruled.
I'm going to withdraw number 4.
Okay.
Yeah, I don't know. I would not like somebody if they bashed out my windows. So. But the jury can feel the same way.
After consulting with my colleagues, we're going to withdraw number 5.
Okay.
Okay. All right. Number 6, Your Honor, is talking about, and this came up in I think the last statement as well. They were under the belief that NBC did the shooting at the dugout, the false belief, and they're talking about why did you believe that? And he's saying because Yak, Mr. Kendricks, beat up someone at the club. And specifically on 55 line 17, if I can make sense of this transcript, they said they didn't mess with each other. They didn't mess with each other. So it was already tension in the air, but they waited until the boy Yak, he had gotten into it with MDC, and I had helped him fighting in the club. So y'all got into it, some guys from MDC. MDC is down with who? They from Bankhead. And then they say, so Ms. Gaither investigate. That's what I'm saying. It's like they not really with. And then Mr. Zachary says, if gang, and Gaither says it's just them themselves. So this has nothing to do with.
All right.
It's just bringing up a fight that Mr. Kendricks apparently got into, allegedly, that led to the mistaken belief that MDC was behind the shooting of the dugout.
All right.
So, Your Honor, the state's position with this part is it has a couple relevant portions. One being state has to prove association. And the fact that Zachary is defending, he's like, I get in the fight too with the MDC, which is the most dangerous clique, a gang on the west side in Bankhead at that time. The state's not going to be belaboring the point about this one fight and trying to cast anything improper character-wise or what about a fist fight in a club. But the point of this is that they defend each other. And that's a big part of the retaliatory shootings. This is a fist fight, but the fact that he jumps in and protects him, and also the way he describes this in the state's position is, he says, like Detective Gaither, Zachary's like, they're from Bankhead. And Detective Gaither's like, that's what I'm saying. They're not really with If Gang. And Zachary says they're just their self, like they're not a part. So he has some familiarity with street gangs and who is clicked up, so to speak, with who. And so the fact that he's talking about and he's saying like to me, there's a we and an us. There's not much else that I've seen in this case file about MDC, but that part is important.
Okay.
Another part about it that's contained in this, I believe, is this gets down the road to where how they learned that Shellkel was the one who claimed or did shoot Defendant Williams' window. And so he says he ran his mouth to a female who goes by Gucci Red. And so again, the key part of this is that's how they end up believing that Kelvin Watts did the shooting, because they initially thought it was MDC because of this fight. So the state believes this portion is relevant for a number of reasons of why they initially thought it was MDC, the association between Zachary and Kendricks, and also there's a part, at least if I'm reading the page 55, line 17 to page 57, line 7. My apologies, Ms. Madam. To page 57, line 7 includes what on its face seems hearsay. Like they learned about this from this female, but it's it's important that they believe it was Shellkel who shot the window.
And I think we've made the decision as a defense that we're not going to fight the hearsay about it being Shellkel and how that eventually came about. And that would be on page 56, line 10 to 19. He's saying that they found out it was Shellkel because he was running his mouth to Gucci Red. He says pillow talk and junk. So I don't have a problem with that section. I just don't know why we need to get into Mr. Kendrick's apparent simmering feud with completely unrelated people that led to the false belief that it was the most dangerous clique as opposed to shell cow. I mean, we can just get into the fact that they know it was shell cow now without going through that whole misapprehension.
Okay, so, I mean, it is potentially relevant, and again, this is only if he testifies inconsistently, on the issues of, as you represented, what you think it's important for is that, hey, we all defend each other. We hear X, Y, Z, and then that's good enough for us. We go back our boys. And what was the other thing you said? I mean, I think it can come in for that. And then, you know, as to, they've withdrawn the objection to how they end up finding out it's somebody else. So, okay? And so, again, as I said with regard to the very first one, and this does not mean that you then have license to play these whole 3 pages. You just need to make the point in the part that would make that point, okay?
Understood, Your
All
Honor.
right. Okay.
I like Atkins more than Love.
So
What do you
turn
guys
into
think?
Item 7 on page 59.
Not that I like him, but I'd rather
This is,
listen to him.
Them talking about the dugout shooting and them finding out it was shell cow. So I'm going to withdraw that.
All right.
I know. I think, JC, thanks so much. I think Atkins is just handling this, what is it, like August 15th, 2015 statement.
All right. Item 8 is bottom of 60 through middle of
But-
64.
But it's funny. Were you here? Were you watching when the judge asked for her stapler back that Atkins had took? And Love
I mean,
snatched
give
it.
me
She
just a
wanted to give it
second
back.
Take a look through that.
I forwarded it to you. All right, hold on. Okay. Just sent it.
And then right in line with this comment here about, did Love get fired? Recused Judge Glanville had said, what's the bet Hilton ain't never coming back to Georgia? She knows the mess Love and Atkins are dealing with. Imagine coming back like, what'd I miss? Oh, Steele filed another motion. Oh, there's still pending motions for a mistrial.
Your Honor, this may be a portion that, if the court has any questions, listening to it may be of assistance, because there is some
There's a lot.
scribbler's errors a lot in this portion.
Okay. Do you have it queued up?
I am, Your Honor. We're getting queued up right now to play.
Yeah, we get to hear
general
something.
proposition, this is my understanding of what Mr. Zachary is saying.
Speak into your mic.
Mr. Zachary is saying throughout this process that my client told him some information.
Okay.
That information included 4 people that were in the car. That's what Mr. Zachary is saying. Mr. Zachary is also saying that Mr. Kendricks said something to him, which was that involved the 4 people in the car, according to Mr. Zachary. Later on, he goes into more detail, and this is starting on 63 line 8. He goes into more detail about an entire story involving cars and cars driving by the Texaco, and spotting Donovan Thomas and switching seats with Bushi and all those things. My understanding is Mr. Zachary is saying his source of knowledge on that is Mr. Garlington.
Okay.
So my objection is that anything that didn't come from my client would not, I understand statements by a party opponent as it applies to my client. If he's saying my client said something to him, I understand that, and I'll deal with that through cross-examination. But regarding things that Mr. Kendrick supposedly said to Mr. Zachary, or that Mr. Garlington supposedly said to Mr. Zachary, I'm objecting as on hearsay and confrontation clause grounds.
All right.
Your Honor, just to kind of give the court the state's position, there's no confrontation clause issue because it's not testimonial, but to go to, so the way, and we'll play this, before he gets into this portion, they ask him, who told you? He says, Shannon and Yak is defendant Kendricks.
Okay.
And then he just kind of
Hi,
goes
everyone
into
from the
after
TLA
that,
and AV
they're like, why'd they
stream.
tell you?
It's good
We were
to
at
see
the
you
house
guys.
talking about it. And for the next, couple minutes, he just starts providing details. So it's not
Right.
exactly clear.
Right.
But also what's important, Your Honor, is he also later on in this interview, and there's some social media that backs this up, that Mr. Zachary, defendant Stillwell, Kenneth Copeland, Demise McMullen, who they call Nard, defendant Williams, they go in a Sprinter van down to Miami, Florida.
Right.
So they have some statements about defendant Williams had a concert there. The state also believes views it as some consciousness of guilt getting out of the city after the murder, because Jonathan Thomas is January 10th, and they start traveling down there January 11th. And so all that aside, the state feels that him, the night of the murder at defendant Williams' condo, them directly telling him, obviously that's a party opponent admission, but the state feels more so it's a co-conspirator statement.
Right.
To keep him abreast, they all travel together as a group down there. And then, so that's the state's position, is that this entire portion is a co-conspirator statement. It's keeping them abreast, it's cohesive, and he needs to be aware, because what happens that same night is if gang members and their associates start shooting YSL houses up. And that obviously escalates.
All right. And I think that my ruling with regard to this piece of the statement is the same as it was with regard to the similar statements in the April 2017 interview or statement. And that is that these are statements by a co-conspirator, and I believe sufficient evidence that they're during the, in furtherance of the conspiracy and still in the concealment phase. So I'm going to admit those over that objection. And with regard to the confrontation clause objection, these are not testimonial as made to Mr. Zachary.
The lead attorney spying printer sent you guys. Welcome to the TLA chat. It's really cool because I love being over there and obviously can't be there if I'm
item
live.
9.
So now I feel like I get the best of both worlds.
Item 9
Super
honestly
awesome.
would fall under the same
Same. Okay.
ruling that you just
All right. Thank you. So item 10 is on page 66.
Your Honor, I believe this is just a single line of Detective Gaither asked Zachary, did Woody, Mr. Copeland, have anything to do with not being killed? And he says, nah. And the state, it's listed as speculation.
And based on the fact that everybody's there right after the murder talking about it.
Correct, Your Honor.
Okay. All right. On that basis, I would permit that. All right. Item 11 is bottom of 66 through mid 69. An objection is hearsay. Is this going to be the same concept or something different?
It is.
Same.
But within it, so I will, over my objection, I understand.
Yes, and I understand you still have an objection to it, but
Now, I will point out on page 67, line 18, they say, why not? And Mr. Zachary says, I don't know, they just like, I guess they just wanted for them to do it instead of Moontunk and Woody. So he's speculating.
All right, let's strike 18 and 19.
And that page.
Page 67, 18, and 19 is speculation.
And then Gaither follows up like they wanted to do it themselves.
Oh, okay, so 18 through 25, really, right?
Well, and then he says, not to get them a name. He's speculating as the reason why they just wanted to get a name for themselves.
Okay, all right, so.
I'm looking at my notes. Line 2 on page 68 says, nah, like to get them a name.
Okay. Okay, well, yeah, that's also speculation, unless you have some basis for it being something other than that.
So, Your Honor, the state's argument on this portion is when he's talking about getting a name, it's very integral from the state's position of how gangs work in terms of trying to move up in rank.
Yeah.
Later on talks about so the state believes that his quite frequent interaction, he does state it speculatively. I'll be upfront with the court about that, but I do believe that in terms of they ask him why, and the court may say, hey, Mr. Atkins, it's speculation, it's out. But my argument on this is that his frequent interactions and, there's evidence that will come out either through impeachment or some other way that he has participated in crimes with them and is familiar with who he's speaking about. His thought process on motivations or what was going on in terms of like a gang context is appropriate. That's the state's argument.
All right.
Now, I believe the state has, I know that they've called experts, and I believe the experts have touched upon people, quote unquote, the term that the experts like to use is putting in work. And they've talked about that.
All right.
The state, I'm sure, is going to argue that. So I'm not saying that, obviously they can do that, but they can make that argument. But for Mr. Zachary to affirmatively say that's why other people did something.
Sure. Okay. Let me make a ruling with regard to 67, 18 through 68, 2, that if you cannot get this in as speculation as to why XYZ people might have done this murder. But what you can do is if you ask Mr. Zachary, is a way for people to move up in a gang to commit crimes, and he says no, then you can ask him about that particular concept. And him having said before, well, you know, not with regard to a specific crime, but you're being asked about a crime and you're saying, well, maybe it was to, okay, understand, everybody understand?
Understood,
Okay.
Your Honor.
All right. Let me write myself a note on that. And the rest of it, if the rest of it is just kind of the same basis of knowledge, co-conspirator thing, or is there more to it than that?
More to it than that.
Okay.
So for the rest of 68 to 69, line 11, it's discussion. I don't know if you've heard us talk about this yet in this case, Your Honor, but part of the story in this case is that there was a meeting where Mr. Thomas, or there was a gentleman that, according to the story, that I believe Mr. Copeland has given, there was a gentleman in prison who was affiliated with If Gang.
Okay.
And through consultation with that gentleman and other people at this meeting, which Mr. Zachary was not at, Mr. Thomas and others ratified a quote unquote green light to kill YSL members. Or no, I'm sorry, let me not misspeak, to kill Kenneth Copeland.
Okay.
And so Mr. Zachary is talking about hearsay that he's heard about this this green light that was put on. I don't think he specifies in this, but in other statements, it's said to be Kenneth Copeland, I believe, but he doesn't specify. He just says he put a green light on line 10 on page 68. It says, cause they said a powwow, and like green light, all YSL and 30 deep. They say nut said whoop or something like that, meaning it's a go. So he's saying they said that Nut did this and Nut did that to say it's a go to kill YSL members or 30 deep. That's Mr. Zachary's statement, but Mr. Zachary wasn't there, and he's saying they say that this is what Nut did.
Okay.
So, Your Honor, the state feels this has a huge effect on listener and also is classic co-conspirator statement in this context. And I'm trying to remember exactly where this is. I believe it's Mr. Garlington who tells, basically it's either Mr. Garlington or Mr. Copeland who gets information from this meeting. And that's why when Zachary says, like from my notes of what he says, so Detective Gaither says, so you're saying if gang had a powwow, and Zachary's like at the house, at their spot on MLK. So he's talking about like a specific location that came from, I believe it was Mr. Garlington, but that's just off memory, Your Honor. And then Detective Gaither says, okay, and they say that YSL and 30 deep. Yes, my apologies. As the court has said, when we read, we get fast. So in 30 deep got a green light, which basically means you kill them if you see them like they're food. And then Zachary says, yes. And so that is important for a number of reasons in terms of whether if gang members actually said, yes, YSL is on the plate, so to speak, you can shoot them, kill them, attack them whenever you see them. The fact that Zachary is stating that YSL members, to include himself, believe that was true, that is critically important for the effect it has on them.
All right. And you're saying that one of the other alleged gang members who's indicted in, or maybe has fled or not, but is indicted, actually has a basis of knowledge for what went on in this powwow. And is that what you said?
Yes, Your Honor. And my memory is either Mr. Garlington was actually, he either was there or someone at the meeting who was friendly, because Mr. Garlington was 30 deep at some point in time. And there's some friend, like people, it bleeds over. It's not like
right.
You have friends in other gangs, so to speak, or associates. And so someone calls and notifies either Mr. Copeland or maybe it's Mr. Garland who calls them. That's what my memory is of how this got to their.
Y'all have evidence of that you're intending to introduce, or you have a good faith basis for saying he had a reason for knowing this?
Yes, Your Honor, and I will find where that is, what interview statement, but yes.
Okay, well, I mean, assuming, go ahead.
It's my understanding, it's Mr. Copeland that introduces this concept.
Okay.
I don't believe Mr. Copeland was at this meeting either. It's entirely unclear to me, and I may just be misremembering, but I don't believe it's ever established exactly how Mr. Copeland knows. But Mr. Copeland is the other person that spoke about this, not Mr. Garlington.
But Mr. Copeland relays to.
Well, I don't know. We don't know that.
Well, he knows it somehow.
Well, I agree that he is passing along information.
He could be correct or not about it, about what happened in the powwow, but at this point.
There's no evidence that I'm not trying to be hyper technical, but when we're talking about statements made by a co-conspirator and furtherance of a conspiracy, there's no evidence that Mr. Copeland told Mr. Zachary this.
Okay, but as I understand the state's position, they're not offering this for the truth of what happened in the powwow. They're offering it to show that the alleged YSL gang believed that it was, open season on them, and that had been authorized by the if gang. So that is permissible for that purpose. It's not hearsay at all. Okay.
Your Honor.
Yes.
And this is something that's probably going to come up later. There may be times if they're not offering these things for the truth of the matter asserted, that we have to give the jury 105 instructions regarding exactly what the purpose of the evidence is.
All right. And I would expect you all on the defense side of the room to make sure that you timely alert me to that fact before
They will.
any testimony like this or cross impeachment like this comes out, because that instruction is supposed to be given prior to the jury hearing that evidence that's only offered for a limited purpose. So y'all are on notice that you need
They'll
to
be
let me know
timely.
that.
They try to be timely.
If you
It's
forget,
just
then I can
we don't
always
need one.
notify them later, but you still have to raise that to me as well.
Yes, Your Honor.
Maybe the judge will coach them
Thank
on
you.
when to raise it before it happens.
Okay, we can probably knock out a couple more of these before we wrap for the day. So item 12, which is bottom of 70 through most of 71.
And then EKPM, do you mean Christian Atkins, the ADA at the table?
So
He doesn't talk much, but
This
today's
would
been his
fall
day.
under, your rulings about Mr. Garlington.
Okay. All right. Then that would be in if that's the only objection. All right. All right, now we're moving to page 81.
And also, shout out to No Weapon Formed Against Me. Good to see you. We did look at Steele's motion during the lunch break. It was granted in part because the state agreed to part of it.
So, Your Honor, my notes or what's said here says, Zachary says Nard says that Woody's going to fold, talking about Mr. Copeland.
Okay.
I'm like, what do you mean? I may have started this a little bit before, but I wanted to read, it's just two sentences. And he says, I'm like, what do you mean? He's going to tell on us. I'm like, about what? About the nut situation. He won't fold. And then he says, that's why Thug stopped messing with him because thought he was going to fold.
I agree with the content.
Okay.
And my objection is to the speculation and explanation of what's going on in Mr. Williams' head. That's why Thug stopped messing with him. They thought he was going to fold. That is the part that I object to, which doesn't come across clearly on the transcript.
Okay. So this is who talking to whom?
So this is,
I was like, what you mean? Blah, blah, blah. Who's
What you
having this
mean?
conversation?
so Mr. Zachary first is mentioning a conversation he had with Demise McMullen, who told him that he believed Mr. Copeland was going to fold.
Okay.
And then Zachary also states, I think Zachary actually then, after he says Nard thought Mr. Copeland was going to fold, he thought he was going to tell on us. I think Zachary just starts saying that's why Thug stopped messing with him, because he thought he was going to fold.
I think he says Mr. Zachary says, I don't think he's going to fold.
Right.
He was responding to Mr. McMullen.
I didn't think he was going to fold. And then I thought,
Then he says, that's why Thug stopped messing with him.
okay,
Thought he was going to fold. And that's the part I'm objecting.
okay.
And the state's position is that Zachary's has enough foundation to know what his fellow co-conspirators' viewpoints are, especially on someone snitching against them, which is of peril to individual defendants and also the gang writ large, for obvious reasons. And so the fact that this conversation is all about someone telling on other members of the gang and individuals, Zachary would have knowledge of how they would view that and why they distance themselves from Mr. Copeland. And so the state feels that he has relevant personal knowledge from interacting with defendant Williams and seeing the interactions with Mr. Copeland starting to go down.
Okay.
as in not as frequent as they used to be.
All right, so and your basis for this not being speculation is that you think that, let me just say this, before you could get this in, you need to establish the foundation for him knowing. I mean, he can know by observing that Ms. Williams and Mr. Copeland kind of stopped seeing each other so much. But if you want to impeach him on why, then you need to establish that he actually had a basis for knowing the why. Okay.
Understood. Your Honor.
Okay.
KMT said it best. Yeah, watching them lay foundation is going to be interesting because Love has struggled with that. I think Hilton struggled with that too. And they just cut the court audio?
The next one is the one that the state, at least a portion, agrees with Mr. Shardt.
Okay.
So that line that says, yes, Shannon's hot-headed, the state agrees that
Yeah,
that should come
okay.
out.
How about him? All they want names for themselves. That's all they want, names for themselves.
And this is similar to the court's earlier ruling where I had asked about moving up in rank. So
Okay, so you could use this as well to say, didn't you tell us already? They want names for themselves.
yes, Your Honor.
But only for that, and the hot-headed part doesn't come in regardless.
Yes, Your Honor.
All right,
And then
hang on, give me just a second to jot myself a note. 122. So I don't know what the line 25 and then the response on the next page is about.
The-
That seemed to be included in your objection.
right, so the investigator says, so Shannon, don't give a F word. And then Mr. Zachary says, oh, hell nah. So that, I object to that as well.
And thank you, DC, for becoming a member. Love your picture.
Okay. So that's just,
I will concede that, Your Honor. I skipped past that,
Okay.
yes. We will not be asking something about those two.
okay.
Same with Jason Bowers. Thanks for becoming a member.
Your Honor, the next one, it says, Mr. Shardt says irrelevant discussion of Bentley selling
Right.
drugs. Bentley being OG Bentley, who's Kelvin Treadwell.
Right.
And so I wanted to read, because I think it's a little bit cleaner, what's said in this portion. So I have Detective Gaither says the guns possibly on Bentley's spot.
Hang on, let me figure out where
Yes,
you
Your Honor.
are. So this is
82.
83, right? Are we back on 82?
I might have had a typo. I had page 82, line 25.
It's 80.
83, line 25.
And DC with 20 gifted
25
memberships. It's so nice.
Is
Oh my God, everyone put
So,
DC in the chat.
that was what you were reading though, Mr. Atkins. The guns possibly at Bentley's spot on Oak Drive. That's the beginning. That's before I object.
Okay. Thank you, Mr. Shardt.
All right.
And as
then
members, you
Mr.
get Mario
Zachary
Kart
says yes.
emojis, so
they're
choose
talking
a
about
racer.
Bentley's spot on Oak
Okay.
Drive with
Mhm.
the guns, but
Yep.
then they move into selling drugs.
All right. Yep.
And Your Honor, the state's position of why this is relevant is that on page 12 of the preamble to the indictment, the state sets forth that part of the purpose of the RICO enterprise is the sale and distribution of drugs.
Okay.
Furthermore, there is in both Mr. Copeland and in Mr. Zachary's statements, they speak and reference that after the murder of Donovan Thomas, OG Bentley basically had like a spot, either a trap house, a drug spot, something
Right.
where he on Oak Drive. And so when he says, so Gaither asked, the gun's possibly on Bentley spot on Oak Drive, that's what she's referring to. And then she's like, what kind of drugs does he sell? And Zachary kind of goes into detail, dope, crack hard. And she's like, nickel and dime are rolling in it. And Zachary's like, both. And so for one, it's relevant for Zachary to have knowledge of one of, even though Treadwell was not indicted, the state's position in Detective Gaither and Detective Dennis' testimony through an earlier act where his vehicle was used, which was Act 36. It's very relevant, Zachary's knowledge of Kevin Treadwell dealing drugs. And the state has to prove the existence of both the criminal street gang and the RICO enterprise, which are sort of part and parcel of the same. And so the state just feels that this is very relevant, given there's also a number of drug charges on this indictment.
Right.
So it goes to count one, the RICO is the state's position.
And Your Honor, nothing I'm trying to keep out finishes Mr. Zachary's alleged knowledge of Mr. Treadwell's house or whatever it is on Oak Drive. I mean, he's clearly saying it's Bentley's spot in Oak Drive before we get to the part that I want to take out.
So do you just not want it said that he sells crack?
All the drugs. And this is why, Your Honor, Mr. Treadwell is not indicted on this case.
Right.
Nothing involving Mr. Treadwell selling drugs is listed as an overt act at all in count one. So we're just throwing in an associate. And there's no indication from this that Mr. Treadwell somehow kicks back money to Mr. Stillwell or Mr. Williams or anyone else. It's just Mr. Treadwell, who is associated with us through evidence that we know him. I think that evidence has come out that he's Mr. Williams' road manager at one point in his early in his career. But I don't know why we would get into his unrelated criminality.
All right. So if he's not an unindicted co-conspirator, if he's just an associate and there's no evidence that YSL is in any way benefiting from this guy Bentley selling drugs, seems like Mr. Shart's got a good argument here.
So, Your Honor, on the first point, and this was the act I was referencing, but just to give a little more clarity, there's individuals at a gas station, they think someone's trying to rob them because they're coming up close. And he calls Walter Murphy, who is a defendant who's pled, and Demise McMullen to come over and shoot with a stick, and they shoot and take off half of Dexter Montgomery's head. Kevin Treadwell, he's the he.
Okay, he Bentley, Kevin Treadwell is the one who makes the call, and then these alleged YSL gang members come to protect him and his drugs.
Yes, Your Honor, and that's in regards to him being like, is he an associate, a member? The Detective Dennis in Gaither would classify Kevin Treadwell as a YSL gang member. Now, in regards to the drug proceeds, I do not have any evidence that some receipt or some conversation of I'm paying my weekly dues to the YSL gang from this drugs that I sell at my trap spot. I don't have that kind of evidence. But the state, so I wanted to answer the court's question.
And in that incident, there was no evidence that these gentlemen were called to protect Mr. Treadwell's drugs. The state, I think, characterized it as just a senseless act. We were categorizing it as Mr. Treadwell believed that Mr. Montgomery and his associates were attempting to rob them outside of the gas station. But at that incident, there's nothing about drugs.
All right, unless you got more than that, Mr. Atkins, I don't think that this particular part, which is 8325 through 8410, comes in.
One small request.
You may.
There's a part, and I need to get the line of it, where he says, Detective Gaither asked him, does he still drive that white Nitro? And Zachary says, nah, he let Nard F that up.
Okay.
I would like that part in because that white Nitro.
All right, that is not a part that is objected to, that's being excluded.
That's line 12 on page 84.
Thank you.
All right, sure.
Dang, Daryl Brooks is winning in the chat. Thank you so much again, DC. You just gave the chat
All
so
right.
much fun.
85, line 13 through 86, 11.
So context here, Your Honor. Mr. Treadwell is actually, at the time, I don't think they're still together, was actually in a long-term relationship and has a child with Donovan Thomas's sister.
Okay.
And so this is all a discussion about, there's a lot of speculation about what Donovan Thomas' sister knows and how she feels about this and how she feels about Mr. Treadwell, which I don't think is relevant.
I agree with you. She loves fantasy.
Your Honor,
It's going to be a win for
main
her.
Portion of this, so to speak, that the state wanted in is not as much about what his wife knows. It's more so this line where he says she doesn't know that he, talking about Kevin Treadwell, hid those guns and had something to do with it, talking about the murder of her brother. And so
Where is that?
I will find the line.
That's 86 line 1. In the part unintelligible, I have, she don't know he had something to do with it.
Okay.
And he's already laid out in the statements that I've objected to, but Your Honor has overruled my objection about what, this is all based, he had something to do with it is all based, from my understanding, is pretty clear. Mr. Zachary is saying that's based on what Mr. Garlington said to him, and that's been repeated several times throughout these statements already about Mr. Bentley getting, Mr. Treadwell allegedly getting rid of the guns. So I don't know why we would need to get into this conversation about what she knows and just for that information, because it's already been provided.
Your Honor, one other small piece is I don't remember when this question was asked or who was asked of, but Donovan Thomas Sr. testified. And there was some questions about, the state asked questions about relationship, family members to give context for the jury. And so there was some questions, I believe, on cross-examination of Mr. Thomas kind of highlighting that Kevin Treadwell's wife is related to Donovan Thomas, because obviously that would cut, this is my idea of why defense would highlight that would cut against their family. Why would he be involved with the murder of his wife's brother? And so, but the state feels that discussing that, because of some of that testimony, this isn't going to be a huge part of our direct questioning of Mr. Zachary, but that is another reason why it is more relevant than it may otherwise be that she didn't know. Zachary's saying she didn't know. Because obviously it would be very odd if she did.
Okay. So then most of 84 and 85 is admittedly not anything y'all would need?
Yes, Your Honor.
Okay. So then if it becomes, part of 85 and top of 86 becomes relevant, I mean, it's still like Zachary saying, I don't think she knew, right? I mean.
Yes, Your Honor. And I don't think we're going to be asking specific questions to try to, about this. It was the topic about, her just, well, it may never come up in our direct assessment.
How about if you think it's going to, you raise it with me and
Yes, Your
we'll
Honor.
hash it out then?
Yes, Your Honor.
All right. All right, 92, first couple of lines.
And big question, do you think Whitaker likes Shardt more today or Atkins more today? Because at first it was all Shardt, then it was like major Atkins win. And then she just really gave the defense a win because of Shardt's argument a few
Your
minutes
Honor,
ago.
I have, and Mr. Shardt, you tell me if you have something different. I have Detective Dennis says, what he thought get you down there? What was Thug like? Zachary says he's normal. Detective Dennis says he doesn't give an F. And then Zachary says, he's like, why the hell did they kill Nut? That's when I guess they told him. Nut said it's a go. And then he says, Woody, talking about Mr. Copeland, is holding back stuff. He's kind of alluding to Mr. Copeland has friends. He knows a lot of people. So sometimes they're saying Mr. Copeland doesn't state everything with them.
I'm going to withdraw my objection.
Okay. And man, y'all weren't kidding about the transcription being less than 100% accurate. Okay.
Imagine if the transcript's like the
It
YouTube
is
captions.
not this court reporter or my prior court reporter. I do not have any idea who this state used, but
I will not
maybe
disparage them on the record, Your Honor.
like entirely off the record. Maybe next time you'll have a bunch of stuff transcribed. You give them like a list of key terms and names of people, and that would help them out a lot. Okay, anyway, totally irrelevant, but okay, so
In light of my review of the transcripts, I'm going to withdraw my objection on number 18.
Also, okay.
Because I believe that, not saying it's the truth, but I believe Mr. Zachary was there.
Okay. All right, then we are at number 19, 102, 15 through 22.
And Your Honor, this is one of those ones that the state agrees. This is just a line with Detective Dennis speaking about basically the streets convicting Kenneth Copeland.
So y'all concede that one.
Yes, Your Honor.
Agree, redacted by agreement. Okay.
And thank you so much, Mahadi.
104, middle of 104 to middle of 105.
You might be right, FFS. Atkins told Love to sit down. I'll show you how to be a DA. Amuse for the 10, Amuse on X. That was so nice. I saw another comment where you said, for what it's worth, thanks for the coverage. So thank you so much.
Your Honor, this is another one that we will concede. Its relevance is very limited.
Okay.
So
Thank you.
I will agree on this.
Okay. All right, that takes us to page 108.
FFS says, how's there only 2.3 likes when there's 3.7 people?
Your Honor.
FFS, I won't say your name out loud.
This came up in the 2017 interview. This is in relation to who shot Mr. Bennett, wife, and Lucci's mother's house. I wanted to point out, because this did not come in, this part, in the 2017 interview to my knowledge, but in the part of this interview, which I have begins around on the evidence reviewer time hacks 30850, Detective Dennis says, let's get to this. Who shot up Lucci's mother's house?
Okay.
And there's a little bit of back and forth. And then Zachary says, I'm telling you all if you work with me. And he says, Woody, Shannon, and Little Pokey. And then they ask him like who these people are. And he's like, Little Pokey is Thug's nephew. And this is where the part I think is important for his knowledge of this. Gaither says the gun that you had that you got caught with, she's telling him about the ballistics from the gun that Zachary's arrested with, comes back to one of because there was two shootings of this house. And Zachary's like, well, that was Moontunk's gun, who is Antonio Sledge. And so he's talking about how did Woody get that gun that day? Because Zachary's like, the people who did it was Woody, Shannon, and Little Pokey. And so this is why I think it's important. Zachary says, we were at Big Boo's grandmother's house, and Mr. Copeland's like, hey, let's ride. They leave and they come back in a white Charger, which I believe is Mr. Copeland's brother's car. And then Big Boo, who was kind of a lot of people looked up to him. He had a lot of money in that neighborhood.
Okay.
And so people would call him to settle disagreements, basically. And so he gets a call from someone in Lucci's, like an associate or friend, who's like, hey, whoever just did that, I got $10,000 on their head because you just shot at his mother's house.
Okay.
And so what Zachary states is while he's at Big Boo's house, Woody and them come back while this phone call happens. And he says, Woody comes in and Woody's like, what happened? He act like somebody just shot up Lucci's mother's house. And then Big Boo's like, don't tell me you all did that, because they came back and didn't say anything. And he says Woody got scared because, and he says, Moncho, who's the person who calls, says, I have $10,000 of whoever did it. So to me, this is my rendition of this. Zachary kind of is like, I know that on some level they did it because they suspiciously leave, come back, and then he gets this call of who did it. And then Kenneth Copeland starts acting paranoid when they're saying, I have $10,000 on the head of someone who did that. Coupled with, and I don't have direct evidence of, on this date, Mr. Copeland told Zachary, I did it, or Mr. Stillwell, or anyone told Mr. Zachary that, but I couple him being present around them shortly after this happened, coupled with his just daily interactions with him, that he actually has more, his knowledge of Lucci's mother's house, he was not present, but is less speculative than it may first seem from interacting with co-conspirators.
Okay.
That's my argument on this. But given the court's earlier rulings, I wanted just to highlight it came out more speculative when we addressed this incident.
Okay. And,
The early
and
interview.
so here, Zachary is saying that he is at whoever, Big Boo's grandmother's house with Woody and whomever, and they leave, and then word comes in that Lucci's mama's house gets shot up, and then Woody and them come back while a phone call is being taken about whoever did this, there's a price on their head. And then Woody acts really suspicious, is what you're saying.
That is a much more concise rendition of what I just said, Your Honor. Yes.
Okay.
I have that large block starting at that certain time, and Zachary says that he's at a house with them, they leave, they come back, they realize it happened, and Mr. Copeland acts suspicious, which is decent clues of possible involvement. And I believe, I have no evidence of this, I just believe that coupled with they tend to talk amongst each other about what happened over time.
So on 110, unless it's transcribed wrong, I guess it's Detective Gaither says, so they actually came back and said they did it, or y'all just assumed it? And Zachary says, no, they said they did it.
That
He says he finally said it, and Mr. Zachary says Woody, which is unintelligible. He says Woody. Like I told you, Woody got scared when they said they got $10,000.
Okay, and then on the next page, it says, and then what's the unintelligible part there?
Like, man, just shut up.
Okay, well, that to me is him actually saying, we did that.
Shit. Saying it.
Okay, well,
Your Honor.
well, Mr. Copeland's not saying I did it, he's saying we did it.
What I'm saying is, I don't know I've never heard Mr. Copeland's in-court testimony about this and what that would be, but it's certainly not an admission by a party opponent that can be used against Mr. Stillwell, because there's nothing in here about Mr. Stillwell saying he did anything. And I don't know how, I mean, it's hearsay, and I don't know what exception this would fall under. I have a theory of what the state may argue, but
Okay.
it's not furthering anything. Except Mr. Copeland is apparently paranoid or whatever, and maybe he has some self-interest he's dealing with, but I'm not sure how it furthers anything. And so I don't want my client to be wrongfully linked to uncharged, well, I should say not substantively. And let me just say this too. No one's been charged with this act.
Okay.
It's listed as an overt act, but no one's been substantively charged with the actual crime.
All right, so who all is, I mean, I get that Zachary is at the house, at the grandmother's house, and Woody is at the grandmother's house and then leaves and then comes back. Who else is at the grandmother's house, leaves with Woody and comes back, if anyone?
So, Your Honor, I believe, so the closest I get is when they ask him who did it, he says Woody, Shannon, and Little Pokey. And he
Yeah.
says collectively, like earlier, he says, Woody's like, hey, let's ride, like collectively. And then
Okay.
he's like, they got back, or so my understanding is he doesn't definitively say this, but I believe either Shannon and Little Pokey were at the house and left. I'm just assuming from the way that he's speaking about it. And also, this is partly, it's the end of the day, but the court is correct that shortly thereafter, Mr. Copeland himself does state and says, you know,
Well, and I mean, if
I did it.
if Shannon, and I guess Lil Pokey is not anybody that we need to concern ourselves with right now.
He is defendant Williams' nephew and someone that.
Okay, but he's not somebody on trial right now.
He's not on trial.
Or indicted.
He's not indicted.
Okay. All right. So I think it is fair to assume if Woody says, let's ride, and right after after Zachary said, here's the three people that I believe did it, and here's my reason for believing it. But I think it potentially could be a statement if Mr. Stillwell shows back up with Mr. Copeland, and then Mr. Copeland's like, yeah, man, we did it. And Mr. Stillwell does not say, what are you talking about? I didn't do it. You might have done it, but don't count me in on that. Then that might be an admission because he's adopted it by silence, but not if he's not there when it gets said. So, you know, if you can establish that when Woody says, yeah, man, we did it, that Shannon's standing right there with him, knowing there's $10,000, you know, on his head, then yes, but otherwise, no.
Understood, Your Honor.
All right.
And thank you again so
Your Honor,
much
can I
to
ask one small
Sachel.
part on that? In regards to taking aside defendant Stillwell, in regards to what Copeland referred to, Zachary, that's appropriate, depending on how testimony of Mr. Copeland comes out, coupled with foundation for Mr. Zachary.
Yes.
Okay. Thank you, Your Honor.
And that might be one of those times when we might need a limiter if that comes out.
If I understand the state's question, they're saying, can we get into the fact that Kenneth Copeland admitted involvement
Right, yes.
without bringing Shannon?
Right,
into
that
it?
was the second question, yes.
If we can't get
Yeah.
to the adoptive admission.
Yes,
I don't have a problem with that.
all right.
And DC, thank you so
All right.
much. Another 20 gifts. That's incredible.
We just have a lot to get done, but these are Mr. Zachary's only two statements that we need to get through, right? Yes. And we're about halfway through, I think.
Yes.
Assuming Mr. Copeland, to try to figure out scheduling, assuming that Mr. Copeland does not testify now, then y'all need to move to your next witness, right? Yes, right, yes. So, and I know Zachary's one of the next ones up. He may not be the very next one up, but is there another, witness that we would be hitting next week? Because after next week, the jury already had a week off, so we can do this delightful stuff that week, the week of the 19th, with regard to future witnesses. But are there other witnesses that, assuming Mr. Copeland does not testify, that we would reach next week whose evidence we have to hash out.
Yes, Mr. Sledge is the other person that I,
Okay.
but his interview is smaller.
Okay, can I go ahead and get that interview? And you have listed also a jail call, right?
Yes.
And then social media. And when can you get the more detailed information? This was supposed to be here today about at least these witnesses to the defense, not social media, but what? If, I mean, and they may have it, but if they don't have it, we need the detail. Yeah.
So can we provide that to them for, like, in the morning, or like?
Do you have any of it ready right now? Because I know that your person working on it had been worried that he or she could not finish it all as to the first 30 witnesses, but surely he or she has accomplished the big chunk of it by now, right?
So those were the exhibits that she was working on. So we had the court had instructed us about the exhibits. And so that is what that person was working on. And I was hashing out the pool of the 30 witness exhibits that we were introducing.
All right, so how far along are you into that? Have you done like page
We miss
one of
Atkins.
it? I mean, I assume you're going by in the order that you.
So can I, will the court just, so may I send to the court or to defendants into the court by 9 o'clock tonight? So everything that I have compiled.
Can you just send right now or in the next 45 minutes what you have so far? Because I'm
supposed to be
sure that,
done.
well, what I suspect is that everybody would probably like to get some sleep, but that's not the reality of being in a trial. And so the sooner you can get them the stuff, the better. So let's not wait till 9. Let's, in the next hour, get what you've got right now over to them and me. And hopefully it'll be a big chunk of it. Okay, so, and then you need to send me, I assume the defense has a copy of Mr. Sledge's interview.
Yes.
Have y'all done this same exercise for Mr. Sledge to figure out what portions of it you need to object to? All right.
No, I will say Mr. Sledge's interview is shorter.
Okay.
And it's really confined to the incident that he's charged with.
Okay.
Which is the shooting up of houses he was charged with back in 2015 that him and Mr. Zachary pled to.
Okay.
It was taken after being arrested for that.
Okay. So I'm thinking that potentially the defense might have objections to social media, the defendant interview, or jail call or calls. But I don't know that. Do y'all know what you're going to get them, the specific social media? All right.
Yes, and Judge, just for a point of clarification, we were trying to include on it the exhibit numbers. That's what I was.
All right. Well, that's wonderful.
But, okay.
But
So
if the exhibit numbers aren't perfect, fine, we can fix those. Is that what your concern was? Okay. No, my concern is more that the defense get the evidence you're planning to use because they need to be able to contemplate it and figure out how they're going to deal with it. All right. So, which means that if we're doing the trial next week and it isn't a couple of days of Copeland and then a couple of days of Zachary and people who, there aren't going to be a lot of objections to, I mean, we need to have hashed out this with regard to all of next week's witnesses.
yes.
And how are we going to do that? Who all do you think there's going to be objection about other than Sledge and Zachary? And y'all, I'm looking at this giant list of witnesses from the state and looking at the first ones.
Right, like please call somebody
And
if you can't be prepared.
Surely y'all have looked at most of this. Do y'all think that there's another witness coming up soon that we're going to have a lot of this kind of detail to hash out for?
No, well,
I mean, you don't think so? Okay, great. Does the defense think so?
Anybody? Bueller? Thanks so much again, DC, for the gifted memberships. You gave 40 people gifts. That's so awesome. And thank you, FFS, for super chatting to thank DC. I appreciate the whole chat has been so awesome today. I appreciate all the support and the gifted memberships. Still trying to get a clear answer on what they're
Your
looking
Honor,
at for
I don't-
scheduling.
So far, the state has seemed to be trying to introduce prior statements through the witnesses that are on the stand. Detective Thorpe and Michael Sprinkle, ADA Sprinkle,
Mm-hmm.
both conducted multiple interviews. I don't know to the extent that they're going to seek to introduce any prior statements through them, but that's the only thing that I can see. Mr. Sledge has a prior interview,
Right.
but my recollection is it's very confined to one incident, and he doesn't say. I'm going to review it, of course, but he doesn't say anything about anyone other than himself and Mr. Zachary, mostly.
Okay.
My recollection.
Okay. Thank you. Anybody else? See something that's going to be a whole lot of what should have been motions in limine?
She's like, please no bombshells. Please no bombshells. FFS says Atkins is going to need a new rotator cuff
Your
doing
Honor.
all his
Yes.
traffic signaling.
Trying our best to give you an estimate of what we think might be at issue. I'm looking, for example, at number 8, Michael Sprinkle.
Yeah.
So yes, we're aware that he conducted multiple interviews, but what we don't know at this point is what interviews it is that they intend to use. So we don't really know how to
All right.
address that. We also don't know what social media
All right.
items.
I think we're going to have a whole lot more of that in an hour. Tell me this, Miss Love, assuming Mr. Copeland does not testify, what witness do you think we are going to be at by next Friday? Keeping in mind that y'all will be here at 8:45, the jury will be ready to go at 9, and we will work till at least 5:30 most days,
I'm going to.
with a break for lunch and a couple of bathroom breaks, and that's about it.
Yeah, so no more long morning recess for you to look for an affidavit, love.
So, thinking, no further than, and when I say Agent Berni, it's for these records that we have, not for the
Okay,
ones that.
right, we talked about earlier, yeah.
But we will get no further than Agent Berni.
Okay, all right, and so will what you send in an hour cover at least through Agent Berni with detail about what the evidence is going to be? Okay, all right, okay, well, then we'll take it from there tomorrow. Let's be here at 8:45 tomorrow. and y'all think about the things that I asked you to think about and have some kind of proposal for me.
So part of that's the
Is
instructions, you
completing
guys,
the-
limiting
Are we
instructions.
completely abandoning for now the Zachary statements, or are we picking that up tomorrow?
No, I want to get through Zachary tomorrow and then move on to Sledge and then whatever else. But no, we're just abandoning that for now. It's time to go home.
Understood.
All right. Do we need an electronic?
An interesting result on this poll. Over 700 of you voted, and there were three
Mr.
options.
Atkins, could you send over an electronic copy of this transcript of the interview we're going through right now?
Yes, Your Honor, I will.
Okay, thank you. All right, we're adjourned.
Only 17% think Woody will
Give the original.
testify. 38% think he'll give mixed signals, which is partial testimony. And 44% say not testify. So very few people think he's going to give the state what they want. And I'm certain that the people that said he'll testify probably, I should split the poll, probably don't mean that he'll testify willingly in the way that the state wants. So, you know the drill. We leave this up because the court has a habit of popping back on when someone has a last minute thing to add. Yeah, they gave her an hour. And tomorrow homework, it looks like we're going to be sorting out the language for the instructions when the jury comes back, as well as, being prepared for any limiting instructions relating to especially Bruce Harvey's client. And then we're going to be looking at more statements, which is not the most fun thing in the world, for Zachary and then Sledge. All Judge Whitaker wanted to do was get a schedule together in case Kenneth Copeland doesn't sit for testimony. We only have 1 week of time to fill, and then the jury's out again for the week, starting on the 19th. They're going to be out. That's pre-planned. So we just need to fill 5 days with productive court days and not waste the jury's time next week. And that last hour and a half was Judge Whitaker probably turning her hair gray, trying to get that sorted out. All right, so no extra court fees. And then I don't know if we have Thugger Daily updates. We'll toggle this. This is updates from Joseph Batt, but he's just, some scheduling. But we'll check before we end this stream to see if anything new pops in. Right after this, in a redirect to set up, we're going to do the Corey Harris update. We're going to watch the guy that showed up to traffic court driving while on a Zoom call to show up for a court appearance for a suspended license. We're going to see his update today. So that's going to be a separate stream that this will redirect to. But in the meantime, Miss AB had asked, speaking of motions, did Whitaker discuss the newest one that we read yesterday after court ended? It was from Steele. And that was an additional motion to disqualify Love and Hilton. I don't think we got into much discussion on that, but we did get into discussion of his lunchtime motion, which was granted in part because the state agreed, they didn't care, they didn't fight it. And then the other part was relating to reports from Agent Berni, possible rebuttal information, and Judge Whitaker says she won't rule it out for the purpose of rebuttal. So kind of a win for the defense with that motion. But we still have some outstanding stuff, guys. And that's really the big question. Satchel had said that it's not enough to declare a mistrial. The judge has to lay out all the jots and tittles as to why she decided to cut it off. That has to be able to withstand the appeal, because otherwise it could be appealed and it could be sent back down for retrial. So thank you so much, Satchel. And then Bariatric Maniac says, what does it say about the judge after this morning BS if she doesn't grant a mistrial? Up in the air, you guys. I don't know. I mean, Woody could do something where he comes up to the stand, says something crazy, and then here we are with the defense motioning for a mistrial. Or maybe the state motioning for a mistrial. Who knows? So as soon as we get over whatever mistrial motions are still standing, do you guys think that there won't be any other shenanigans happening in this case where someone raises their hand and asks for a mistrial? But thank you so much, Bariatric. FFS, thank you so much for the super chats all day today. You're saying thank you so much for giving us 9 hours so far. We're about to keep going with the Corey Harris trial, or pre-trial conference. It was short. It'll be a fun, lighthearted, entertaining, just totally different from watching people go through statements from witnesses and debating whether or not they should be admissible. It'll be way different, but it'll be nice and short. I hope you guys can join us. Ray says, on top of all that, it's Drea's birthday. Yeah, guys, don't forget, Drea is a great mod. We're celebrating her birthday all week. You guys have shown so much love with emojis, and it's been really nice to see. So thank you so much, Ray. And then Marlena Mack, I had bookmarked this earlier and had it on the screen, but didn't get to it. Prior to returning. So certain verbiage, right, we're hearing from the judge. Marlena says, the judge is pissing me off. So this whole idea that we're coming back next week. And I think the bigger issue next week might be mistrial on the table or not. I think she's going to be pissed when the state is not prepared. I don't know how much patience she'll have moving forward. So thank you so much. Marlena Mack also says the judge lied. She said she'd rule on motions over the weekend. This is true. She did say that, but don't forget there was a new motion for the fair and constitutional trial with a mistrial as a suggested remedy filed on Friday. And then we also had an additional motion to disqualify lawyers Love and Hilton filed by Brian Steele this week. So with that, it extends the timeline and the state gets a chance to respond, which she's granted them till Friday to respond to those. I don't know how great their responses will be when they have a bunch of homework on their plate, but who knows? But you are right that she said she wanted to rule on this over the weekend. She said she started drafting arguments for some of the points, but was still waiting on what she wanted to write about that critical stage and some of the Brady stuff. So she gave a clue as to 2 issues that she's really, really not certain on at this point in time. So thank you so much for the 5. And then Looney Boy, 221133, says, Woody is going to testify. He's an opportunist. He knows the state got caught trying to finesse. He's going to sabotage their case with Melnick. Yes, that's the thing, right? You could get up there and testify, and that sounds like the cooperative word, but you could testify in a way that's completely adverse to the state's case. So honestly, no matter what happens with Woody, if he takes a stand for 1 minute and ends up saying, nope, not testifying, if he takes a stand and decides to testify, and we sit through another week of whatever they have to get through with him, I don't think it'll be uneventful either way, no matter what he decides, how he feels when he wakes up in the morning. So thank you so much for the 5. And then you guys, we are all caught up. We have the Corey Harris live stream is going to start in about 15 minutes. This will redirect over there, but I'll drop a link. Again, that's going to be lighthearted. It'll be a good time. A nice happy hour, if you will, after this boring stuff with the statements, because it is not fun to listen to the statements, especially when we can't hear in full what the whole statements are each and every time. And yeah, you guys, Bifrons is saying, Woody gets the snitch pass. I clicked the wrong one. Yolanda, this is really nice too. Yolanda wishes Drea happy birthday, beautiful queen. Thanks so much for keeping everything afloat. And then no problem at all. And we got another one. Thanks, Gwennon. Dear jury, just ignore everything, WTF. Can you imagine that's the proposed jury instruction? And then, last but not least, okay, yes. So I had seen this floating in the chat. I'm her, thanks so much. Infamous Sylvia, there's some commentary floating that there was a juror in the courtroom, and Infamous Sylvia had seen them, and according to I'm her, I think the defense has been notified. I would also guess and assume that the defense has been notified if they didn't notice themselves. So that's also interesting. And you know the deal, guys. We will keep our eyes peeled for new motions. Penny G with, what is it, in the top of the 7th? Is that like the suspenseful moment in baseball? Penny G with the 5. Probably judge wanted to write against defense and mistrial, but then she could not after all the new baloney that started with really Monday. Hearing about this meeting details, the off-the-record details, then having Woody come in yesterday and saying the state told me I can't say I killed Donovan Thomas, and then yesterday at the end of the day finding out that there may have been more disclosure or late discovery issues. So, which I do think the state saved themselves, because at least it wasn't a Brady issue, because they at least had a record of turning over information about the name and the phone number. But as far as the reports, that still seems like some hot water. That might not be the end of the story there. But who knows? I'm sure this state will do it all again anyway. And then Candace Yates, thanks for becoming a member. We're going to close this up because in 10 minutes we're going to talk about the Corey Harris, his pretrial conference where he finally gets his license after driving to court with a suspended license. Big shout out, last love and appreciation for TLA and AV. You guys know I'm in those chats, like, especially before I started to stream, probably spent way more time in there doing anything else. And I would love the opportunity to just drop their channel to anyone that doesn't already know them, which seems like a stretch, but just in case, you know. So the first one is AV7's channel. And AV does a lot of great, short, concise, on-demand recaps that you can watch anytime, even if you miss the live. And what I love about looking for them is their channels come up so easy. It's so nice to find them. And then the second link is going to be TLA. Oh wait, what am I correcting? Hold on, what am I correcting? So this is TLA's chat. What am I correcting? Marley Mac, I'm going. I'm looking backwards. Thank you for the super sticker, watermelon juice. So maybe juror in the courtroom. Is it this? It was in the courthouse, not the courtroom. Okay. Courthouse, not courtroom. I think that's the, yes, let's correct that because that is a big difference then. So they're not listening to these stuff going on. Yeah, that's a huge difference. So courthouse, not courtroom. So potentially maybe they're there for something else. But still, can you imagine? I mean, people should be cautious about talking about certain things, but how do you could be in a courtroom and easily overhear courthouse and easily overhear mention of something that you might want to confine to a courtroom. So I don't know. That's still interesting even though it's a courthouse. But yeah, sorry guys, big distinction there. Thank you, Marley Mac, for making me hit the brakes on that. I appreciate that. So we will be going over to the Corey Harris stream. We'll start that up in a few minutes here. Thanks you guys for tuning in. Bye. Have a good night.